Hey everybody, this is going to be day 7 of the Edrick Faust trial, or Faust. I watched opening statements and everybody's saying the name a different way. I'm going to go with Mr. Cruz, who says, like the word moss, he says Faust. I'm going to try to stick with that because I assume he should know how to pronounce the name properly. With that being said, I noticed no feeds once again have closed captions, so my stream is going to be on like a minute delay with some latency, so sorry if I'm awkward with interacting with your chats, but you guys should see the option to turn on the closed captions if you look below my video screen. I can't put them on screen through the feeds that we're watching, so you guys would have to do it manually, but I think they should be there. With that being said, good morning to everybody. Hit that like on your way in. Adventure Aaron was here early. Everybody's looking for their orange VHS tapes after yesterday's riveting redirect of Chris Melton. Kiana says today is already wild. Can't wait to watch it with you. Same, right back at you, Kiana. The other Aaron is here, so we've got the Aaron gang going. We've got Anisha in the building. We've got Amanda here. We've got the whole crew going. So let's see what happens today, you guys. There's a little bit this morning, it looks like, before the jury comes in. So we're queued up right to there. And let's see. Hey, Miss Janet Demeanor, thanks so much for hanging out yesterday. That was an awesome time. Awesome host. Show Janet some love in the chat, you guys. And let's see. Yes, I'm commenting from the future. So let's see what we've got. We will skip some breaks. We've got a nice
before
ceiling.
we get started. So we are going to provide badges for all the media who has been granted Rule 22 permission. And so when those come in, we'll take a little break, or it might be during one of our breaks. And I'm going to ask all media who have been granted Rule 22 permission to wear that badge whenever you are in the courtroom. It's very helpful for the bailiffs to know who you are. Have your cell phones out and in use at all.
Can you guys hear?
And so if you have a cell phone, if you would kindly turn it off. And so if you have a cell phone, if you would kindly turn it off and put it away. The only persons that are allowed to have their cell phones, as we have talked many times, of course, are the attorneys who are at the table, the media who have been granted access for the purpose of business only, and any attorney who's in the courtroom who has business in the courtroom.
How come they didn't give media badges until after Sylvia put in her Rule 22? Is that weird to anybody else? I think it's a little coincidental, the timing.
Needs to, of course, look at their cell phone to see when they need to be in court. And so with those exceptions, everyone else needs to make sure their cell phones are away. Law enforcement, of course, can have their cell phones. All right, Mr. Yalamanchili, Mr. Bolden, anything from the state before we get started? The jury is here.
Judge, just briefly, when we ended yesterday, I did not think that we would necessarily reach playing Mr. Faust's statement today. But it does look like we may get to that point this afternoon. I've spoken with Mr. Cruz this morning. The way that the two parties have done timestamps differently, the state's timestamps correspond to the time that is displayed at the bottom of the video interview, and the timestamps in Mr. Cruz's transcript just start at a 0 and move forward in time since then. So if the court were willing, after the state's first 2 witnesses of this morning, I believe, if we could take maybe a little bit longer lunch break to allow Mr. Cruz and myself to go through and make sure that we have timestamps that connect or correspond correctly. I think that's important and certainly needs to be done, and for the court to hear if there's any kind of disagreement between the parties and what may be admissible before the jury or may not be admissible before the jury. You know, as we've said before, there are many things we agree on. You know, Mr. Faust makes reference to several prior criminal convictions for attempted robbery, burglary, possession of a firearm by a convicted felon, and things along those lines over an extended period of time. And so those things, I don't think there's any argument from the state that those things are not going to be admissible before the jury, but I think that there may be some other things. I just want to make sure that we flesh that out before anything gets played before the jury.
All right, thank you. Mr. Cruz, anything you want to say in response?
No, ma'am.
All right. We will go ahead and do that. I think taking a longer lunch break, if necessary, is appropriate. I'll be downstairs. Y'all need to let me know if we need to take something up on the record before the jury gets back. All right, anything else from the state?
Nothing else from the state, Judge.
Mr. Cruz, you ready for the jury?
I am, but I do have one matter. Your Honor, the WebEx link, is it possible that I could get?
All right, so I just wanted to look this up. That way you guys would know. All the way back in October, the defense filed a motion for a Jackson-Deno hearing. Jackson-Deno would deal with a statement by a defendant to law enforcement where they could make incriminating statements. You know, you want to have a hearing to make sure all of the constitutional rights of the defendant are intact for these statements to be admissible. I wonder if this hearing ever happened. It sounds to me like this hearing didn't happen, even though the defense asked for one. So now we're going to be going through this statement in the middle of the day because the state is going through their witnesses too quickly. We ended early yesterday. Yesterday they were aware that yesterday they requested to have a hearing after the witnesses go home for the day today to clear up the statement. And this morning they're saying, well, we think we're going to play it now. We think we're going to get there quick enough. Why didn't we just deal with this before trial? And it's one thing if we hadn't heard issues on days 1 through 6, where Mr. Cruz, you should have done something before we're in the middle of trial. It's not an even application, if you ask me. Anyway, back to the court.
Then so I can start sending it out to witnesses. One is, I forgot the gentleman's name, but I spoke about him the first day his father died, as well as Ms. Keishana Armstrong, the 2 individuals that need the link.
And this is for your case in chief, is that correct?
That's correct.
Okay, so the easiest way to make that happen, because it is a very time-sensitive matter and it's hard if we are not in sync with the time that has been set to redo it. So as soon as we know when you're going to present your case in chief, I think is the best time to get those set up.
Yes,
all right, but we will certainly do that.
Yes,
all right, anything else?
No, ma'am.
All right, thank you. You can bring the jury in.
Zoom.
Ladies and gentlemen, thank you again for returning here on time. We are ready to resume the trial. State of Georgia versus Edrick Faust, SU 24 CR 0547. Is the state ready to proceed?
State's ready, Judge.
Is the defense ready to proceed?
Yes, ma'am.
You may call your next witness, Mr. Yalamanchili.
State calls Bill Ricketts.
Could you get
Oh,
Bill
man.
Ricketts, please?
So Bill Ricketts was not responding. He's one of the detectives. We heard that he wasn't responding to the defense's subpoena. I think, did we hear a little bit about him yesterday too? I think we heard the truck customs guy spoke with Detective Ricketts. Or maybe not. Maybe it was Melton. But Ricketts came into play in those early days, like the weekend, the Friday, Saturday, and Sunday, interviewing different witnesses, including Melton. So this should be good. This should be good.
Sir, if you would, raise your right hand, take an oath. Do you swear or affirm the testimony you will give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. If you would, please speak towards the microphone and just state and spell your name for the record.
William, William, Ricketts, Ricketts.
Sir, where are you currently employed?
I'm a supervisor with the Department of Homeland Security.
Okay. And what capacity do you, or is there a particular agency that you work with within the Department of Homeland Security?
Yes, sir. I'm a supervisor with the law enforcement section of the Transportation and Security Administration.
Okay. Prior to working for TSA, were you involved in law enforcement in a different capacity?
Yes, sir. From 1992 to 1996, I worked at the Oconee County Sheriff's Office, and from 96 to 2001, I worked with the Athens-Clarke County Police Department.
Okay. And were you working with the Athens-Clarke County Police Department on January 19th of 2001?
Yes, sir, I was.
At that time, what was your assignment or role at ACCPD?
At that time, I was currently assigned with the Robbery Homicide Unit. I was in transitioning out into training at the time, but I was robbery homicide during that time.
Okay. And were you working on January 19th of 2001?
Yes, sir, I was.
All right. So I want to start kind of at the beginning of the day. Did your assignments at robbery homicide take you anywhere outside of Athens?
Yes, sir. That morning I was, I believe it was Milledgeville, Georgia. I was at the state penitentiary working a cold case homicide from, I believe, 1996. I spent the morning there and then drove back to Athens with one of the DA's investigators and came back to Athens that morning. I would say lunchtime or so, somewhere in that ballpark. Maybe.
Okay. And so just to clarify, though, this cold case homicide you were working from 1996, did that have anything to do with an individual named Ms. Tara Baker?
No.
Okay. And so when you got back, you said around lunchtime or so, was there anything unusual that you noticed when you got back to the police department?
Yes, sir. When we got back to the police department, pulled in the back where I normally park, and all of our vehicles and forensics and the CID units were gone, which I told the other investigator that wasn't a good sign for us for the day, and it was not. We went inside, and this is early in the days of cell phones, so we went inside, and I got a sign to go back out over to Fawn Drive.
Okay. And you said go back out over to Fawn Drive. Was that related to Miss Baker's murder?
Yes, sir, it was.
Okay. And what did you do when you arrived at Fawn Drive?
All right, before we get too deep in the weeds, just wanted to give these updates here that there's a posting of a supersedious bond, which means that Cruz will be appealing the contempt order, that contempt order here. The attorney filing this is Russell Gabriel on Cruz's behalf. So that's interesting. It'll be interesting to take a look at that appeal. Not sure when it will be available for viewing, but I'll check and see if it's already available. And, interesting. Also newly on the docket, court directs that all witnesses listed in this case all witness lists in this case shall be filed under seal. And that order came down yesterday. Seems a little late for that. But okay. Alrighty then. All right.
Arrived back on the scene and met with Lieutenant Durham. Crime scene folks were there. Talked to outside for just a few minutes with folks there. And then I began to talk to Lieutenant Durham, and he took me on a tour of the scene to get a look around so we could start taking some notes and look around. They had already been working for a pretty good bit of time before I got there. He showed me around the location, the crime scene. We looked at that. I took some notes. And then he kind of put me up to where he wanted me to go start doing some canvassing door to door and wanted me to do some other items that he had on his checkoff list that needed to be done.
So I want to start with your canvassing door to door. Did you speak to an individual by the name of Matt Owens?
Yes, sir.
Okay.
That's
and
one
then
of the
did you
sketch artist
also
witnesses.
speak with an individual by the name of Tiffany Riker?
Yes, sir.
Okay. And so as it relates to Mr. Owens, what did he tell you about anything that he may have seen that day?
Objection, hearsay.
Any response to the objection, Mr. Yalamanchili?
Your Honor, I do believe Mr. Owens testified in this trial, and then Mr. Cruz challenged the credibility of certain things that Mr. Owens had said. So I believe that this would be admissible as a prior consistent statement.
I did not challenge the credibility of Mr. Owens. Mr. Owens testified. I don't even think I asked, well, not even think, I didn't ask Mr. Owens any questions. I just thanked him.
Right. Mr. Yalamanchili, any response to Mr. Cruz's statement before I make a ruling?
Your Honor, if the defense is contending that he challenged nothing about the truthfulness and accuracy of Mr. Owens' statements, then I don't believe that the prior consistent statement would be admissible.
All right, I'm going to sustain the objection.
Thank you, Judge. Mr. Ricketts, so you.
Yep, I just checked my notes. Matt Owens, no cross. So good try, Yalamanchili. We're going to get an emoji for him. Thanks to DB. I don't know if DB is in the chat yet, but shout out to DB if he is.
Spoke with Mr. Owens. We're not going to get into the details of what he said. Did you speak to an individual by the name of Tiffany Riker?
I did.
Okay. What is it that Miss Riker relayed to you?
Objection, Your Honor. Hearsay.
Any response to the objection, Mr. Yalamanchili?
As it related to Mr. Owens, I don't have definitive memories of the ways in which Mr. Cruz may have asked questions or
Maybe you should have prepared.
attempted to impeach that witness, but certainly as it related to Ms. Riker, there were significant periods of cross-examination, including confronting Ms. Riker with previous statements and things along those lines. So I do think that this would be admissible as a prior consistent statement.
Thank you. Yes, sir.
So my second objection based on the state's response would be waste of the jury's time. In regards to our examination of Ms. Riker, the only thing we went through were the statements that she gave to this officer. There was no need to impeach Ms. Riker on her prior statements because the testimony she gave in court, we used her prior statements from the day she spoke with Detective Ricketts.
And she agreed that she said something inconsistent. She agreed.
To establish what her accurate testimony was.
Thank you, Mr. Cruz. I remember the statements, and I've taken notes on that. I'm going to overrule your objection and allow you to continue with that line of questioning.
So, Mr. Ricketts, as it relates to Ms. Riker, what did she relay to you?
She stated that morning around 8:15 in the morning, she left to go to class. She saw a male subject, black man, walking down the street from the area of Cooper Road towards her apartment. Now, she said the male subject had to stop in order for her to back out of the driveway and go on. Her description, was a medium, average-looking height, medium, no hat, medium hair. It had an orange or bright red shirt, baggy pants, possible jeans, but they weren't dark in color. She gave us that description while we're sitting there talking to her. She was surprised that morning, and it was kind of a foggy, rainy morning that morning. I do remember driving down that morning. I wasn't at the scene during that, but that morning was a heavy fog, kind of rain kind of morning, kind of nasty. And she said it was kind of odd to have somebody cutting through just the apartment area at that time of morning.
And was the unusualness also based on the weather that she described?
She described the weather and then how the subject was almost walked into her car. It was one of those where if she hadn't seen him, she thinks maybe if she had seen him, they might would have run into each other, if that makes sense.
Okay. Did you conduct other canvas interviews?
I did.
Okay. And I'm not going to get into the details of those, but just talking about what you did that day. Eventually, did you end up back at the Athens-Clarke County Police Department?
Yes, sir. Lieutenant Durham sent me on several other assignments to take care of, and I did end up back at the police department later that afternoon.
Okay. While you were at the police department, and this would still be January 19th of 2001, is that correct?
Yes, sir, it would.
All right. So while you were at the police department, did you have any contact with an individual by the name of Chris Melton?
I did.
Okay. And who did you understand Mr. Melton to be at the time that you spoke with him?
I had understood Mr. Melton to be the boyfriend of the deceased. From being out at the scene, I had not yet seen or met him at this point, but I understood that's who he was.
Okay. And you said by being out at the scene, to your knowledge, had Mr. Melton been brought to the scene at some point during the investigation?
Yes, sir.
Okay. Do you know the purpose for which he was brought to the scene?
He identified the body, which I was told via digital camera from the crime scene, and was out on the crime scene answering some questions there, I believe, to Lieutenant Durham.
We've got to fix Melton's testimony here.
Did you have an opportunity to speak with Mr. Melton?
Yes, I did.
Was there anybody else present when you were speaking with Mr. Melton?
Yes, sir. His father came with him. We weren't expecting him at the police department. He arrived, and he and his father were there together. So we decided to do an impromptu interview there at the office.
With the father?
Where in the police department in particular did this interview take place, if you recall?
We were kind of over in that forensics area. We were not actually in an interview room. We were over in the forensics office. If you think of it, it's like a small conference room. I won't say a common work area, but a small conference room there where we could have a little bit of privacy and a table where we could sit.
So when Chris Melton goes to the police station with Josh McCurdy, someone that could and should have been the alibi witness, Josh McCurdy's like there but then leaves. Nobody talks to him. But now we have father present who will hear what Chris Melton's saying about his whereabouts. And then we're going to use the parents to say, well, yeah, he was home on these occasions, either in the upstairs bedroom or in the basement. He's both. Like, also on a get me away from my frustration here, Donnie Not Wahlberg, one of my favorite usernames on here, gifted 5 memberships. Big thank you. Let's give Donnie some thank yous in the chat, especially if you turned green. Super generous. Thank you so much.
Talk. The area was pretty busy that whole afternoon. We had several things going on at that same time, but that's where we decided to sit.
Okay. So what, if anything, did Mr. Melton tell you about his relationship with Miss Baker?
So we sat and began to talk.
Your Honor. Hearsay.
All right, Mr. Yalamanchili, any response to the objection?
Yes, Your Honor.
Did Yalamanchili forget that, well, they're going to say this is how it made the investigation proceed. But if this was Chris Melton's trial, it'd be a party opponent, so you'd be able to talk about it. So in my head, I'm imagining Yalamanchili forgetting who's actually on trial here.
I believe that Mr. Cruz attempted to impeach Mr. Melton regarding the, I guess, status or general place that his relationship with Miss Baker was in at the time. And so I think that these would be prior consistent statements on that issue.
May I respond, Your Honor?
Of course.
During our cross-examination of Mr. Melton yesterday, the exact statement he gave Detective Ricketts about his status, Mr. Melton testified to. My concern, Your Honor, as we just saw with Ms. Tiffany Riker, is the state is attempting to use this officer to change the testimonies of other witnesses. That's why we're raising our hearsay objections. Ms. Riker has testified, Mr. Melton has testified. If it truly is a prior consistent statement that was not elicited or left hanging, which it would lead to a misinterpretation, yes, he could bring it up. But just to ask this officer to follow up and give the same testimony that other officers, that the actual witnesses have come in and give themselves, I ask that the Honorable Court, sustain our hearsay objection in that regard.
Thank you. Anything further before I make a ruling?
Just briefly, Your Honor, the prior consistent statement rule for admission has to do with exactly the situation Mr. Cruz just described, as far as a witness having testified, the defense attempting to impeach that witness, and then later that witness's prior consistent statements from the time coming in to show that that impeachment isn't credible. So it's the very purpose of the rule.
Yes, sir. Yes, sir.
I disagree with that, Your Honor. Prior consistent statement is if I challenge the credibility of this witness on that statement, and then the state comes in and say, hey, he's elicited testimony that the witness has said one thing, but we have a consistent statement from the past showing that his testimony in court is consistent with the statement that he's made before. We don't have that issue here because Mr. Melton, the same testimony that Detective Ricketts can give to the Honorable Court, Mr. Melton gave. And I can say the statement I won't because I don't want to put any, I don't want to taint the witness. But I would just ask that if there are prior consistent statements that the state would like to use, that's fine. I won't object to those. But just to ask Detective Ricketts what other witnesses told him, we would ask the Honorable Court to sustain our hearsay objection on that ground.
All right, thank you. I think it's the first time in this trial you both are right. You're both correct about what a prior consistent statement is. I am going to sustain and overrule the objection. I'm going to do.
He's going to say it's going to be fine for him to, it's not for the truth of the matter asserted, that it's instead how the investigation proceeded. Watch her come up with some ground that the state didn't even argue. Let's see.
Both. And so this is what I'm going to limit the state to. With regard to the statements that you are seeking to elicit, they need to be connected to the issue of impeachment and any necessity for a prior consistent statement. It cannot be, for example, as Mr. Cruz has just outlined, an entire narrative of the interview with Mr. Melton. So I'm going to ask you to limit your questioning. I'm going to make a ruling that you have to limit your questioning of this witness to the specific areas that you're seeking and arguing need a
But what kind of limitation is this, though, when you need to rehabilitate the entire testimony of Chris Melton? Is this really a constraint? Because all they're going to say is anything that was cross-examined on, we should be able to have this detective rehabilitate and reinforce and bolster the testimony of a witness we no longer have on the stand.
Prior consistent statement.
Yes, Your Honor.
All right.
And so I will not ask the witness, what did he tell you? I will try to be direct, which should give Mr. Cruz an opportunity, if he has additional objections, to bring them up at that time.
That's correct.
All right.
May I proceed?
So, Mr. Ricketts, I want to ask you very specifically, what is it that Mr. Melton told you about the condition or status of his relationship with Ms. Baker at that time?
That is hearsay with that exception. I would object.
All right. Mr. Yalamanchili, any response to the objection?
I was just restating the previous question I'd asked, and I think it is directed in the manner that the court informed or instructed me to ask it in order to be admissible as a prior consistent statement exception to the hearsay rule.
I'm going to overrule the objection. You may continue.
And so, Mr. Ricketts, I'll ask you the question again. What is it on January 19th of 2001 that Mr. Melton told you about the condition or status of his relationship with Ms. Baker?
He said they had a serious relationship and had talked and had intentions of marriage in the future.
Okay. And then, I want to take you forward a little bit. We've talked about the general nature and status of their relationship at the time. What, if anything, did he tell you about the plans that he and Ms. Baker had for that weekend?
Objection, Your Honor. Hearsay.
Mr. Yalamanchili, any response to the objection?
Your Honor, again, it is a prior consistent statement. Mr. Cruz, in his cross-examination of Mr. Melton, indicated that at the time leading up to Ms. Baker's murder, the two of them may not have even been in a relationship. He referred to Ms. Baker as his girlfriend or ex-girlfriend. So prior consistent statements regarding the fact that they were in a relationship and had plans together that weekend that both were excited about would be a prior consistent statement that would be admissible.
Ms. Kris, anything further, sir?
Sure. Mr. Yalamanchili's purpose for admitting this isn't because Mr. Melton or I elicited inconsistent testimony or inconsistent statement. It's the statement that matters, not the general view, not the general theory of the witness, the statement. We did not.
And this is, let me just let him argue because he's making a great point. I know it.
Not get into, on cross-examination, Mr. Melton's plans with Ms. Baker on the weekend after her death or the weekend following her death. We spoke about the relationship generally. So I would ask the Honorable Court to sustain the hearsay objection.
All right. Yes, sir.
And I would just add, Your Honor, the state had opportunity to examine Mr. Melton on direct and redirect examination. I do think it's inappropriate to now try to bolster or support Mr. Melton's testimony through Detective Ricketts, as the jury has had opportunity.
So now do we understand why the redirect was so short and really only focused on that weird orange VHS tape porn video side story?
To hear from Mr. Melton themselves.
All right. Thank you, Mr. Cruz. I'm making a finding that the very issue that the state is asking to have this witness speak about, which is the weekend after the incident, was in fact brought out on cross-examination. The articulation the state has made about what a prior consistent statement is with regard to that issue is accurate, and I'm going to allow you to do it. I'm going to overrule the objection.
So, Mr. Ricketts, I'll ask you again, and I'm trying to make this a specific tailored question.
I don't remember that.
What, if anything, did Mr. Melton tell you about plans that he may have had and Ms. Baker had for that weekend?
Yes, he went in depth about Tara had plans that evening with friends and family for a birthday party on the 19th for that night. And
Did we hear Chris Melton say yesterday that Tara Baker had plans with her friends and family that night?
For that weekend.
Yes, he went in depth about Tara had plans that evening with friends and family for a birthday party on the 19th for that night, and that he had planned something for her on Saturday night where they were going to meet and be together that evening on the Saturday the 20th.
Did he express anything to you about their feelings regarding those plans?
Yes, on the Friday, numerous times when we were talking, he said that Tara wanted him to drive down and be there for the 19th for the party at the winery with folks from the law school and from the law firm where she worked.
And so was whatever he's telling this guy, was his impression that she had plans with a bunch of people and he wasn't included in that plan? It seems like he was aware that Tara had plans with all of her friends and maybe he wasn't included.
He didn't think scheduling wise.
Objection. I am so sorry, Your Honor.
Okay.
We did not get into this.
This testimony is an accurate testimony from anywhere in this file. The disadvantage that Mr. Faust has right now when they are bringing in another witness to testify regarding what Mr. Melton may or may not have said, we have no way to cross-examine Mr. Melton on that information. I would ask that the state ask Detective Ricketts questions related to Detective Ricketts' personal knowledge, not information he's heard from someone else, unless it falls under his exception, of course. But to the last question, to the answer, Your Honor, our objection is hearsay.
All right. Thank you, Mr. Cruz. Mr. Yalamanchili, I know the witness is in the middle of a statement, but go ahead.
Your Honor, I think it's the same argument that the court just ruled on, a minute ago, that this is admissible as a prior consistent statement. And I believe it falls within that exception to the hearsay rule, as the court's already indicated.
Mr. Cruz, let me just ask you a question so I understand your objection. Are you arguing that this information was not elicited when Mr. Melton was on the stand?
I am arguing that the statement that was just made from Detective Ricketts doesn't exist in the case file. So I'm not saying this is intentional.
I'll let you respond in just a moment, Mr. Cruz.
I'm not saying this is intentional from the state. I don't think it's intentional. But what's going on here is Mr. Melton testified yesterday. I'm assuming the state didn't get the information that they would have liked Mr. Melton to say, so they brought in Detective Ricketts to now become a surrogate of Chris Melton, and they'll ask Detective Ricketts, well, what did Chris Melton say about this? What did Chris Melton say about that?
Okay, hang on just a moment. Ladies and gentlemen, I want to take this up outside your presence, all right? So if you'll go into the jury room and don't talk about the case, I'll be with you shortly. Thank you.
Now she kicks the jury out. Can't hear about the coaching and chats between the state and their witnesses.
I wanted to do that in the event, Mr. Cruz, you were talking about things that were not elicited during testimony. I didn't want the jury to hear it if that, in fact, was the case. You may continue your argument. Go ahead.
But my concern is, Your Honor, is the state is attempting to circumvent the rules of evidence by using Detective Ricketts to elicit testimony that, of course, during cross-examination, there's no way I can impeach Detective Ricketts on things that Chris Melton said while Detective Ricketts is on the stand.
I want to make sure I understand your objection, Mr. Cruz. Are you arguing that what Detective Ricketts is talking about right now or about to talk about was not brought up when Mr. Melton was on the stand?
Well, my objection is hearsay.
No, I understand that, but are you also saying that it was not brought up, that particular information was not brought up when he was on the stand, or something different?
Generally, yes, but this wouldn't fall under a prior consistent statement. I didn't get into plans for the weekend. Our entire theory of cross-examination with Mr. Melton was the deterioration of the relationship before her death. The statements, if they wanted these statements from Mr. Melton, they could have talked to Mr. Melton about them. These were, and we could have gotten into it on cross-examination with Mr. Melton. These were outside of the statement that was just made. But as far as Mr. Melton stating, hey, she wanted to see me, we had plans for Saturday, those are accurate statements. As far as, oh, she wanted me to come that night, and we had all this stuff laid out, that's not anywhere in this discovery packet. We looked through all 25,000 pages and 25,000 files. That is not in here. But it would be inappropriate to cross-examine, and let me put it this way. Mr. Faust has a right of confrontation. Mr. Faust has a right to cross-examine statements of witnesses. The state is attempting to use Mr. Ricketts as a surrogate for.
I understand exactly what you're saying, but I want to get I need to understand very specifically what you're arguing. I understand
rule
what you're
against your grounds.
saying about this witness testifying about what other people said and you're not having the right to confront the actual declarant. I understand that. What I need to know, Mr. Cruz, is what exactly are you alleging does not fall under the exception for prior consistent statements? So you've made two statements. I just want to make sure I understand what you're saying. You are saying, number one, that the information this witness is providing was not in the discovery. And certainly that's one thing. But in terms of this objection, are you also saying that Mr. Melton did not provide it on the witness stand, that this is something you've never heard or something different? That's what I don't understand what you're saying.
Please forgive me for not being.
I mean, that's okay. I just want to make sure I understand what you're saying.
I understand.
So our specific position is that this is hearsay that does not fall under the prior consistent statement rule. And the reason why we did not elicit a statement from Mr. Melton that was inconsistent with anything they had, I'm going to say allegedly, had planned on Friday or Saturday. My cross-examination didn't even delve into plans because our position, as the Honorable Court is aware, is that they weren't together. So we didn't get into that, we did not get into those statements with Chris Melton. If the state would have liked to get into that with Chris Melton, they could have did it during redirect or direct examination. But
I understand what you're telling me now.
Yes, ma'am.
All right. Thank you very much.
Are we sure?
Mr. Yalamanchili, do you care to respond?
Yes, I
Go ahead.
think Mr. Cruz in part just made the state's argument for us. He has just said that the entire contention during his cross-examination is that these parties may not have been in a relationship. Mr. Melton did, in fact, testify that he and Ms. Baker had plans for that weekend that he and Ms. Baker were excited about. And then on cross-examination, Mr. Cruz tried to develop a theory that the two of them were not in a relationship. And so that is obviously a challenge to Mr. Melton's testimony that they were in fact in a relationship and had plans that they were both excited about this weekend, as Mr. Cruz.
First of all, having plans to hang out doesn't prove that you were in a relationship.
Just indicated was the purpose of the cross-examination questions that he asked. So I do think that this evidence is admissible. I would also like to read to the court from Detective Ricketts' narrative talking about the things that Mr. Cruz has been alleging are not in the discovery. Kris told me that Tara was excited about Friday night. It was her birthday and she was going out with her girlfriends. Kris was going to take her out the next night, which is exactly what Mr. Ricketts was just in the process of testifying to, Your Honor. So, I mean, I understand why the defense doesn't want Mr. Melton's prior consistent statements to come in, because they cast doubt on the impeachment mechanisms that the defense has attempted in this trial. However, that is the...
Man, this whole cross-examination of this detective needs to be, and you just took his word for it. And you just took his word for it. Did you follow up on anything relating to him, Tara going to his house and leaving a note for him?
Entire reason that a prior consistent statement may be admissible in the trial of a case when the defense or the state, depending on who called the witness, has impeached or attempted to impeach that witness, Judge. So, I mean, I think it's a textbook example of when a prior consistent statement would be admissible.
All right, thank you. Yes, sir.
And I just say this, Your Honor, I'll leave it to the Honorable Court's discretion.
Cross-examine on it. Get this detective.
I'm going to relook at the law. I'll be with you both shortly.
Oh, we're looking at some law. Keep the record clean, I guess, or try to. There is a new channel emoji in the chat for Mr. Yao. So, shout out to DB who created that.
To subsection C of 246613, and it will be the second sentence that would...
I've got it, Mr. Cruz. Thank you.
Yes, ma'am.
Oh. Well then. All right, we are on the seal. We are on the Dom with seal. We'll speed through. But also, shout out, we've got some new green in the
Overrule the
chat.
objection because
They're going to overrule the objection. We've got Sylvia turning green. Thank you so much, Sylvia531. Thank you for hanging out with us for this trial. It's been awesome to have you in the chat for this one. And then EDW Raptor. Let's get some dinosaur emojis in the chat. EDW Raptor just gifted 5 subs. Super, super generous. Thank you so much, EDW Raptor.
this is the law. So we're clear. A prior consistent statement shall be admissible to rehabilitate a witness if the prior consistent statement logically rebuts an attack made on the witness's credibility. A general attack on a witness's credibility with evidence offered under Code Section 608 or 609, which is not the case here, shall not permit rehabilitation under this subsection, but we're clear that does not apply. If a prior consistent statement is offered to rebut an express or implied charge against the witness of recent fabrication or improper influence or motive, the prior consistent statement shall have been made before the alleged recent fabrication or improper influence or motive arose. I'm going to overrule the objection. You may continue, Mr. Yalamanchili. You may bring the...
All right, maybe I don't understand how that actually applies here, but okay. I'm not a lawyer, but I feel confused and feel like that doesn't read in a way that applies to what's happening here.
Jury in.
Thank you, Judge.
In the restroom? Okay. At ease. We have a restroom moment.
Oh, and now we're taking a restroom break. So we're just going to go back and forth to the seal all day. This is like the pictorial version of Thunderstruck. All right, they're gone for quite a bit, so we'll jump.
As to the witness whether or not he would like a glass of
Of
water.
course.
He got me one. Thank you very much, sir.
Okay.
The ruling that I just made needs to be consistent with the prior ruling that I made when I sustained Mr. Cruz's objection. This questions that the state feels support prior consistent statements cannot be a narrative, just in general. It has to be specifically tailored to the moment in question that the state feels is entitled to be rehabilitated. All right, thank you. You may...
Oh, she sounds like she's a little unsure.
Bring the jury in.
Oh, I can take down my jury presence picture.
You all may be seated. Thank you. Yalamanchili, you may proceed.
Thank you, Your Honor. Mr. Ricketts, before we took that brief break, I'd asked you a question, and I'm going to try to, as best I can recall, ask you the same question again. Did Mr. Melton talk to you at all or say anything to you about plans that he and Ms. Baker had for that weekend and their feelings surrounding those plans?
Yes. He advised that Tara was very excited about her birthday coming up the weekend, and that she and friends from law school and the law firm she worked at were all getting together at the winery on Friday night, and that Kris had made plans on Saturday the 20th to meet and take her out to celebrate her birthday.
All right. And as it relates to Mr. Melton's where...
Why didn't we ask, and maybe this guy will talk about PV or Valerie, Amanda and Valerie, but didn't Amanda and Valerie say they had no clue what she was doing for her birthday, but that they would just, Ashley had an equestrian competition and Valerie had something to do out of town, and they felt really bad, but were going to try to do something whenever they got back? Nobody mentioned getting together with Chris Melton and planning something, or, hey, we were going out of town, but we knew that she had plans with Chris Melton that night. because we're girls. And as girls, we gush to each other and say, oh my gosh, Kris wants to take me to that restaurant I've been wanting to go to. This all seems very unbelievable. And it's only Kris saying, I had plans to take her.
Whereabouts on Friday morning, January 19th of 2001. Is that something that y'all discussed in your interview?
Yes. One of the reasons Friday night that he wasn't going to be down is for work on Friday. The new area where he was working and things of that nature was taking time away. He had jobs to do on that Friday, so he said Saturday would be a much easier thing. And she had her college law school friends and her law firm friends and all to do the dinner with on Friday night.
Okay. Well, and so my question, I might not have been clear, and I apologize for that, is did he talk to you about where he was Friday morning?
Yes, he did.
Okay. And what did he tell you about that?
He spent the night and had spent most of the nights that week with his mom and dad, and it was at their residence. I have the address here if you need it, but he was at their residence that night until he went to work that next morning.
Okay, and I don't think we want to or need to say any specific addresses, but when you say until he went to work that morning, did he talk to you about when that was and where he went on that morning of January 19th of 2001?
Yes, sir. He laid that morning out for me. So his morning was to have his helper, his friend Kris, show up to help him that morning at the house there between 7:15 and 7:30, and then they left to start their day.
Okay. Did he talk to you about where they went when they left to start their day?
Yes, sir. His first, on this encounter on the 19th, they stopped at Nash Plumbing first off to load up with gear and equipment for that day, for the projects and the jobs that they were going out to do. He said they loaded up to there, and then they were headed over to try to make a stop over at Truck Customs. Kris explained in the interview that he was trying to get a ladder rack put on his truck. They needed to measure it, and then he would go back later in the day and they would install that ladder rack, was my understanding the conversation we were having. That location is in Loganville, Georgia, and he went there in order to get that measured out. They left there and went over toward Grayson, Georgia, in order to do a job there, a check for some leaks, that kind of thing at that house. From there, they went on to Forsyth, met up with a contractor there to look at doing a house there in Forsyth. Now, the house there, I guess it wouldn't have it had boarding on it, but no paper and shingles, I guess, if that makes sense. And I think they were just getting pretty wet. They were going to lay the house out to do the initial plumb of the residence that day. But there was no cover on the roof, so they were kind of getting wet. So Kris stated he went back by Truck Customs just to stop in and see if maybe they happened to be ready on his way back to his house. And when he went back to the house, he just dropped Kris off.
All right, any response to the objection?
Your Honor, I mean, I think it's all still responsive to the initial question of what Mr. Melton relayed to him about what he was doing and where he went that morning.
I am going to sustain the objection. I do think it is
Wow.
imperative. I'm going to ask the questioner to walk their witness through appropriately.
So instead of the narrative, it's going to be, and did he we better get some leading objections. And did he tell you went to Truck Customs? What, if anything, did he tell you after that? What, if anything, did he tell you after that? What, if anything, did he tell you after that? And just go line by line.
Yes, Your Honor. Thank you. Mr. Ricketts did, so we're at Truck Customs at this point. Did Mr. Melton tell you where, if anywhere, they went from Truck Customs?
Due to the weather and whatever else, he went back to the residence, dropped his helper off in order to let him go eat and see if they could maybe wait the rain out and see kind of how that would go. He advised that they would meet up together later and try to complete some more work or go back by Truck Customs.
And I'm sorry, let me just ask you some questions as we go along here. So you just testified that he had dropped his helper. What was that person's name?
Kris.
Well, Chris Melton.
Oh, I'm sorry. I have to look back. I apologize.
That's all right.
Give me 1 second. I'm so sorry.
Objection, Your Honor. I object on the grounds of hearsay to the witness having his notes while he testifies. If the state would like to refresh the witness's recollection, there's an appropriate mechanism to do that. But for the witness to be able to use his notes while he testifies, that constitutes hearsay.
All right, thank you. Anything from the state before I make a ruling?
I think that's correct. We can go through asking those couple of questions if the court would like.
All right, very good. I'm going to sustain the objection with regard to how to refresh a witness's recollection, but I'm going to overrule the objection with regard to having the report on the stand. A witness is entitled to have it on the stand. They just have to use it appropriately. You may continue.
And so, Mr. Ricketts, before you refer to your report, please, indicate to me that you may need to do that, and we'll go through the appropriate questions.
I understand.
My understanding from your last answer is at this time you can't necessarily recall the name of Mr. Melton's helper. Is that correct?
Yes, sir.
All right. Do you think referring to your report would help you refresh your recollection?
It would.
Okay. Please refer to the report. Do not read from it, and just let me know when you've had a chance to review it.
Yes, sir. His first name is Josh.
Okay. So I think, do you recall now, after having reviewed your report, that individual's name?
Yes, Josh McCurdy.
Yes, sir. Okay. So you had just testified that Mr. Melton dropped Mr. McCurdy off at Mr. McCurdy's residence. Is that right?
They were back at Chris's house. They needed both the vehicles, from my understanding, because Josh went there. But when they went back to Truck Customs, Josh, he was going to have to follow him back to Truck Customs. In order to leave Chris's truck there, they would need the second vehicle. So he went to lunch at that time.
Okay. Did they ever return to Truck Customs?
Yes, sir.
All right. And what did Mr. Melton, what did Mr. Melton tell you about where he went after he left Truck Customs?
He went to Truck Customs, he said around 3:45, 4 o'clock for an appointment that he had there. And he got a page that he received while he was there. He received that page, made a phone call, and then went to Athens to the address on Fawn Drive.
Okay. And this, when you said the address on Fawn Drive, were we talking about Miss Baker's residence where she was killed?
Yes, sir.
Okay. During this interview, this is January 19th of 2001, did you have an opportunity to observe Mr. Melton's hands?
I did.
Okay. What did you observe about Mr. Melton's hands?
During the interview, while we sat and talked, Mr. Melton, for lack of better words, just picked at his hands and messed with his hands, pretty much just moving glue and things off his fingers from his fingernail beds, and just kind of making that kind of movement while he was moving with his hands. You could see that. And then I had the opportunity to fingerprint him for prints. And at that time, we didn't use computers like we do now. We had to do manual prints, ink prints. So I printed him both hands on the printing, pretty much with a desk just like this. Start with outside and work
And tell us you saw no hand injuries.
inside. So I had to hold and sit and stay there and hold his hands and roll each finger out as I made the fingerprints. And then I would move over to the other hand and do the same exact thing and work through all 5. So all of his fingerprints were done there at the police department after we finished this interview.
And you yourself did that rolling of the prints. Is that what you just testified to?
I did.
Okay. And I just want to go through that process again a little more slowly. Did you just testify that all 10 of his fingers would have been printed? Is
Yes,
that
sir.
correct? Okay. And when you're going through that process, do you make contact with the person you're printing?
Sure. So unlike now, you have to take your hand and you hold the print, the finger, you go to the far side and you roll it because you're getting ink. So now with a computer, you can sit and look at a screen and kind of move it around. But with this, you had to dip his hand in ink. You take it and roll from side to side. And then you would move one at a time from finger to finger. So I dip, roll, dip, and roll, and then get the thumb. And then you move around to the other side. And each time you do that, you have to grab the hand and you have to hold the hand and do it. And they have to kind of hold their hand real loose and kind of give you kind of control of the hand. It's a much better system we have now. But at that time, I had to sit and hold his hand during that time while we were doing that.
All right. And so I want to fast forward a couple of days and then rewind back a couple of days. Did you have an interaction with Chris Melton on January 21st of 2001?
Oh,
Yes,
we
I
don't
did.
ask about the
Okay.
hands?
And during that interaction, did you and Detective Newton take any pictures?
Yes, we did. We took pictures.
Okay. In particular, on Mr. Melton's hands, when y'all met with him on January 21st, was there anything that caused you to?
Did I miss a question? Because he's going to say now that they saw injuries then, but why not ask and clarify that you did not notate any marks on his hands on the 19th before you move on to the 21st? We're just going to move to the 21st and then say, we noticed it then for the first time.
Take pictures of his hands.
Yes, he had marks on his hand on Sunday that weren't there on Friday evening when we talked to him. And so when we were taking pictures, we took pictures of those also in the rest of his body.
So when you met with him on January 21st and you saw the marks, you took pictures of those, or Detective Newton, y'all took pictures of
Yes, on the 21st, we saw those. We did the other stuff we had to do, and we also took those pictures.
Were those marks on his hands on January 19th of 2001 when you interviewed him and then fingerprinted him?
They were not.
Okay. If they had been, would you have taken pictures of them the way you did on January 21st?
Yes.
Okay. And this is a little bit of an aside. Have you ever worked with plumber's glue and some things related to plumbing?
Sure. So there's primer and there's glue, and the glue gets all over your hands. You have to peel it off, things of that nature. On the interview on Friday, I was just watching individuals who were interviewing, and he was picking at his hands. One, I think, for concentration and trying to cope, if that's a word. I don't know, but he was just trying to pick at his hands and pull that glue off. None of the stuff that I had to do, like if your hands are extremely dirty, like if I got somebody, I needed to print them, I'd have to clean their hands in order to take prints. So there was nothing on his hands that impeded with me taking fingerprints. So I didn't have to go scrub his hands, which I've had to do before, where we had to get somebody and scrub their hands in order to get prints. We didn't have to do that. Glue primer is usually purple, and I won't say it's see-through, but it's not. It doesn't block, and glue doesn't either. It just peels up, and you have to peel it off.
Well, and let me ask you this question.
Did he not
then.
have it on his hand or no?
Was there anything about the things on Mr. Melton's hands on January 19th of 2001 that would have prevented you from seeing these injuries if they had been there?
No, there was nothing covering his whole. From the picture, you would have had to cover his hand from about where my shirt stops all the way to his fingertips to cover that up, and his thumbs and that area right in there. So you would have had to cover everything.
Okay.
And the plumber's primer and the glue, it gets on your skin, but it's not that bad. I plumbed the house when I built my house. I'm not very good at it, but I got more stuff. But you can see through it. Like if you cut yourself or anything like that, you're going to see that.
Okay. So I want to go forward to January 20th of 2001. So this is the day between the first day in time that you ever talked to Mr. Melton and the second day in time that you talked to Mr. Melton. Did you take any investigative actions in order to, see if you could talk to some of the people that Mr. Melton had mentioned to you about being with him or around him on Friday morning?
Yes, we made phone interviews on Saturday from the police department.
Okay. As specifically as it related to Mr. Melton's whereabouts on January 19th, who did you talk to on January 20th?
I talked to Josh, and I also talked to Mr. Teeters.
Okay. And you've already testified about who you understood Josh to be. Who did you understand Mr. Teeter to be?
From Truck Customs.
Okay. And is that the Truck Customs that you were making reference to?
Yes, sir.
Judge, I'm going to turn the Elmo off, or can the court turn it off? I just don't want to put something down here inadvertently and have it displayed, because I almost did. Thank you. Okay. Well, and so as it relates to Josh McCurdy, what did Mr. McCurdy tell you about his whereabouts and Mr. Melton's whereabouts on January 19th of 2001?
He drove to Chris's house that morning, approximately 7:15. He said to 7:30, and he said their first stop was at the plumbing. They went there first. If I could refer to my notes, I can tell you that he also mentioned that they went by a Chick-fil-A that morning also.
Do you, and so as you sit here, are you having difficulty recalling the remainder of what Mr. McCurdy told you?
Yes, sir.
Do you believe that reviewing your report would help refresh your recollection?
Yes, sir.
Okay. Would you please do so? Then don't read from your report, but let me know when you finish.
Yes, sir. So he does mention that they went by Chick-fil-A that morning also for some breakfast.
Did Mr. McCurdy tell you anything about where they went after Chick-fil-A?
To Grayson, which is just right down the road. From
And was there a particular time he said he believed that they had gone to
He
Grayson?
thought it was between 8 and 8:15.
Okay. And from there, did he tell you anywhere that they may have gone after that?
He mentioned Forsyth and the place with the rain, and he was talking about just how wet they were getting and weren't able to get in and out from underneath that rain. He said that it was just too much rain to get any work done there.
Okay. And so after they left Forsyth, did Mr. McCurdy say anything about where they went next?
He did mention they went back to Truck Customs that afternoon.
Okay. Did they go anywhere between Forsyth and Truck Customs?
They did stop for lunch, for the lunch break that they mentioned earlier, if I didn't mention that.
Okay. And then did Mr. McCurdy say anything about anything that happened while they were at Truck Customs in the afternoon?
He mentioned the page in detail, and then he talked about how they left Chris's truck there and he drove him to Athens. He didn't want Chris to have to make that drive, but he drove him all the way to Athens.
Did he say anything about any fears that Mr. Melton had or any actions that Mr. Melton took as they drove to Athens?
No, he said while they were in the truck that Kris was calling information, trying to track down other parents of the girls there and trying to make contact as he drove from that area. I'll just say Loganville because it's easiest there, but as they drove down from Loganville to Athens, he was trying to get information and see if he could make contact with family members.
Okay. And did he?
All right, I want to take a quick segue back to opening statements about this issue with the substance on the hands. Because, you know, I always enjoy when on direct examination, the question and answer, you get the feeling that it's something that the state says, hey, we're going to have to talk about this issue. Putting them on alert that we're going to have to address something because we know the defense is going to go at it. So I was curious exactly what Cruz had said during opening, because I vaguely remembered him saying that the substance was on his hands the first day he spoke to the police. So I queued it back up. It was the day one feed from Law and Crime, so the volume sucks. Let me boost it and pull us over.
Chris Melton, another important fact. After Ms. Baker's death, Chris Melton comes to the police department with his hands covered in plumber's glue. You will hear from law enforcement that there was a shirt that Ms. Ashley P.B. Hall, she's an amazing friend, she did everything she could to try to figure out what was going on with Ms. Baker. When Chris Melton came to her house, there was a shirt that she washed, and it was a substance. She called police and said, hey, we believe there's an issue with the shirt. And what law enforcement determined was the substance on the shirt was the exact same substance Chris Melton showed up to the police department with his hands covered in the day of her death. Now, you may hear the audio is grainy. I'm going to try to play it for you all. But you may hear law enforcement. I'm going to play it. But I have to play it a couple of times. But you'll hear law enforcement ask him, and this is a quote, do you want to wash them things? And Chris Melton says, no, this is neat right here.
So there we go. There we go. I thought that was especially interesting because I remembered the mention of it. But isn't it weird that he goes to Ashley Peavy to help him wash a shirt? I forgot about that detail from opening. But that's interesting. Hey, can you wash this for me? Like, was he worried that they would search his own apartment and didn't want to wash it? Does his mom and dad, do they not have a washer dryer? Did he need to wash it right away but couldn't bear to not go hang out with Ashley and whatever girl came over that he might be able to canoodle with next? Well, okay, Donnie, so I think that was strategic by Cruz. She's so amazing. She's just washing his clothes as if there's nothing weird about that, right? So putting the emphasis that I didn't catch during opening, I missed it. But now that I'm thinking about it, it seems like a sly remark from Cruz. Like, isn't that something? She's doing his laundry. What great friends. Just randomly needed a shirt washed. So I'm excited for cross-examination. Also, yeah, covering injuries. I don't know. I'm coming up with different pictures when I do a quick search for, like, plumbers. Would this be the, well, some of it just looks white. There's others that come up looking kind of purple. But I found one that the glue is peeling, and there's some redness under the finger, so I thought this picture was interesting. So if you look, like, this looks all like white and normal, but look how red it is under the peel. So I thought this was a good perspective. It seems like it could conceal discoloration, things that you would think you'd be able to notice on somebody's hands. I don't know. Back to everybody's favorite witness.
He say anything to you about any types of worries or fears that Mr. Melton had?
Objection, Your Honor. Hearsay.
In response to the objection.
Judge, under 24-8-8035, past recollection recorded, I believe yesterday during Mr. McCurdy's testimony, the foundation for that was laid, and this would be that past recollection recorded being admitted under exception to the hearsay rule of 24-8-8035.
All right. Mr. Cruz.
Here, I'm pulling up the law. Okay, so 8035 does not apply in this case. The state, if they wanted to use past recorded recollection, it's not Detective Ricketts who they would use it with. It was Josh McCurdy who they could use it with. I'm becoming concerned that the state is trying to use Ricketts to override everybody else's testimony. So I would just ask the court to instruct the state not to elicit hearsay. If it's something that's a personal observation of Detective Ricketts, that's lawful, that's legal. As far as just going through witnesses and saying, hey, what do they say about this, what do they say about that, I believe that is improper.
But your objection is hearsay.
It is.
I'm going to sustain the objection.
And, okay, is it, so I'm going to move forward then, Detective Ricketts, and talk to you. You've already mentioned that you had a conversation with Mr. Teeter, is that right?
That's correct.
Okay. I don't think we need to get into the contents of that conversation, but I do want to go forward with you to January 21st of 2001. Did you have contact with Mr. Melton again on that day?
I did. He voluntarily came back and met with us.
Okay. When Mr. Melton met with you, did he have anybody else present with him?
His family was with him, but they came back with him, but his dad was with him.
Okay. When you spoke with him, and I think you already mentioned taking photographs of him, who all was present when that was happening?
Just Kris and Detective Newton and myself.
Okay. And did Mr. Melton give you any additional information beyond what he told you on Friday evening about where he was on Friday morning?
We went back over the timeline of events from Friday, and Kris added that he had stopped by the Wachovia Bank in Loganville just after 9, which he didn't mention on Friday, which we took note of that. And then on Monday, some other detectives went to run that to ground. That information wasn't passed on a Friday, but Kris talked about it with me on Sunday. Everything else pretty much stayed the same except for that.
All right. And so when he was meeting with y'all on January 21st, did anything come up regarding a blood sample?
Yes, so at the end of our conversation at the police department, we talked about the crime scene, things of that nature. It's the first time that I brought up with Kris that there was the possibility that Tara had been sexually assaulted. We had a brief conversation about DNA and some things of that nature, and I told him that at some point we would need to get consent and he would need to do a sample for us, and he agreed. So warrant wasn't necessary, but he agreed to go with us to Athens Regional or Piedmont Hospital to do that.
Did you attend or observe that blood draw?
I did. We went there. They followed us over. We had made contact because it was a Sunday, and we had a nurse in the lab do that for us. And I observed both vials be drawn, placed in the evidence bag, and then I took them back to the police department and placed them into evidence.
Did Mr. Melton make any statements to you about the last time he and Tara had sex?
He did. From going over my notes and listening to the recordings, I can't give you a precise date. His voice trails off there, but it was in that week period of time, sometime between that last weekend. I want to say it was Saturday or Sunday would be my best recollection. The recording goes off, kind of. That microcassette recorder's not real good.
Sorry.
That's okay. Sorry, sir.
There. Let's talk about the tools that you had in 2001. Obviously, nowadays, we all walk around with these guys that have a recording function on them. When you were a police officer in January of 2001 and you needed to record an interview with an individual, what equipment were you provided with in order to do that?
We were using microcassette recorders. Audio wasn't always the best, but we did pretty good on it. You can listen to them. It's pretty hard to. We used those. I laughed talking to some of the officers waiting for grand jury this morning. They didn't understand that this was the first area of time when we were doing these reports, and the one that was word processing. So if that makes sense, we were done everything else before that on typewriters. So word processing was kind of new, and we were using microcassette recorders, which weren't that great. Athens Clarke County at that time was in the process of putting up interview rooms with video cameras and things of that nature, but they weren't. That was not the norm.
So, I mean, is it fair to say that this was a period of time when, like, the use of technology and the tools that y'all had available was in a period of transition?
Huge.
Yeah. So, as you were there on January 21st, I want to go and retrieve some things from evidence and show them to you. So, if you bear with me for just a moment.
Oh, did they mute us?
and then, I'm sorry, I said 2 exhibits, 2 sets of pictures. So D29 has been marked collectively, so all the pictures are D29. And then I'm also going to hand you Defendant's Exhibit 37, 38, 39, and 40 that have been admitted into evidence already as well.
All right, so these were the pictures yesterday.
I'm going to give you a chance first to look through them, and then if you just let me know when you've had a chance to look through them, I'll continue asking you questions at that point.
So these are photos of the wall that was punched.
Okay. Detective Ricketts, in the collectively marked exhibit that I handed to you, where there's one number but a bunch of pictures, do you recognize those pictures?
This one right here?
Yes, sir.
Yes, sir, I do. These were taken at Piedmont, Athens Regional.
Okay. And again, who was present when those pictures were taken?
Detective Newton, that's his arm right there in the picture right there. He took these photos here.
Oh, you could see some of it on his hand. Like, there's like a band of it. Okay, wait. Does he hold it? That's the first time he holds it up,
Athens
right?
Regional.
Okay. And again, who was present when those pictures were taken?
Detective Newton, that's his.
I don't know if there's a way I can, like, really doesn't let me zoom in. Let's slow it down and go try to catch a good frame. So this is a collective exhibit of some of the hand pictures. How did Cruz describe this yesterday? This omnibus exhibit that he wanted to introduce? Yeah, so photos of wall is what I noted for it.
Arm right there and
All right, we'll speed it back up.
picture right there. He took these photos.
Yeah, because he's got stuff all on his hands for sure.
Here. And
But why would he have all that on his hands on the 19th if he didn't work? And then he was eating food.
I took the other photos.
Okay. And those images, the injuries that are depicted on those hands, were those present on January 19th of 2001 when you interviewed Mr. Melton and then fingerprinted them?
They were not.
Okay. And then the other set of pictures that I handed you, I want to ask you a few questions before we talk about those. I think they're defendants exhibits 37 through 40, if I'm recalling correctly.
Yes, sir.
Okay. When you noticed those injuries to Mr. Melton's hands, was there any explanation provided by him for where those injuries came from?
I talked to him about those. He advised that when he got back to his apartment that went in was alone for a period of time, that he kind of lost it. He said as soon as he walked in the door, it was there on the right side when you go into his apartment, and he just punched the wall numerous times. And then he said he sat on the floor and just cried.
Did you ever go to Mr. Melton's apartment after you talked with him about those injuries and how he received them?
So I believe it's the 23rd. Went over. I believe that's the correct date. But yes, sir, I went and I took these photos in the apartment.
Okay. And when you say these photos, are you referring to defendants exhibits 37 through 40?
I am.
Okay. The damage that you saw to the wall, was that consistent to you with the injuries that you saw on Mr. Melton's hands?
It is.
Okay. Detective Ricketts, thank you so much for your time. I don't have any other questions for you right now, but I'm sure Mr. Cruz may have some.
Yes, sir.
Cross-examination, Mr. Cruz.
Cross, may I use the bathroom?
Yes. Why don't we take a 10-minute recess and allow everybody to use the restroom? We'll be off the record until about 10:25. Thank you. Don't discuss the case. We'll see you all shortly.
Happy that we get to skip this break because I want to see it. Oh, this is kind of a long break. Let's see. Yeah, so basically what we're working with, you guys, following Chris Melton's hands, and the podcast that helped bring renewed attention to this case has been saying that his hands were fine previously, that he had no injuries on his hand. If you go check out the comments on their Facebook page, the podcaster is repeatedly making comments saying, but there were no marks on his hands, there were no marks on his hands. So I've been waiting to see, because why would the podcaster be saying that so adamantly? Lo and behold, really the only evidence that there weren't marks on his hands on the 19th is Detective Ricketts' word. The word of somebody who didn't make this guy wash his hands before fingerprinting him. And I'm like, okay, well, how bad could the splotches have been? Could it really have covered up injuries on the hands? But the little glimpse of the picture we just saw, there was a huge splotch of cover. And it looked like there was coverage on his thumb, too. And in the injuries on the hands, like, I can imagine how, like, a smear of something. I've covered up one time. Dog got out of the house, had to run across to my neighbor's yard, and they had like one of those cement block walkways, and there was a part of the block that was like a little bit lifted compared to the block before it. And I'm just running, trying to catch Simba. Simba's honky-dory running across the lawn. And when my foot lines up with this block, it like face plant, and I got this ugly, ugly scrape. Like all this red across my face. And a little bit of foundation. I didn't even do anything complicated. I don't know how to use that stuff properly. Just straight foundation, caked it up. It was gone. Couldn't tell. Couldn't see a thing. So I can imagine this is actually pretty easy to cover up. And then seeing a picture where there's actually gunk, apparent gunk on his hand, to the point where you can't even see his hair visible in the little picture that we saw. It's enough to cover the hair on his hand. I'm not convinced that this is a credible debunking of the idea that Chris Melton's hands had these injuries only on the 21st and not on the 19th. But that's just me. That's just me personally. Just me.
Back on the record, you may bring the jury in. Thank you.
I mean, they don't search his car anyway, so.
You all may be seated. Mr. Cruz, cross-examination.
Maybe he'll pull up the picture during cross. Let me not get ahead of myself.
Good morning, Detective Ricketts.
Hey, good morning.
My name is Attorney Ahmad Cruz, and I have the privilege and honor of representing Mr. Faust. Under the authority of this honorable court, I'm going to ask you some questions. Is that okay?
Yes, sir.
So we're back to the authority language when it's a sus witness.
Okay, excellent. Detective Ricketts, you were with ACCPD, is that correct?
That's correct.
Okay, and during the time of this investigation, you were with ACCPD. Is that right? Would you agree that ACCPD dropped the ball on this investigation?
No.
Okay. You believe ACCPD followed up on all leads,
Yes.
confirmed all information,
I think so. I would like to add something to that if you would allow me to.
So it's not just a simple yes?
I can't answer any questions. We could talk about it after, though, if that's okay. This time.
No, I think I'll answer that question. Yes, I wish if you look back at any case 25 years ago and look at it with fresh eyes from 25 years ago, yes, things would have been done totally different, I think, with some options and things that would have happened. Everything that I can say to, and I will not answer on behalf of ACCPD, but on the days that I was a part of this case, I will say, I think, yes, we did. But I think if you look at anything 25 years back, I think if you look at something I did last week, there'd be things that I would like to improve on. Okay. But I don't think drop the ball would be a word I would ever use.
Sure. Do you believe ACCPD followed the evidence appropriately?
Yes, sir. The evidence, to my knowledge, I believe they did.
Okay. And I'm assuming that you met with the prosecution before you testified today. Is that right?
That's correct.
Okay. Do you or ACCPD feel a need to justify why Chris Melton was not arrested?
No.
Do you or ACCPD feel the need to have to defend Chris Melton?
I don't believe I'm here defending Chris Melton.
Sure. So that is a yes or no question.
Then please repeat it.
Yes, sir. Do you or ACCPD feel the need to defend Chris Melton?
No.
Okay. Do you or ACCPD feel the need to defend the state's case?
No.
Okay. So I'd like to ask you some questions about a couple of things that you talked about on direct examination, okay?
Okay.
For starters, would you have any reason to disagree that January 19th, 2001 was 9,153 days ago?
Sounds appropriate.
Okay. And I'm going to use this whiteboard over here.
Yes, sir.
Got the whiteboard back. There's a poll, chat.
So 9,153 days since
They don't want him to write on it. They took it away from him.
01. Fair?
Sounds correct.
In 2001, can you tell us what team won the Super Bowl?
I cannot.
Okay. In 2001, can you tell us what team won the World Series?
No.
In 2001, can you tell us what your favorite song was?
No.
Okay. So no to Super Bowl, and forgive my handwriting. It is terrible.
Here you are testifying about how great your memory is
No.
in 2001.
To
Because remember, even though he's looking back at his report, he also said, when it comes to the 6 days, I saw her the weekend prior versus the 10-day claim, he's saying it trails off. You can't hear it in the recording, but I remember him saying it was either Saturday or Sunday. So that's something, that's at least one thing he's claiming to remember without having a report available to refresh his recollection.
World Series. No to favorite song.
I feel like it's a good guess to guess the Yankees in that era. Just statistically.
My handwriting is terrible. And this is no to favorite song. Correct. And you would agree that your notes say nothing about Mr. Melton picking anything off of his hands. Is that correct?
Braves
Yes, sir,
one.
I'm going with that from the recollection of the audio cassette tapes from that day.
So your statement to this jury is that based on the audio cassette of that day, it refreshed your recollection that Mr. Melton was picking items off of his hands.
Yes, sir. You asked me about the Super Bowl. Not an NFL guy, not a baseball guy.
That's fine.
The crime scene for Tara Baker, I'll never forget.
Mr. Ricketts, that's a yes or no question.
Well, repeat your question, please.
Witness is allowed to explain his answer.
May I be heard on that, Your Honor?
You may be, yes.
I would disagree with that. The witness on cross-examination My job is to posit to the witness yes or no questions. If the state wants the witness to elicit further testimony, they do that on redirect. At this time, Your Honor, I pretty much give the witness what the answer is. They can answer yes or no, and we decide which direction we go from there. So I would ask that the witness is not allowed to control cross-examination, to control Mr. Faust's rights to cross-examination, and we're allowed to ask the witness leading questions that the witness answers appropriately.
Okay, so this is not about witness control. This is about what the law allows. And cross-examination questions are yes or no questions, certainly. But the law allows a witness to answer yes or no and then explain if he or she chooses to make an explanation. And so I'm going to overrule your objection. He is allowed to explain if he chooses to. If there are further objections the court needs to make with regard to those explanations, I certainly will hear it.
Yes, ma'am.
If you'll ask the question again, Mr. Cruz. Thank you.
Sure.
No such thing as non-responsive in this court.
But my understanding is the audio is what refreshed your recollection in regards to what was on Mr. Melton's hands.
Yes,
Okay. And that audio is from January 19, 2001.
that's correct.
Okay. And you've already listened to that audio because the state provided you with a copy. Is that correct?
Yes, sir.
Okay. And if you were to hear that audio, you would recognize it. Is that fair to say?
Yes.
Okay. Court's indulgence. Turn the volume down on this. I'm gonna move the mic out the way.
Okay.
I'm going to allow you to hear the audio. I want you to listen to it. When you feel comfortable that you recognize the audio, just look up, okay? Is that fair? Is that fair?
Yes, sir.
May I approach the witness, Your Honor?
Right.
Yeah. Sounds like something's playing. Give me 1 second. There you go. And if you need to turn it up just a little, you can press that button right there.
Okay, I think we're muted. I don't think we'll be able to hear it the first run. Oh, we're back. Just get the witness headphones. Just put headphones on the witness stand.
You can turn it up if you need to. Correct. If you recognize it, if it's accurate, what you recognize it as.
It sounds like the beginning of the audio from the 19th.
Correct. With you and Mr. Chris Melton?
Yes, sir. It's followed.
Okay, that is fair. Does that sound like a fair and accurate rendition of that recording as you remember it? Now, what I'd like you to do, I'm going to mark that flash drive, which has been identified by the witness as the interview between Detective Ricketts and Chris Melton on January 19th, 2001, as Defense Exhibit 44. Let the record reflect that I am showing the state what has been marked as Defense Exhibit 44. All right, so this is what I want us to do with Defense Exhibit 44. Detective Ricketts, I'm going to allow you to listen to this, okay? And can you look up at the portion where you discuss with Chris Melton what's on his hands? Is that fair?
Yes.
Okay. And just to make sure we're clear, this recording, based on your prior testimony, this recording refreshed your recollection about Mr. Melton picking his hands, what was on his hands, things of that nature. Is that fair to say?
Yes.
Okay, excellent. May I approach the witness, Your Honor? Okay. There you go. And I just stopped it where you stopped it, so if you... Okay. And if you would, once you hear that portion of the recording, just let us know the timestamps.
I know you might be thinking, shouldn't the attorney already know the timestamps? Well, he's played the timestamps previously with every other thing he's tried to get admitted into the record. I'm wondering if by doing it this way, there can be no objection from the state about foundation or what part of the recording, because it will lead this witness to specifically identify the relevant portion of the interview. Oh. Even better. So much for prior consistent statements, huh? They're just non-existent.
If that was anything. I thought that, that's all I meant to say.
Okay, that's it.
Look at his face.
You can turn audio if you need it. Your choice. If you could find it by speeding through it, we'll take that. If you need to listen to it, we'll take that. We just want to know where in that recording do we talk.
Recollection is toward the very end of the interview, which is pretty lengthy.
You can speak through it. I think it's I could give you the times for the ending of the interview. But yes, you can speak through it.
Do we just watch him melt in real time? Or should we speed it up? You should have focused this hard in 2001. Get some music in the background. I only have
And the
sound
interview
effects.
ending time is 42:08, if that will help you. 42:08 is the interview ending time, if that will help you.
Slow it down. Have this sound effect. could play the StreamYard countdown loop. I'll only play it for a second if I can end it early, but one of these. Play Glanville reading lyrics.
Associate of YSL released a song on YouTube titled Slime Shit, where the lyrics state, hey, this is that slime shit. Hey, YSL shit. Hey, killing 12 shit. Hey.
Get some really in the mix. Get some Antonio
Your
Sledge.
playing is pointless.
To present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak.
Your Honor, if you would like to just avoid the jury sitting in the box, if you would like to give them a break while Detective Ricketts looks over that video, I have no objection to saying.
Thank you.
Yes, ma'am.
I think this is the Are You Certain, which might be timely for this.
Without saying what he said, yes or no, did Mr. Williams indicate that he knew the gun was in the car? Without saying what was
Would
said.
a transcript help you find if that?
No.
Are you certain?
What's the basis for the objection?
I just asked, was he certain?
Would a transcript
I
help you
will
find?
sustain this.
Would a transcript help you find it faster, Detective Ricketts? Sure. I have a transcript for you as well.
Are we gonna have like 40 minutes of this guy staring at a recording to fill? Okay, wait. A few more minutes and he holds up the laptop. Got 2 more minutes. We're gonna speed up till he holds up the laptop.
You go to mark 4048 through 4049. Or 4048, start at 4048 and play it to 4051. Justin. Thank you. Did you hear it? Yes. Okay. And you would agree that the statement that you made that led you to say that Chris Melton was picking things off of his hand, that he had different glues on his hands, was you need to wash those things up or anything. Is that correct?
Yeah, I believe I said, do you want to wash those things up?
Okay. Can you write that on the board? Do you want to wash those things up? Okay. And that is minute mark, you would agree, 4048 to 4051?
Yes, sir. That was helpful. Thank you.
You're welcome. Your Honor, I would move to admit defense exhibit 44 for the purposes of moving.
Any objection?
No, Your Honor.
It is admitted.
Thank you, Your Honor.
And just to clarify for the record, is it my understanding, Mr. Cruz, that you're just seeking to admit those 3 seconds of the recording?
Right.
Okay.
For now, we're gonna admit more, but for now, just those 3 seconds. So, the statement, do you want to wash those things up? It says nothing about picking at fingernails. Is that correct?
That's correct.
Okay, and we've agreed that it's been 9,153 days, right?
Correct.
It says nothing about picking paint off of his skin, or picking glue off of his skin. Is that correct?
No, sir.
Okay, it says nothing about whether the glue was transparent or not, does it?
No.
Okay, would you be shocked to learn that Mr. Melton testified himself that he had plumber's semen on his hands?
No.
Okay, but that would be inconsistent with the testimony that you just gave the jury here today. Is that correct?
No, plumber's glue, plumber's cement, I would
different.
categorize as the same thing.
Well, he said 3, and he included plumber's glue.
Okay.
Okay. So would that testimony differ from the testimony that you just gave the jury on direct examination?
I don't think so.
That's fair. 9,153 days. We don't remember the Super Bowl. We don't remember the World Series. We don't remember our favorite song. But the simple statement, do you want to wash those things up, led you to tell the jury that Chris Melton's hands, you could see them. Is that right?
Yes, sir. It was a totality of this interview, sitting in that interview room, looking across the table at a dad and a son. And Chris, as he would make comments, you can hear that. He'll tone in, tone out, not a person to show emotion or things of that nature, but would sit and pick at his hands and pull. And it was just, I won't say a nervous tick, but it was what he was trying to do, I think, to keep his focus, would be my opinion. That is what we're talking about with there. We're ending the end of the interview where I've got to get fingerprints, and I just asked him, hey, do you want to wash those things up? Do you want to get that stuff off of there? That's all it was. If he'd have had a high amount of semen or whatever else on his hands.
Objection, non-responsive and narrative.
I'm going to sustain the objection with regard to non-responsive at the end of this particular statement. You may continue.
What you just stated, that's nowhere in the police report, is it?
No.
You have your reports, is that right?
That's correct.
It is not in the audio recording you heard, is that correct?
That's correct.
Okay. And
if this 2001 interview was with somebody other than Chris Melton, if they knew about Faust back then and he had something on his hands or he was just picking at his hands, do you think that, one, they would not have photographed his hands that day? 2, do you think this guy would characterize it and try to explain it away, if you will? That seems to be the phrase of this trial. Explain it away as just something he was doing as a nervous tick that anybody would do. Not a nervous tick because maybe somebody's dealing with consciousness of guilt. It's just an ordinary discomfort that people feel when they talk to detectives like us. People are always uncomfortable talking to us. How often do we have a detective look at that type of demeanor and think it's no big deal? Because typically, a detective would be on the stand telling us he was acting nervous in a bad way.
as far as the evidence that you've personally provided in this case, the very first time you've ever made that statement is before this jury here today. Is that correct?
What do you mean?
Sure. Based on your notes and based on the audio recording. You have never said before that Mr. Melton was picking at his hands, picking items off of his hands. Is that correct?
No.
Okay. But we would agree 9,153 days later you stated. Is that correct?
That's correct.
Thank you. Now, you also stated on direct examination that Mr. Melton wanted Miss Baker at his, excuse me, let me rephrase that. You also stated on direct that Miss Baker wanted Mr. Melton at her birthday party on Friday. Is that correct?
That's correct.
Did you interview Miss Virginia Baker?
No, I don't believe so.
Okay. So you're not aware that, but you did not interview Miss Virginia Baker, is that correct?
No, the only people I did were some roommates and other folks who corroborated what Chris said for me there.
Okay. Do you know if Chris Melton had talked to those roommates and told those roommates the same thing he told you?
I would have to look at my notes, but one of them mentioned it to me in her statement, I believe.
Sure, look at your notes. And tell us the date that she mentions that.
Give me one more second, just to make sure I'll give you a good direct answer.
Absolutely.
What is going on with the microphone? Okay, this is Skippy Skip. Jeez.
So those statements aren't going to be about the birthday party, and I don't know if you want me to read what I've got about the relationship with Tara. I don't want to say so. I don't have anyone doing what you said, so I'll say no to that because that's on a different relationship page. I don't know if you want me to bring that up or not. So
No. So the specific answer to my question is no. No one else said anything about Mr. Melton's.
to my knowledge, no. Then it was a different statement.
So the statement that you gave on direct is inconsistent with your notes.
Which was the statement I made on direct?
That Mr. Mr. Melton and Ms. Baker had plans on Saturday. Is that correct?
That's correct.
Okay, and I asked you, and I'm gonna paraphrase it, had that been corroborated by anybody else? Is that correct?
That's correct.
Okay, and your answer to that question is no.
Yes, that direct question, yes.
Okay, so you just simply took Chris Melton's word for it. Is that fair to say?
Yes, that was my point there.
Do you think in a criminal investigation, especially involving murder, aggravated assault, burglary, aggravated sodomy, arson, it is important to take more than someone's word for it? Is that fair to say?
Yes.
And I believe the question I asked you was about the party Friday. That's what we were talking about, not Saturday, the party Friday.
Yes, sir.
So just to clarify the record, the fact that Tara wanted Mr. Melton at the party Friday, that was based on Mr. Melton's word. Is that correct?
That's correct.
Okay. And the same for Saturday. Is that right?
Yes.
Okay. And Mr. Melton did not provide any proof of any plans he had with Ms. Baker. Is that correct?
Did not.
Yeah, I'm going to go into a line of questioning that the Honorable Court has advised us to be cautious about. Can me and Mr. Yalamanchili approach the bench, please? All right, so you know Mr. Melton's parents' address, is that correct? Okay, you don't have to say the address. And Ms. Baker's address was 1C.
Oh.
Your Honor, I am asking the Honorable Court to take judicial notice under OCGA 24-2-201B 2 of the distance between Mr. McCurdy's parents' home and Ms. Baker's home.
Judge, judicial notice does not bring a fact before a jury as a trier of fact in a jury trial. It is just something that the court can take notice of. It is if it is a previously established fact. So the method in which Mr. Kris is attempting to use judicial notice, I don't think is proper.
That is not true, Your Honor. I have case law 1, but I'll read the statute. The statute provides B, a judicially noticed fact shall be a fact which is not subject to reasonable dispute in that it is either, and we're under subsection 2, capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. And C says a court may take judicial notice whether or not requested by a party. And D is the language that, shows that the state's argument is not the law. A court shall, there's no discretion here, a court shall take judicial notice if requested by a party and provided with the necessary information. The limitation that the state just put on the honorable court's ability to take judicial notice is not a limitation in the law, Your Honor. We're relying on the statute. We would like to show the state, if okay, the statute as well as the item we would like judicially noticed.
I'm familiar with the law, Judge.
And may I approach, Your Honor? Approach you.
May you approach the court?
Yes, ma'am, to provide you with these documents and the law.
I don't need the law, Mr. Cruz. Any other
Are
arguments?
you sure?
No, ma'am.
All right. I'm going to sustain the state's objection. I agree with the state's rendition of the statute and the appropriate things that are to be used for judicial notice. I'm going to sustain their objection.
Yes, ma'am. Do you have your phone?
I do.
Okay. Can you go to Google for us, please?
I can turn it back on. It's off. Is that okay with the court?
I don't have any prohibition against that.
Okay. I have it on flight mode.
I'm not objecting in this trial. If there's an objection, I will hear it.
I just don't want to upset you, ma'am.
No, sir. Thank you.
Thanks.
Okay, I've got a signal now.
Okay. Can you go to Google Maps or whatever you use, Apple Maps, Google Maps, whichever you prefer.
Okay.
And I'm going to approach you. And for the purposes of the record, I am going to provide Detective Ricketts with Chris Melton's parents' address.
So they're muting us every time they say the address.
Can you put the distance from Melton parents to Tara's home? Yeah, 100 miles.
Give me the directions.
Don't give me the directions. Do you have it pulled up?
I have the address.
All right, and do directions to 160 Fun Drive, Athens, Georgia, 30605. Chris Melton's parents' home.
All right, maybe they'll search all this and then.
And when you pull it up, I won't ask you about the time. I believe that that's not competent evidence, but I am going to ask you about the distance. Is that fair?
Sure.
Okay. All right. To Tara Baker's home. You would agree that on one route, the distance from Mr. Melton's parents' home to Miss Baker's home is 39.6 miles. Is that correct?
Yes, sir. I'm getting an ad pop up, but
Sure. Circle this.
yes, sir. I'm getting 40 miles.
Okay. 39.6 added up, 39.9 rounded up. Excuse me, rounded up. Okay, perfect. All right. And I want to be specific. So 39.6, is that correct?
Yes, sir. This Google's giving me 40 on the nose.
Even?
Yes, sir.
Okay, we'll take what Google gives you. Put 40 miles.
I can switch routes and see for you if you like.
No, you're fine. All right. Do you recall talking to a Mr. Lindsey Baker?
I'd have to look at my notes to double check.
Okay, sure. And I don't believe that would be in your individual reports. And I don't know what all notes you have, but
I pretty much only have anything that my name is on. I don't have anything.
anything else? Well, let me ask you this. Do you know who Mr. Baker is?
No, sir.
Okay.
Off the top of my head, no, sir.
That is fine. Did you ever visit Mr. Melton's parents' home?
I did not.
Okay, but he did tell you at the time that Ms. Baker was killed, he was staying at the parents' home. Is that right?
Correction. Could you repeat that question for me one more time?
Sure. Which?
Say the Baker's residence?
No, and I might have said the Baker's
Yeah, I think
residence,
so.
so please forgive me.
You go to the Baker's home.
Previously, he
the
said
Melton
Baker.
residence.
This time he said Melton.
No, I did not. Someone else did that.
Okay. So you don't know the layout of the home?
I do not.
Okay. But Mr. Melton did tell you he was staying in the basement of the home. Is that right?
No, he just told me he was staying there. He never told me where in the house he was staying. He just said he was staying at his parents' house. And on that same audio, you can hear his dad at the beginning say he's been staying there for pretty much the week.
Okay.
Hear him chime in.
But to your personal knowledge, you don't know where in the home he was
No,
staying?
I don't have any information on that. May I turn my phone back off?
Absolutely.
Because it will.
Now, you had opportunity to listen to the recording between yourself and Mr. Melton, right?
Yes, sir.
And we've agreed that that interview took place on January 19, 2001. Is that right?
That's correct.
And you asked Kris during the interview, how did you start your day today, or what kind of went on today for you? Do you recall asking that question? And Kris was able to explain his day in a calm and clear tone. Is that correct?
Yes.
He was not unable to answer any question. Is that correct?
I believe everything I asked him, he did answer.
Okay. He was not fumbling over his words. Is that right?
No, there are times in that recording that he will get quiet. He won't say anything.
Okay.
But he was able to get through his conversation.
But we could both agree that he wasn't frantically crying. Is that right?
No, he was not.
But he did tell you that he was asked to identify the body that day. Is that right?
That's correct. Earlier in the day.
Okay. And we agree that Ms. Baker died on the same day. Is that right?
That's correct.
And he also described her as his borderline fiance. Is that correct?
That's correct.
He even spelled the name of Truck Customs for you. Do you recall that?
I did. I was having an issue with it. I believe in that tape, I asked him to spell it for me.
Mm-hmm.
It could be the second interview I did because I was having a hard time finding it. But that could be the second interview I did with him where I asked him to spell it.
Would hearing the first interview refresh your recollection? Or excuse me, let me change that. Would hearing him spell out Truck Customs refresh your recollection?
Sure. If that's in the first one, I'll just agree with you. It did. He did spell it for me in one of those two because in my report I had it wrong.
Sure.
And I had to get it corrected.
So let me ask the question this way.
So I know a lot of people have been mentioning this in the chat and that the pictures were coming out for a possible suspect for Nancy Guthrie. So just wanted to share that I just saw this pull up, that the Pima County Sheriff just released pictures of a potential suspect at Nancy Guthrie's camera the morning that she went missing. Sheriff says these images weren't accessible until now. So here we go. Just pulling the plant, I guess. There we go.
You would not disagree that on January 19, 2001, Mr. Melton spelled out Truck Customs for you during that interview?
I would agree with you on that.
Now, while detailing his day, Kris stated that Josh came to his house after he woke up on the morning of Miss Baker's death. Is that fair?
Say that one more time.
Sure. While he was detailing his day to you, he stated that Josh came to his house on the morning of Miss Baker's death.
Yes, so that's how I took it.
And Kris stated that him and Josh only work together. Is that correct?
What do you mean by only work together? It's the two of them?
They don't have any personal relationship. Is that correct?
He advised that they work together, yes.
And the address Josh came to pick up Mr. Melton was from Mr. Melton's home. Is that fair to say?
That's correct.
Okay. We've discussed that address. And they drove to a company called Nash Plumbing together. Is that
Correct.
fair? And this was in Chris's truck.
That's correct.
Kris says that they arrived at Nash Plumbing between 7:35 and 7:40. Is that right?
Yes.
Pen. Thank you. And he stated while at Nash Plumbing, they loaded up. Is that correct?
We went there to get their supplies.
Would you agree that during the course of your investigation, you were unable to speak with any supervisor that confirmed that Josh and Kris were at Nash Plumbing between 7 a.m. and 9 a.m. on January 19, 2001?
That's correct. I did not do that.
You were unable to speak with any coworkers that confirmed Josh and Kris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001.
That's correct. I was not assigned to do that.
You were unable to speak with any receptionists that could confirm that Josh and Kris were at Nash Plumbing between 7 a.m. and 9 a.m. on January 19, 2001.
That's correct.
You were unable to speak with any eyewitnesses that confirmed Josh and Kris were at Nash Plumbing between the hours of 7 a.m. and 9 a.m. on January 19, 2001.
That's correct.
You were unable to obtain any sign-in logs or visitor logs confirming their presence at Nash Plumbing at all on January 19, 2001.
You're correct.
You were unable to obtain any business records that confirmed that Kris and Josh went to Nash Plumbing on January 19, 2001.
Yes, that's correct.
Now, Kris claimed they loaded up. We've agreed on that. Is that right?
Yes, sir.
But you were unable to obtain any signed delivery or pickup receipts that supported that Kris was at Nash Plumbing on January 19, 2001. Is that right?
That's correct.
You were unable to obtain any invoices supporting that Chris Melton was at Nash Plumbing on January 19, 2001. Is that correct?
You're correct.
And although they picked up supplies, you were unable to obtain any work orders that supported that Kris was at Nash Plumbing anytime on January 19, 2001.
That's correct.
Now, in regards to Kris and Josh saying they worked together, Kris told you that Josh was his employee. Is that fair to say?
Yes.
Okay. You were not able to obtain any payroll stubs to confirm that they were employed together, were you?
Yes, sir. I was not assigned to do that.
Is that a no?
Yes, it's a no.
You did not collect any W-2s or 1099s confirming their employment together?
I did not.
Mr. Melton didn't even provide you with an employment contract showing that those two worked together?
No, he did not.
Did you obtain any work-related emails between the two?
No.
And I know it was 2001, but you didn't collect any work-related text messages between Josh and Kris,
Yes, sir.
correct? You were unable to interview any third-party co-workers that confirmed that Kris and Josh worked together. Is that correct?
That's correct.
And Chris's father was with Kris during the January 19th interview. Is that right?
He was.
And during that interview, not even Chris's father confirmed that Josh and Kris worked together. Is that correct?
No, he was not asked to.
So we simply took Chris Melton's word for it.
At that point of the interview, that's what I did. Other folks were assigned to follow up on those things.
Yes, sir. Now, during your interview with Kris, he told you that his home and Josh's home was less than one mile apart. Is that correct?
I don't know if he gave me a direct. He did say they lived near each other,
Okay.
if I recall that correctly.
Do you recall Kris stating, drove back to their house, talked to let Josh off, that little guy. He lives like a mile from me. Do you remember?
Yes, sir.
And obviously, Kris knew where Josh lived. Josh knew where Kris lived. Is that fair?
Yes, sir.
Okay. And Detective Ricketts, you personally never investigated whether Josh and Kris were personal friends. Is that right?
I did not.
Now, Kris stated after going to Nash Plumbing, he went to Truck Customs. Is that fair?
Yes. If you'd like to refer my notes, but yes, that would be the second location.
Justin. Yes, right, Ricketts at the bottom. And you go to the next picture and start on the top.
And again, I really want to emphasize that with a cold case where somebody's a new suspect decades later, like they are not a suspect before the case goes cold. For that type of new suspect, that new suspect never would have had this opportunity to say, hey, here's my bank receipts. Here I am on a surveillance video. Here I am making phone calls with people. Here's a picture of us at this place that we all went to at this time. I saved this picture on purpose because I was looked at. And even though they moved on and didn't try to prosecute me in 2001, let me specifically hold on to this thing in case they ever try to circle back around and make this a case 20 years later, right? someone that's in Faust's position never had the contemporaneous awareness to, 1, go and seek these things, 2, collect these things, 3, report it to somebody who was investigating to say, hey, look, I have an alibi, and 4, be able to keep it on hand in case this came to trial 20 years later.
Question for you, Detective Ricketts. Have you met with the state in this case?
I have.
Did you take notes of your meeting with the state?
I did not.
And then we'll go to the next page. All right, Detective Ricketts, what we're going to do for purposes of the record, I have a whiteboard here. We're going to write your name at the top, okay?
All right.
And we're going to discuss the information that you were given. Is that fair? All right, so Ricketts at the top. Two T's. You write it big. All right. And put an underline here. And we're going to write Kris. We're going to write Josh. All right. Then a line down. And then write Kris here. Write Josh there. Thank you for your patience.
No worries.
All right, so we're going to write, and you let me know if this is accurate. Very first place Kris says is Nash Plumbing. Is that correct?
Yeah, on the 19th?
Correct.
Yes.
All right, can you write Nash Plumbing here under Kris?
And for purpose of this, you may want to put the 19th on there because on the 21st, he added a location. So I don't know if you want to differentiate that or not.
So the first place is Nash Plumbing.
Yes, sir.
Okay. All right, put a hyphen at the Nash Plumbing. And Nash Plumbing was unconfirmed. Is that right?
By me, yes, sir.
Okay, and put unconfirmed.
By me. Yeah, I have a hard time thinking Nash Plumbing is actually confirmed by anybody besides McCurdy and Melton themselves, if Cruz has continuously asked about it. He's looked at the case file.
All right, after Nash Plumbing, he stated that he went to Truck Customs. Is that correct?
Yes, Truck Customs is number 2. Yes, sir.
Truck Customs. And he stated that they went to Truck Customs at 9:30 a.m. or earlier.
May I refer to these?
Absolutely. And Detective Ricketts, to be fair, you can use the 19th or the 21st, whichever one you would like to use as far as the
He
time.
said around 9:30. Yes, sir.
So put 9:30. And I want to emphasize this language. He didn't say 9:30 or later. He said 9:30 or earlier. Is that right? And it's page 1 of 2.
He says or maybe earlier. Yes, sir. You're correct.
Or earlier. Now, after leaving Truck Customs, Kris advised that him and Josh went to a home in Grayson. Is that correct?
Yes, that's correct.
And forgive me, we skipped something. He eventually tells you that he went to the bank, right?
Yes, sir.
Just put the bank right there. Bank right here. Did you speak with anyone other than Josh to confirm that Kris was in Grayson, Georgia on the day of Ms. Baker's murder?
I did not.
Did Kris provide any documentation confirming that he worked on or went to a home in Grayson, Georgia on the day of Ms. Baker's murder?
To me, no.
Okay. So just for you, we just took his word for it. Is that right?
For this on the day of, yes, it's preliminary, and then Sunday the same.
Yes, sir.
Why did you even need to explain that? So you just took his word. On that day, yeah, and also the other day, yeah.
Grayson, Georgia, after truck customs.
Oh.
Now, excluding Grayson, we could safely say that Ms. Baker was killed between 7 a.m. and 11:32 a.m. Is that a fair window? And I can ask it a different way. At 11:32 a.m., the fire was reported. Would you agree with that?
Fire was reported at
11:22.
I don't have notes on this, but at 9:00 whatever, the clock on her wall no longer worked.
Okay, perfect. That's fine. We could say 7 to 9, whatever. So
9:32.
we'll say 7 a.m. to 9 a.m. Is that
I would
fair?
be more comfortable at that time.
Okay, excellent. And you're aware at 7:45 a.m., a neighbor of Ms. Baker said they saw a white guy running through their backyard away from Ms. Baker's home. Is that correct?
Yes, that's not in my interview,
But you are aware of that?
I heard that, yes, sir.
Okay. So it's safe to say that if that person was the murderer of Ms. Baker, it's safe to say that the murder occurred before 7:45 a.m. Is that correct?
If that's the murderer.
Correct. Is that fair to say?
Yes. Could be, yes.
So you knew that it was very important to confirm where Chris Melton, well, let me change that. It's fair to say that it would be very important to confirm Mr. Melton's whereabouts before 9 a.m. Is that fair?
Yes.
And for his alibi, he says, I start my day at my parents' house. Is that fair? And between, because this is a specific time, he says between 7:35 and 7:40, right? At Nash Plumbing, is that correct?
7:30 to 7:45.
Okay. So based on what he told you, he's saying I'm either at Nash Plumbing or I'm at Truck Customs. Is that right? 9:30 or earlier. Is that correct?
Yes.
So after speaking with Kris, ACCPD's job becomes confirming Chris's alibi. Would you agree?
Yes.
Because if his alibi is false, would you agree that would suggest consciousness of guilt? Is that fair to say? Let me rephrase it.
Yeah,
let me rephrase it in a better manner. If Chris Melton lied about his alibi, that would be significant in your investigation. Is that fair to say?
Yes.
Okay. Now, we can agree that you actually took the next steps to trying to confirm Chris Melton's alibi. Is that fair?
Yes, I was part of that, but there were other detectives doing that also.
Yes, sir. You spoke with Josh McCurdy. Is that correct?
Yes.
You spoke with Mr. Bill Teeter. Is that right?
I did over the phone.
Okay. And you spoke with Josh McCurdy not on the 19th, but the next day, January 20th.
That's correct.
And it goes without saying, but it's the day after Miss Baker's death.
That's correct.
Now, Josh also told you they started their day at Nash Plumbing. Is that correct?
Yes.
Okay. And you'll put Nash Plumbing here. And we've agreed that Nash Plumbing was unconfirmed.
From me, yes.
And if you'll put unconfirmed next to Nash Plumbing. Then after leaving Nash Plumbing, Josh says we go to Chick-fil-A for breakfast. Is that fair?
Yes, Josh brought Chick-fil-A up.
Say that one more time.
Josh brought Chick-fil-A up.
Thank you. And if we could write Chick-fil-A under Nash Plumbing. And then Josh says at around 8 a.m., they went to a house in Grayson to check for leaks.
Yes, he gave 8 a.m. checking for leaks.
Okay.
Said behind the fire department on Georgia 20.
And I think we've already agreed Grayson, Georgia is unconfirmed for Kris. Is that right?
From me, yes.
If you put unconfirmed there. And then Grayson, Georgia here, unconfirmed. Or Grayson, Georgia, 8 a.m. And then Josh says from Grayson, they go to Forsyth.
That's correct.
And did you confirm that Josh or Chris Melton were at Forsyth?
I did not.
Okay. Now, they did provide you with the name of Truck Customs. I believe he may have even provided you with the address to Truck Customs. Is that correct?
He may not have advised me of it, but we did get the address for Truck Customs.
Perfect. But he didn't provide you with the names of anybody he spoke with in Grayson, did he?
Grayson, no. I don't know if he did with other detectives, but he did not with me. That's not what sure.
So Grayson is unconfirmed, Chick-fil-A is unconfirmed. Is that fair?
That's correct.
Okay. You put unconfirmed there.
That
Grayson is unconfirmed, Chick-fil-A is unconfirmed.
just by me, so you got my name on it. So yes, sir, that's correct.
Correct. So you'd agree between 7 a.m. and 9 a.m., both Kris is unaccounted for by you and Josh is unaccounted for by you.
I have both their statements given at different times that corroborate where the other one was. So in this preliminary part of the investigation, we had a general idea of where they were, and that's what we were going with at that time.
Well,
you were the only one that talked to them at this time, and then you said the rest was assigned to somebody else later.
When it comes to murder, aggravated assault, aggravated sodomy,
oh, Lord,
we want to have facts. Is that fair to say?
Correct. And in this early stage, the 19th, 20th, 21st, we're trying to get information on three. So a lot of times when you're taking these cases in this first, you'll get somebody says this, as Kris did. He left information out on Wachovia remembered it. Now, people forget things like that all the time. You've got Josh's, and then you interview these other ones.
Yeah, he told you about Wachovia on Sunday the 21st, and then on Monday he's going and asking for a personal loan for 30 to 35 minutes.
And all you're doing is taking and aligning their timeline. During that first 3 days, that's what we were doing, is just aligning that timeline and getting the stories where everybody was, and then getting DNA, fingerprints, and things of that nature in order to work the case to push on to the crime lab.
Correct. So I ask you this. At that time, you were a law enforcement officer. Is that right?
That's correct.
And your job was to protect this community. Is that correct?
Yes, sir.
So as we talk today, why are you defending Chris Melton?
I'm defending the information that I gathered on the 19th, 20th, and the 21st.
But you're not defending it. You're saying nothing was verified by you. So how are you defending something that you say was passed along to everybody else? Lord.
But wouldn't it be an issue if Chris Melton says that they went to Grayson after 9:30 and Josh McCurdy says that they went to Grayson at 8 a.m.?
Yes, but from the Wachovia video and whatever else, we've got that stamp at 9:08.
You're aware of the Wachovia videos, is that right?
Yes, sir.
Okay, but our timeline is 7 a.m. to 9 a.m. 9:08 is outside of our murder timeline. We're saying 7 a.m. to 9 a.m. Josh and Kris are unaccounted for. Is that fair?
Well, yes, if you want to say it that way, but to be in the Chick-fil-A is right next door to that also.
But you didn't verify that he went.
To be in that area in under an hour and 15 minutes from Fawn Road in Athens on morning rush on a Friday, it's going to be very difficult to do.
My question again, why are we defending Chris Melton?
Again, I'm defending what we were doing in these first 3 days of this investigation.
But Detective Ricketts, you've told us that Chris's parents' home is only 40 miles away from Miss Baker's home. And you've already said that January 19, 2001 was 9,000 days ago. How do you know what the traffic was like, Detective Ricketts?
The route that we're going to their house, I drive a good bit, but I'll just say you're going to do it in an hour. During that time frame, someone from Athens, Clark County, I'm not sure who did that drive. It's going to take you approximately that amount of time. Now
we're just hypothesizing.
Again, not defending Kris, I'm explaining to you how investigations in those early 72 hours are done with trying to line up those statements.
Copy of this redacted. Okay. Course indulgence. And I just want to make sure I understand your testimony. Your testimony is it takes an hour to get from Mr. Melton's parents' home to Miss Baker's home?
Yes, with traffic, I'm saying yes.
Well,
hold on. Only with a qualifier.
Let's be clear.
So when I Google mapped it just a minute ago for you on the record, it said 1 hour and 4 minutes to do that 40 miles. So that was at 9:30, 10 o'clock in the morning past rush hour.
But you would agree in 2001, Athens wasn't the city it is now, right?
Judge, I would ask Detective Ricketts was in the middle of an answer. Mr. Cruz cut him off with his
He
next
wasn't still
question.
answering.
I'd ask Detective Ricketts to be able to finish his response.
I'm going to allow him to finish his response, and then you may question.
Sure.
Is there anything you wanted to add? You may-
No, I was just going off the recollection of what I pulled up at 10:30 in the morning on Google for right now. And yes, I'm sure traffic was different in 2001.
Well, let's talk about this. It's 10:30. If, and we've already discussed this, if the person seen running committed this crime, he would have been traveling before 7:45. Is that fair?
Okay, yes, sir.
Okay. And he could have been traveling, we don't know, at 6:45 a.m. Is that right?
I don't know.
Okay. But you do know, as you just told this jury, that at 10:30 on February 10th, 2026, it's an hour and 4-minute drive.
Yes, sir. Only because you asked me to look it up.
Sure.
That's the only reason I know
But
that.
that's irrelevant to our conversation about January 19th, 2001. Is that fair to say?
Okay.
Is that fair to say? Would you?
Yes, sir. That'll be fine.
All right.
Now, we have a discrepancy in the alibis, right? We have Josh saying Chick-fil-A. We have Mr. Melton not saying Chick-fil-A. Is that fair?
Yes, sir. They're both saying that. One saying Chick-fil-A, one saying that.
Okay. One saying what?
One saying Chick-fil-A and one saying the Wachovia Bank.
So you're saying the bank and Wachovia are next to each other?
They're close.
So how do we explain Josh saying Chick-fil-A before 8 a.m. and Kris saying Chick-fil-A after 9 a.m.?
Say that again.
Sure. Your testimony was that the Wachovia is right next to the bank. Is that fair?
Yes, they're close together.
And you just made the statement that Josh said Chick-fil-A, Kris said bank. Is that fair?
Yes,
Okay. Josh said Chick-fil-A before 8 a.m. Is that correct?
he did.
Okay.
Josh
Kris
was
says
with Kris
bank
that morning.
after 9 a.m. Is that correct?
Yes.
Okay. So that's a discrepancy. Is that fair?
Or both things could be true. They could have gone by that Chick-fil-A and then gone back to the bank. The bank doesn't open until 9.
So my question is this: why are you defending Chris Melton?
I'm not. You're asking for information, and I'm trying to give it to you from the 72 hours that we were working the very first. Now, in this, from the 19th, 20th, and 21st, not even working this case, I believe we did 20-some odd. I did 20-some odd interviews during that time. Typically, this is what happens during those first 72 hours, is just trying to get timelines. And then over time, you start pulling those timelines together.
Do you
Over
know if
time.
Mr. Faust got that courtesy?
No, he did not.
I don't work here anymore, sir, so I don't.
But we can agree that Chris Melton got
He is literally doing the I'm only here so I don't get fined.
that courtesy.
I don't think Chris Melton got the courtesy. I think we worked the case.
Well, officer, we just talked about this. You said that you explained that the reason Josh said Chick-fil-A and Kris said the bank, you said two things could be true at once. You were saying they could have went, and this is your testimony, they could have went to, I guess, to Chick-fil-A by the bank first, and then after 9 a.m. went back to the bank. That was your testimony. Is that right?
Yeah, when we're looking at this during this time frame, so when you take somebody who's been involved in a crime or whatever else, and they've been a victim of a crime, and they're giving witness statements, things are recalled the next day or so. He forgot Wachovia, which is a timestamp thing. Don't know why he forgot that until Sunday. Don't know. Normal people, through the course of doing investigations for almost 35 years, do not walk through and timestamp their day. They can give you approximates and say this and that. The majority of people I've interviewed for homicides, whatever else, and not saying at the bank I was at 9:08, whatever else. Now, I understand what you're saying. This was a timeline in 3 days where we're trying to put people where they're supposed to be, and I'm testifying to those 3 days of what I did on those. And some of it, like I've told you, I didn't do those interviews, so I cannot answer that for you.
Sure.
We're trying to put people in those spots and then see what evidence moves from there.
You would agree that Ms. Baker is the victim in this case?
100%.
Since January 19, 2001, Ms. Baker was the victim. Is that correct?
100%.
And her family were victims. Is that correct?
100%.
And ACCPD's job as law enforcement officers are to make sure the victims are taken care of. Is that right?
Yes.
And yet
And
Cruz
to
is the
solve
one
those crimes,
advocating.
correct?
Yes.
And when questions pop up as a law enforcement officer, your job is to answer those questions. Is that right?
Yes, sir.
Your job is not to explain away those questions. Would you agree?
I'm not. I'm explaining away 72 hours.
I'm not saying my specific question is your job is not to explain away those questions. I'm not speaking.
I'm sorry. I took it as you were implying, but no, it's not. I agree with you.
Now, on January 20th, 2001, you spoke with Mr. Bill Teeter. Is that correct?
Yes, sir, over the phone.
And Bill Teeter is the gentleman that worked at Truck Customs.
Yes, sir.
Okay. You had no reason to believe whatsoever that Mr. Teeter and Mr. Melton were personal friends.
At that time, no. On the 21st, no.
Okay. And based on your interaction with Mr. Teeter, you understand that Chris Melton's relationship with Mr. Teeter was solely as a customer.
At that time, yes, sir.
And you would agree that gives Mr. Teeter a certain type of credibility, right?
Yes.
He would have no reason to lie for Chris Melton. Is that fair?
Yes.
Okay. He would have no reason to try to cover up for Chris Melton. Is that fair?
That's correct.
Okay. And Mr. Teeter told you that Chris came to his shop around 10 a.m. Is that right?
Yes, sir. I believe that's correct.
Cross here. Put Teeter in that box. So we could say that Chris's trip to Truck Customs was confirmed. Is that fair?
Yes, sir. He said Chris had to come by there once in the morning around 10 a.m. The only appointment Chris had that day was for 4 o'clock. The initial appointment in the morning, the reason he said if
10 a.m.
on the tape
To drop off the truck.
is it was just to show up for a measurement, and that was a stop-in. They measure the compartment or whatever else, and then they go, and then would come back for that appointment later in the day.
Okay.
But the appointment was for 4 o'clock.
So we've confirmed around 10 a.m., correct? But we still have not confirmed that window between 7 a.m. and 9 a.m. Is that fair?
Yes, sir.
So based on what Mr. Teeter told you, it is fair to say when Chris Melton told you that he went to Truck Customs at 9:30 or earlier, that was not true. Is that correct?
His timeline was off on that one because Truck Customs,
Just
if
on
he'd
that
have left the
one.
Wachovia to go there, he would have been there right around 10.
Detective, why are you
If you
defending
can
Chris
answer this
Melton?
question.
Sure.
Do you feel the need to explain for Chris Melton?
Again, you're asking about a timeline,
Sure.
and I'm trying to explain to you from where that Wachovia was to Truck Customs is not a very far.
Well, this was my question. My question
very
was,
far.
and I'll ask it a different way. Chris said he was at Truck Customs from 9:30 or earlier. Do you agree?
That's what he said, yes, sir.
Okay. Bill Teeter said that he was at Truck Customs around 10 a.m.
That's correct.
Okay. And you would agree this is significant because once you told Chris Melton that you talked to Bill Teeter, he changed the time that he was at Truck Customs to 11 to 12:30 a.m. Is that fair to say?
The second interview is when he mentioned that he went to Wachovia.
Officer, we're talking about Truck Customs.
Yes.
Okay.
So, and that's why I believe his timeline just slid just a little bit, but that was a timeline from 9:30 to 10:30.
Did Mr.
Is it acceptable for a timeline to slide just a little bit when you're dealing with the day of the crime and you have no other certain evidence about when the crime was committed? You just have this broad window that's still a fact in dispute. The timeline is still in dispute. Both parties seem to agree it was early morning, but state is leaning more towards like 8:30 to 9:15 window. And defense is leaning slightly earlier than that.
Mr. Faust get the same courtesy from law enforcement to
Just a
explain any discrepancies he may have had?
Judge, I'm going to object to the form of the question as being argumentative as well as lack of personal knowledge. As Detective Ricketts has already said, he never worked the case at the point that Mr. Faust entered it.
I will withdraw the question, Your Honor.
I'm going to sustain that objection.
Yes, ma'am. But after you told Mr. Melton that you talked to Mr. Teeter, Chris Melton then changed his time to somewhere between 11 a.m. and 12:30 a.m. Is that correct?
I don't know if I told Chris that I talked to Bill or not. I cannot testify to that. Chris told us about that, though, the evening he came in and brought up Wachovia, which in a normal investigation, somebody bringing something else up they did that day is not that far out of the realm of possibility.
Okay. So this is possibility here. You say this would be normal for Mr. Melton?
Yes, sir.
Okay. On the morning that Miss Tara Baker was killed, this is normal.
What do you mean by normal?
Sure. You said this is not outside the realm of possibility.
I'm talking generalized in an investigation when somebody comes back in with a time. Like I said before, people don't roll through their day now pretty much with time stamping, especially in 2001. With phones and everything we have now,
Timestamps don't matter in 2001. They were a little bit dicey.
you can timestamp pretty stinking well. I'm just saying that's along the realm of that kind of ballpark window that we're looking for just to keep things for that initial 72 hours.
Well, I would like to talk about police. Police, they live in timestamps. Is that correct?
Yes, sir.
Okay, police, they confirm. If you say you went somewhere, a police officer's job is to confirm it, correct?
That's correct.
Because you got to give answers to the community. Is that fair?
Yes, sir.
And you have to give answers to the family. Is that right?
That's correct.
And if the family asks you, where was Chris Melton at 8 a.m., an appropriate answer isn't, well, in the general realm of possibilities, he could have been anywhere between these places. Is that fair to say?
I understand what you're saying, and yes, that is fair to say. And in that first 72 hours, we're putting in on the timestamps of what's happening in that first 72 hours.
Yes, sir. Would you have any reason to disagree with me in the multiple interviews you conducted with Chris Melton? He has never stated that he went to Chick-fil-A.
No, sir, he is not to me. And again, he may have to some other investigators after that, but not to me.
Sure. And we've already agreed that you never personally confirmed that Josh went to Chick-fil-A, right? That's unconfirmed.
By me, yes, sir.
And we've agreed that you talked to Chris the second time on January 21st, 2001. Is that right? Now, his parents were present. Well, his father was present at the interview. Is that fair?
Yes, they drove him there. But at the interview, I believe it's just Detective Newton and myself.
Now, during your interview with Josh, Josh told you that he had worked with Chris for a year. Do you recall Josh making that statement?
Yes, sir.
However, Chris told you that he had only met Josh in December of 2020. Is that fair? I'm sorry, December of 2000. Please forgive me.
I understand that. I've done that a lot lately. I don't know. Is that in my notes?
It's in the recording.
That's a good possibility, then. I won't argue that with you.
You didn't verify that they knew each other before that.
December 2000 was just a month from Miss Baker's death. Is that fair to say?
Yes, sir.
Okay. And if you can, write Chris 1 month, Josh 1 year. And this is a very important area for us, officer, because I do think you did. I think you did the best you could with the facts that you were given under the circumstances. So I do want to say that, and I do appreciate your service tremendously. Okay.
Okay.
But I do want to ask you about the interview on January 21st, 2001, in regards to Chris's statement about going to Wachovia Bank. Okay.
Okay.
Now, he told you that he was in the bank on Friday, January 19th for 35 minutes. Is that correct? And that would be on the recorded interview if you don't
He
see
said he's in the bank for around 30 minutes. That's just what I typed in my notes.
Would you have any reason to disagree that he specifically said 35 minutes?
I put 30 in my notes, but 35 won't be a...
Would you like to hear the audio recording?
No, sir, I'm fine.
And if that's true, that Chris Melton spent 35 minutes in the bank on Friday, January 19th, you would agree that it's not an insignificant amount of time to spend in the bank. Is that right?
No, sir.
Okay. However, Josh never mentions going to the bank for 35 minutes with Chris, does he?
He does not.
In fact, he never mentions the bank at all. Is that right?
He does not.
Yeah, I don't think they were together.
Now, we've agreed that Chris' father was with him on the January 19th and January 21st interview. Is that fair?
Yes, sir. I don't believe he sat in on the 21st. He did sit in on the 19th.
Okay, so we'll discuss the 19th. Chris's father never agreed with the statement that Chris left his home between 7 a.m. and 8 a.m. on January 19th while he was present in an interview with you.
Yes, sir, not in that interview.
And during the weekend of January 19th, 2001, you did not speak with Mr. Melton's mother. Is that correct?
I did not.
Now, Dad knows that Tara has passed away. Mr. Melton's dad, is that right?
Correct.
Okay. Dad knows that Mr. Melton's son has conducted an interview with law enforcement. Is that fair to say?
That's correct.
But Mom never calls you, Mr. Melton's mom, she never calls you and says, hey, Detective Ricketts, Kris was here with me that morning of Tara's death. Is that right?
No, sir, I did not do that.
Kris's parents don't reach out to law enforcement at all. Is that correct?
Except for coming to the police department twice voluntarily.
With Kris. Is that right? Only Josh and Kris are the only two people that stated that they left Chris Melton's parents' home around 7:15 a.m. Is that correct?
Yes.
And as of January 21st, 2001, with your involvement in the investigation, besides Josh, there were no other witnesses or documents confirming where Mr. Melton was between 7 a.m. and 9 a.m. on January 19, 2001.
Past the 21st, I cannot answer that, but from the 21st backwards, that's correct.
And I believe you mentioned this on direct. You told Kris that Tara was probably sexually assaulted. Do you recall telling Kris that?
I did.
Okay. And when you told Kris that, he didn't start crying, did he?
No, sir.
Okay. Kris didn't become upset, did he?
No, sir.
Kris didn't say, I need a moment to myself. Is that fair?
No, numerous times during the interview he stopped, but no, sir, he did not.
Okay. And Kris didn't say, I hope you find who did this before I do. Is that correct?
Not on the 19th. Mentioned it on the 21st while we were at the jail at the jail at the phlebotomist, getting blood work done there. Just a statement he made in the hallway, but yes, sir, not during an interview or anything of that nature.
Can you show us that statement in your
It's
notes?
not in there, sir.
Okay. And we've already agreed that January 19th was over 9,000 days ago.
100%.
But Kris did ask you about the evidence in the case. Is that fair to say? And specifically, Detective Ricketts, Kris asked in response to you telling Kris that Tara was sexually assaulted, did you find some stuff on her like semen? Do you recall Kris asking that question in response to you telling him that Ms. Baker had been sexually assaulted?
Yes, sir.
Did you find that odd that his response was about asking questions about the evidence?
No, for a couple reasons of sexual assaults, and one of the reasons John Newton and some of those folks were brought in for the sexual assault is if he's not sure she's been raped. Sometimes people wander down that road of how do you know that this person was sexually assaulted?
So can I ask you this before you finish? So it's normal to tell someone that's engaged or preparing to be engaged to another person that the love of their life has been sexually assaulted, and before they say anything.
Back to the form of the question as being argumentative, Judge, I'd also ask that the witness be allowed to finish the answer they were giving before they were interrupted by Mr. Cruz.
I think that is correct, actually. I'm going to sustain the objection. It is argumentative.
Yes, ma'am.
And if this witness chooses to finish his statement, he may. Otherwise, you may continue.
I withdraw the question.
Okay, yes, sir.
We've established that Chris Melton was in his vehicle on January 19, 2001. Is that correct?
At the police department?
No, the morning of January 19, 2001.
Yes, sir.
You would agree that you did not search Chris Melton's vehicle for the presence of Miss Baker?
Oh, how far back, Chuck? Okay, wait, let's see. Let's watch here. Maybe this was it?
1,000 days ago.
100%.
But Kris did ask you about the evidence in the case. Is that fair to say? And specifically, Detective Ricketts, Kris asked in response to you telling Kris that Tara was sexually assaulted, did you find some stuff on her like semen? Do you recall Kris asking that question in response to you telling him that Ms. Baker had been sexually assaulted?
Yes, sir.
Did you find that odd that his response was about asking questions about the evidence?
No, for a couple reasons of sexual assaults, and one of the reasons John Newton and some of those folks were brought in for the sexual assault is if he's not sure she's been raped. Sometimes people wander down that road of how do you know that this person was sexually assaulted?
So can I ask you this before you finish? So it's normal to tell someone that's engaged or preparing to be engaged to another person that the the love of their life has been sexually assaulted, and before they say anything,
Back to the form of the question as being argumentative, Judge, I'd also ask that the witness be allowed to finish the answer they were giving before they were interrupted by Mr. Cruz.
I think that is correct, actually. I'm going to sustain the objection. It is argumentative.
yes, ma'am.
And if this witness chooses to finish his statement, he may. Otherwise, you may continue.
I withdraw the question.
Okay, yes, sir.
We've established that Chris Melton was in his vehicle on January 19, 2001. Is that correct?
At the police department?
No, the morning of January 19, 2001.
Yes, sir.
You would agree that you did not search Chris Melton's vehicle for the presence of Miss Baker's blood. Is that correct?
No, sir. From the 19th to the 21st, I did not.
Okay. Well, any other time past the 21st?
I did not. No, sir.
Would you agree that it's important to search a vehicle in a murder case? If it requires travel, let me add that. If the murder would require travel, you would agree that it's important to check the vehicle.
If you had a viable suspect at that time, then yes.
And Chris Melton was not a viable suspect at that time?
That time, through everything we were getting was coming voluntarily, timeline was coming together. So at that time, by the 21st, he was not.
Well, what choice did he have, officer? Because you stated if he didn't agree to blood, you would have got a warrant.
Did not tell him that.
But it's true, right?
100% I would have. That was part of the interview when I started with him. At the very beginning of the tape, I make it very clear to Mr. Melton that he's there voluntarily and giving me a free and open statement. Because going into that interview, I don't know if he's a suspect or I don't know if he's a boyfriend of a victim. So as you start going down, that's what these 3 days are for, is to try to figure out what that person is and then what do I need to get to prosecute this.
Okay. So my question, my specific question to you, and if you can answer it with a yes or a no, he didn't have an option but to give blood. Is that right?
He did have an option, yes. At that time, he could have told me no.
And you would have got a search warrant and still got his blood?
We wouldn't have got blood that day, but I'd had to see a judge and move forward.
Okay.
Yes.
So you would have had his blood regardless?
Yes, sir. But
Okay.
at that time, he was not told, hey, if you don't give this to me, I'm going to go get a warrant.
Sure, that's fair. And as far as coming to the police department voluntarily, were you the one that called the family and told them to come to Athens?
No. What do you mean by the family?
Sure, Miss Baker's family.
Oh, no, sir.
Okay, but you are aware that officers called them and told them to come to Athens. Is that correct?
I would 100% believe that, yes, sir.
Okay. But to your knowledge, no one called Chris and told Chris to come to Athens. Is that fair?
Well, Chris was paged by Miss Baker.
Law enforcement. We're talking about law enforcement.
Well, that's not the question he asked, Judge, and I think the witness is entitled to answer the question that he was asked.
You're going to allow him to answer.
Well, I withdraw the question, Your Honor. I withdraw that question. Did law enforcement call Chris Melton to come to Athens?
To my knowledge, no.
So he voluntarily went to Athens the day that he found out that his girlfriend was murdered?
Yes.
Okay. And you all asked Chris Melton to identify the body. Is that correct?
Lieutenant Durham, I believe, is the person who did that. I can't testify to who asked him, but yes, he was asked to identify the body.
That's fair. And Chris Melton, you stated that he didn't appear with a lawyer. Is that right?
He did not.
Okay. If he appeared with a lawyer, that would have looked a bit suspicious to you?
It would have been way out of the norm.
So if Chris is trying to avoid looking suspicious, the best thing to do is to appear voluntarily. Is that correct?
I don't believe so.
Now, you talked about the injuries to Chris Melton's hands taken on January 21st, 2001.
Yes, sir.
Okay. And Chris told you that those injuries came from punching a wall.
Yes, sir.
Okay. We would agree that that is drywall in that picture. Is that right?
It is.
Okay. We would agree that injuries to Mr. Melton's hands look like scratches. Is that correct?
Looked like abrasions would be what I'd call them. Abrasions.
Okay. Help me, what's the difference between abrasions and scratches?
Abrasions is usually when you hit something and it slides, it's open. A scratch is usually a line or whatever else, and abrasion is usually wider open. So if you look at the picture, there's more of an abrasion, a hit, that kind of thing.
Sure. Your Honor, can we turn on the projector?
Okay.
All right, we're getting the projector.
Everything's in hands?
Yes, sir.
So
Chris
you
has got
say this
hands
is
on
an
the screen.
abrasion from punching a wall on the inside of his
Look over,
thumb?
I don't have a pointer, but if you look over to the index finger, all right,
Nope, we're talking about the thumb.
the ring finger and the next finger over it, that's what I'm calling abrasions right there. There's some other stuff on there that are nicks, scratches, things of that nature, but that's what I mean by abrasions, just that larger hit of something of that nature.
And this is my follow-up question. Did you confirm that Mr. Melton, well, let me say this. Mr. Melton told you on the 21st that he punched the wall. Is that right?
Can we just rewatch? Like, we are doing gymnastics.
Suspicious. The best thing to do is to appear voluntarily. Is that correct?
I don't believe so.
Now, you talked about the injuries to Chris Melton's hands taken on January 21st, 2001.
Yes, sir.
Okay. And Chris told you that those injuries came from punching a wall.
Yes, sir.
Okay. We would agree that that is drywall in that picture. Is that right?
It is.
Okay. We would agree that injuries to Mr. Melton's hands look like scratches. Is that correct?
Looked like abrasions would be what I'd call them.
He didn't say there are also some abrasions.
Abrasions.
Okay. Help me, what's the difference between abrasions and scratches?
Abrasions usually when you hit something and it slides, it's open. A scratch is usually a line or whatever else, and abrasion is usually wider open. So if you look at the picture, there's more of an abrasion, a hit, that kind of thing.
Sure. Your Honor, can we turn on the projector?
Okay.
Is that an accurate depiction of Mr. Melton's hands?
Yes, sir.
So you say this is an abrasion from punching a wall on the inside of his thumb?
I don't have a pointer, but if you look over to the index finger, all right, hold on. The ring finger and the next finger over it, that's what I'm calling abrasions right there. There's some other stuff on there that are nicks, scratches, things of that nature, but that's what I mean by abrasions, just that larger hit of something of that nature.
And this is my follow-up question.
I don't know. If you punch something, this area would be messed up. Like swollen. Swollen. I don't really see swelling here either. But like, I'm very confused how we don't have swelling here.
Did you confirm that Mr. Melton, well, let me say this. Mr. Melton told you on the 21st that he punched the wall. Is that right?
That's correct.
You all didn't take pictures of the wall until 2 days later. Is that correct?
I believe it's the 23rd when I went over there.
Correct. Did you confirm with anyone else that Chris Melton punched the wall and that's where those injuries came from?
I did not, but I believe somebody talked to his roommate in one of the reports.
Well, he stated that his roommate wasn't present when it occurred, officer.
The only other person that would have been in the house is just the two of them then.
So you don't know if they talked to the roommate, is what you're saying?
No, I'm saying somebody else did, but I did not talk to that roommate.
Now, on January 23rd and 24th, 2001, you obtained a hair sample from Chris Melton. Is that correct?
Yes, sir. I believe that's correct.
And this was done with Detective Newton?
Yes, sir.
Do you recall requesting and obtaining a court order for phone number 678-725-4136?
I believe that was the 24th that I did the hair samples. Is that correct? Before I think I said yes, but I want to make sure I'm on the same page with
That is correct. I have the 23rd and 24th.
Okay, the 24th. I have the 23rd, 24th written in there, but I just want to make sure that's the date you're talking about.
That is fair.
What you're looking at?
No, sir, just my notes.
Okay. Yes, sir, we did do hair samples on those days.
Okay. And you also obtained a court order for phone number 678-725-4136. Is that correct?
If I signed for it, then yes, sir, I did. I don't have a signed copy of that with me.
Would you like to see it?
Yes, sir.
So Bailey's asking in the chat, there was DNA under her nails. I already forgot, or did they even check? So they did have fingernail clippings. They detected that blood was present, but they didn't do further testing because they needed to preserve, this is the reasoning, they needed to preserve the small quantity for DNA testing. And I don't know if we're going to hear more about that from True Allele. But from what that witness told, I think that was Corsi. She said that the DNA testing under the nails was only a match for Tara Baker. Which could just be if she was stabbed in the neck and was like this.
After this, can we take a break just in case the jurors need to use the bathroom?
And just let you keep going, Mr. Cruz.
Put those in order for me, please. With the stickers together. Thank you. All right, is it okay if I approach you and show you the court order?
Yes, sir, please.
You're welcome.
So I want to call out here, Bob Wright earlier in the chat said that Tara Baker would never sleep with Faust. And then said all evidence points to Faust. Making a claim that somebody would never sleep with somebody, one, it's kind of irrelevant here. I mean, I know one of the charges is rape, but that's the state's burden to prove that. But two, the DNA evidence that we have is not from sperm. There was no sperm found. So the DNA that may or may not have been found on Faust, I think we're going to hear some dispute on that, the integrity of the DNA testing, isn't even from sperm. So to come in and base your opinion on a preconceived notion that Faust must be guilty because there's no way that somebody like Tara Baker would encounter or be around somebody like Edrick Faust, I can only say is based inherently in prejudice and racism. Because there are no facts in this case that have demonstrated that Tara would not associate or be near or be in the same room with somebody like Edrick Faust. So to say the two comments that you said back to back are very disjointed. Your perception, there is nothing factual to base it on. And your perception is not evidence. And for what it's worth, Bob is not the first person I've seen make this comment that, well, I don't see any evidence showing that Tara would even be around somebody like Faust. First of all, that's not the burden. That's not what this case is about. But secondly, why do you hold those beliefs? Why do you hold those beliefs? So. Yeah, and there is actually evidence she wasn't racist.
Yes, that's my signature.
And that number was for, excuse me, you recognize that document, you recognize that court order?
I do recognize the court order and my signature, yes, sir.
Okay. And the 678-725-4136 number belonged to Mr. Melton's cell phone, is that correct?
From my recollection, I believe so. I can look back at my notes, but I think that's what he gave me.
And I believe it's listed in the court order itself, officer.
Yes, sir, but I want to make sure that's the same number he gave me at the interview. Is that
Understood,
what I'm saying?
understood. I do.
Hang on one second. But I believe you're correct. You okay? I believe that's his next deal, yes, sir.
Okay, excellent. I'm waiting on the state to review some documents I gave them. May I approach you?
Yes, sir.
The document? Thank you.
Judge, can we approach about this briefly?
Like, geez, if you're going to come into the chat, at least, like, have a basis. Have a basis for what you're saying. Defense walked away from the bench a little early.
Do you recall the records that you received in response to the court order?
I do not recall them.
Would seeing them refresh your recollection?
It might.
May I approach you?
Yes, sir. It looks like what we used to get faxed to us when we put these things in.
Do you recognize those particular records?
I'll take your word for them. The document you showed me a minute ago was my signature for the request.
So I'd like to talk about those records, okay?
Okay.
And Your Honor, I am not tendering the records into evidence, but I would like to mark them for the purpose of the record. Is that okay?
I'm going to object, Your Honor. The witness has indicated that he doesn't have necessarily a direct memory of these records, but more importantly, as we discussed at the bench, they're not admissible in the manner to admit them at this time, and therefore they can't be testified to as far as contents from them in front of the jury.
That is correct. I'm going to sustain that objection.
Yes, ma'am.
Hey, thank you.
Sorry, I think I missed an objection. I was zoning out.
On January 21st, 2001, you spoke with a young lady by the name of Miss Laura Sherling.
This is the country concert girl.
And that's your January 22nd, 2001 report. And it's page 104, first paragraph, first sentence.
Okay, I don't have the 104 numbers. I just have some of my case reports. What was the name again you gave, sir?
Lauren Sherling.
Yes, sir.
Okay, and that interview with Miss Sherling was recorded, is that correct?
Roll.
Yes, sir.
Okay, and Miss Sherling is a former co-worker of Miss Baker?
Yes, sir.
All right. I have no other questions for you. I want to thank you so much for your patience and your time and your service to this nation. Thank you.
I think Laura Sherling's going to be a witness.
Thank you very much, sir.
Any redirect, Mr. Yalamanchili?
I do, Judge.
Gotta get that water. Also, shout out Sheriff Chuck here, gifting 10 subs, sneaking them in while I was zoning out over here. Let's get some party chucks in the chat here. I'll drop some to start it off. Good vibes only in the chat. Big thank you here to Sheriff Chuck.
Mr. Ricketts, I want to go back and talk to you about some answers that you started during cross-examination before being cut off. Mr. Cruz asked you a series of questions about whether you recall certain sporting events that occurred back in 2001, the Super Bowl, the World Series,
he already
things
said
like
he
that.
wasn't a fan.
And then you began to give an answer that talked about the differences between this horrific crime and those sporting events in your mind and your ability to recall certain facts.
Yes, sir.
How is it that the murder of Miss Baker is different than the Super Bowl or the World Series from 2000 and 2001 to you?
From the fall of 2000 to 2001, unfortunately, I worked numerous homicides and then a serial rape case, and in this case, those incidents leave a lasting impression, if that makes sense. So it's not something that you forget. Now, when you read over your reports and records, you remember it. Those small things come back, the details come back. When you start reading back through your reports, it opens up stuff, if that makes sense.
Yes, sir, it does. There was another question where you started to give an answer and Mr. Cruz cut you off and then withdrew his question. It had to do with you beginning to talk about what you would have done if you had noticed a bunch of things or a thick coating on Mr. Melton's hands. Do you mind telling the jury what you would have done?
Objection. That was drawn out on direct examination, not cross-examination. Mr. Yalamanchili asked him what he would have done if he saw items on his hand when he was fingerprinted. So I would ask, I would object to that question. That was nothing that came up.
Rephrase.
As far as what he would have done. That was direct examination.
Okay, what is your specific objection, Mr. Cruz? Mischaracterization, perhaps?
Characterization and relevance. It doesn't follow the line of cross-examination.
All right. Mr. Yalamanchili, you care to respond to the objection?
Yes, Your Honor. You know, I've got it in my notes underneath Mr. Cruz's cross. Obviously, the court will recall that in whatever way the court recalls it. But Detective Ricketts was in the process of explaining what he would have done if it were some kind of thick coating, and then Mr. Cruz stopped him in his answer.
All right, I'm going to allow it. You may continue.
All right. So, Detective Ricketts, I'm going to kind of ask you that question again. During cross-examination, Mr. Cruz stopped you in the middle of your answer as you were discussing what you would have done had you found a thick coating of things on Mr. Melton's hands. Can you explain to the jury what you would have done if you had seen that?
I'm going to overrule the objection. You may continue.
Well, number one, if it's a large amount, you can't be fingerprinted. So that would have interfered with just the fingerprinting if there was a large amount. Now, on the back of the hands or whatever else, there wasn't enough stuff on his hands to cover up anything that might have been there. You could easily see it. So if there would have been things that we would have had to take pictures, and then we'd have had to move with Lieutenant Durham and some other ways that we would have gone on from that moment on. But those were not noticed. And again, I'm literally holding his hand while I fingerprint him. I mean, my hands are holding finger by finger.
And you just admitted you see a ton of stuff on his hands. So have him clean it, because two things can't always be true, right? I know this guy keeps trying to have two things be true. You cannot say that there were no marks underneath his hand because you didn't wash his hands to check. Like, what are we doing? What are we doing?
As I flip that hand over, I'm having to hold his hand.
Also, during your testimony, after the distance from 160 Fawn Drive to Mr. Melton's parents' residence was established, you testified to a timing run that was done by ACCPD at the time. Is that correct?
Yes, sir.
And I just want to clarify that because I feel like it might have gotten lost in your testimony and questions coming in while you were talking.
Objection, Your Honor. This calls for hearsay. We explicitly did not ask him about the time stamp. We disagree with the time stamp that was given. But the reason we didn't ask that is because we know under the law that is hearsay.
All right. Any response to the objection?
Well, Judge, this is a response that was given to Mr. Cruz's question about what was done. The response is about what ACCPD did at the time. And the answer was given during Mr. Cruz's cross-examination. I'm just going back to talk about that answer. That answer wasn't objected to or asked to be struck or otherwise identified as hearsay by Mr. Cruz at the time. So it's in evidence, and I think it's an appropriate grounds for redirect examination.
Yes, sir.
I would just ask, Your Honor, I'll leave it to the discretion of the Honorable Court, but if that door is open, the reason I didn't go down the impeachment route with that line of question is because I wanted to follow the law. That isn't appropriate to bring out of a witness. That was non-responsive to my question. But if the state is allowed to go down that line of questioning, I would just ask the Honorable Court to allow us to follow up with that line as well on recross examination.
Okay. Thank you, sir. The objection was with regard to hearsay. I don't find that this question is going to elicit hearsay. I'm going to allow you to ask it. Certainly on any recross, we will address any issue that the state might object to, and we'll take it up again if we need to, but you may go ahead.
All right. And so, Detective Ricketts, what was it that you stated was the time period when ACCPD or law enforcement did a test run back in 2001?
It was over an hour with traffic. So it took them just a little bit over an hour to make that drive.
Okay. I want to talk to you just really briefly about your familiarity with some of these areas in Loganville, Grayson, Truck Customs. During your testimony, you made reference to the fact that you drive that route at least semi-frequently. I'm not asking you an address where you live, but in general terms, what area of the state of Georgia do you live in?
Toward Gwinnett County, that way off 78.
Are you familiar with these areas that we've been discussing, kind of independent of your investigation?
Objection. Gwinnett County to Athens is irrelevant to any facts that are already in evidence in this case.
All right. There's a relevance objection. Mr. Yalamanchili.
So is the objection to the follow-up question that I asked or the answer that Mr. Ricketts gave to the previous question? I'm just not sure.
Sure. Go ahead.
To the follow-up question, Your Honor.
All right. Do you want to respond?
Yes, I do, Judge. The follow-up question was, are you familiar with the areas that we've been discussing as it relates to Loganville, Truck Customs, and Grayson? So I think that is relevant.
Okay. Is that your objection, Mr. Cruz?
Not the follow-up question, Your Honor. The follow-up, he asked him about Gwinnett County to these parts around here, Your Honor. That is not relevant. Mr. Melton stayed in Loganville, which is outside of Gwinnett County. So Gwinnett County to Athens is irrelevant in this case.
Okay. Let me just say this. I think you're referring to the question before the follow-up question, but we can talk about that. I think that is your objection. All right. And so that question has already been asked and answered, but let's let the state, if they choose to, respond to the objection about relevance when you asked about the Gwinnett County area. Do you care to respond?
Yes, Judge. I think Detective Ricketts, during cross-examination, indicated he was familiar with that general route. And now I'm going back to establish why it is that Detective Ricketts is familiar with that general route. And then, obviously, court heard the follow-up question, which had nothing to do with Gwinnett County. It had to do with his familiarity with these specific areas that we've been discussing.
All right. I'm going to overrule the objection. You may continue.
So, Detective Ricketts, I'll go back. I'll ask that question again. So, as it relates to the discussions we've had about Loganville, Truck Customs, and Grayson, are you familiar with those areas?
Yes, sir. It's like a small triangle that we're there together. Loganville, Grayson, all those little areas are very close to each other, like in a triangle.
And so when you say very close, let's just talk about Loganville and Grayson. How close are we talking about?
5 miles or so. I mean, they almost touch each other, I would say.
Okay. Repeatedly during cross-examination, Mr. Cruz made reference to you being unable to obtain documents from Nash Plumbing and some of these other locations that both Mr. Melton and Mr. McCurdy said that they both went to. I just want to clarify, because I think sometimes unable can leave a certain impression. Did you ever actually even attempt to do that?
I did not.
Okay. So is it fair to say that you didn't ask and then someone wasn't able to produce them? It's just that you yourself never asked.
That's correct.
Okay. Also want to talk a little bit about differences in timelines. And obviously, Mr. Cruz had Mr. Hill write some things on the flip chart. I don't need the flip chart. Detective Ricketts,
I don't need a timeline.
In your having received all that information from Mr. Melton, Mr. McCurdy, and Mr. Teeter about Mr. Melton and Mr. McCurdy's whereabouts on January 19th of 2001, was there anything that you received from those individuals that caused you concern about the integrity of those statements regarding where they were?
No, similar to the whiteboard, we use a similar thing except we go across. And on any kind of investigation we started back when I did those and even to this day, we would go across with a timeline, and you get the second subject and you go across with a timeline, and you get the third and the fourth and the fifth, and you start looking for consistencies and inconsistencies in those timelines. In this first 72 hours, just because Kris came back and remembered the bank, again, like I said when Mr. Cruz was talking to me, that's not abnormal for the timelines not to be minute by minute, to be some overlap. So on that first 72 hours, we weren't concerned about that overlap. We weren't concerned about any of that. We wanted to move on toward getting fingerprints, DNA, and push the investigation that way. So we were trying to secure all that, but that timeline didn't give me any pause at the beginning. Now, we've had investigations before, just to give you a this or that, investigations where as soon as you put the timelines on, you're like, they're in another world. So when they're close together and you can put that line close together on a board, you can kind of work that out. And I wasn't, in that first 72 hours, I was not at all uncomfortable in what we were doing.
And so as far as these variations that you saw and that we've talked about between Mr. Melton, Mr. McCurdy, and Mr. Teeter, would those be consistent with variations that you had experienced in other investigations that you had?
Yes.
Okay. Was there anything unusual to you about those things not being minute for minute exactly the same?
In the first 72 hours plus, no. In that first 72, 96 hours, nothing was out of that realm of that I was concerned about, that I needed to move on quicker, if that makes sense.
Right. And so I'm going to ask you, Mr. Cruz asked you about things that Mr. Melton's father may have said or not said to law enforcement. Was there another law enforcement officer who followed up with Mr. Melton's father?
In my recollection, yes. Lieutenant Durham was sectioning out what needed to be done. Again, as for this case, on that weekend, that Friday, Saturday, I was scheduled to be back going to school on Monday, leaving the state. Canceled that trip because of Friday. This was way more important. But Lieutenant Durham was assigning people to do those tasks, to do those follow-ups. So yes, sir, somebody was assigned to do that follow-up and talk to that person.
Do you believe, one second. Do you believe that seeing a police report from Rebecca at the time Taft would help refresh your recollection?
Yes.
Relevance, improperly attempting to refresh a witness's recollection are my two objections. So relevance, and improper attempt to refresh recollection. Those are my two objections.
Okay. I'm not sure I know what you're trying to refresh. You didn't finish the question. So he's made two objections.
So first, as to the relevance factor, this would be information that Mr. Cruz solicited on cross-examination about statements made by Mr. Melton's father to law enforcement regarding Mr. Melton's whereabouts. So that's one, relevance. It is absolutely relevant, even independent of Mr. Cruz's questions on cross-examination, but certainly at the point that the information is solicited on cross-examination, it would be relevant in a redirect. Improperly refreshing the witness's recollection, what the law says about that is that a witness's recollection can be refreshed with anything, including, things that might not make sense. I could hand him a pack of exhibit stickers and ask him if it refreshes his recollection, and it may or may not. So I don't think that that's a valid legal objection in this circumstance.
Yes, sir.
I have one. Double hearsay. Double hearsay. It's a report from one person that he's going to show the detective to ask, or I guess refresh his recollection as to what a third person said. So I'll add that objection as well, Your Honor.
Well, and Your Honor, if I may respond to the new objection. So once Mr. Cruz solicits that information on cross-examination, I believe he's barred from raising an objection during the redirect examination as to that same information.
Yes, one more time. Yes, sir.
I know Your Honor knows the law. I'll just leave it there.
Okay, thank you, Mr. Cruz. All right, with regard to the relevance, I certainly find that this is relevant based upon both examinations this court has heard with regard to this witness. I'm going to overrule the relevance objection. With regard to the refreshing recollection, you are entitled to refresh this witness's recollection if it does. So you may refresh his recollection with anything. We're going to take it from there, and then I'll make.
I couldn't be an attorney because I would be so petty with this ruling on the other side. Anything. I've got a water bottle here. Let me refresh your recollection. I've got this box of tissues here. Let me refresh your recollection. I'm just going to go for it.
Make a ruling on the hearsay objection.
Couldn't
So
be
you
an
may go
attorney.
ahead with the refreshing recollection if you can.
Thank you, Judge. I'm going to show Mr. Cruz a copy of the police report from May 4th of 2001.
Judge, I am going to object again. I don't understand how
Move
another
for mistrial.
detective's
Do
police
it.
report will refresh this witness's recollection. The foundation hasn't even been laid. He never asked the question, do you remember Rebecca Taft's report from May 4th, 2001? He hasn't laid the foundation that this officer even read this report, Your Honor.
All right, thank you. All right, any response to that objection before I make a ruling?
No, Your Honor.
All right. The law
Hand
is
above your
that
head,
if a
refresh your
witness does
memory.
not recall, the state can ask, or the defense, any party can ask to refresh a recollection. It doesn't mean that the witness's recollection is going to be refreshed, but any party is entitled to use a document, an object, an audio recording, a visual recording, anything can be used to attempt to refresh a witness's recollection. I'm going to allow the state to attempt to refresh a recollection, and we're going to take it from there. So I'm going to overrule your objection, allow you to continue, and then we'll take it from there. I'll rule then, if necessary, on the other part of Mr. Cruz's objection.
Thank you, Your Honor. Detective Ricketts, I'm going to hand you this, and for the record, it is a police report from Detective Rebecca Taft from May of 2001. If you would, please review it, and once you've had a chance to review it, let me know.
Yeah, Cruz needs to try this at least once to see if the judge really means the defense can do it too. Gotta test her on it.
Yes, sir. Have you had a chance to review that report from Detective Taft?
Yes, this was one of the assignments.
Hold on one second before we get into any other testimony. has reviewing that report helped refresh your recollection as to what other law enforcement may have done related to George Melton, Mr. Chris Melton's father?
Yes, I knew a detective had gone and interviewed them both. I just couldn't remember if it was her or John or Painter. Not Painter, but anyway, I knew it was one of the ones, but yes, this is the recollection of the report that I remember seeing.
Okay. All right.
Right.
So I'll come get that back from.
All right. And at this point, since the recollection has been refreshed, I'm going to send the jury out for just a moment and take something up outside your presence. Please don't discuss the case. Thank you.
Why'd he look like that? Look at his face.
Please don't discuss the case. Thank you.
Oh, I can't keep discussing it. And like the other days so far, Elizabeth Bigham is here sitting on the state side.
Good to see you.
GBI
Thank
cold
you.
case agent.
Yes, of course. All right. I wanted to take this up outside the presence of the jury in the event that the information you all are arguing about is something that is not admissible, and I don't want the jury to hear it. So I'd like to hear what you all are arguing about.
Thank you, Your Honor.
Not for nothing, but his question, I feel like the jury's already cued in that something out there exists that corroborates this thing because it's been alluded to in the questions. Oh my gosh.
So, Judge, if I could retrieve.
May?
I'm sorry.
I think so too, Freedom Ring. I would not be surprised. Put a robe on. Or leave it off. It makes more sense to not have it on.
Your Honor, on cross-examination, Mr. Cruz elicited information regarding statements that Mr. George Melton, who is Chris Melton's father, either made or failed to make to law enforcement, with the implication that Mr. George Melton never corroborated Chris Melton's whereabouts at his own home on the morning.
Okay, we went through a long, slogging cross-examination where if the witness at first kept having to say, only to me, only with me, or what I know, or somebody else looked at that. And Cruz ended up adopting that language with his questions as time went on. So I do not think it's accurate to say that the testimony gave some answer that needs some type of rehabilitation now because of what happened on cross. Because this witness and then Mr. Cruz started adopting the language, at least to you. Not to me. Anyway.
Of the incident, which is, one, what is contained in Detective Taft's report, who I'll note for the record is deceased. And so, based on the fact that Mr. Cruz is soliciting this information, which, in its outset, obviously Mr. George Melton is also deceased, so it would be a hearsay statement. However, once Mr. Cruz, as the opposing party, has elicited hearsay statements, then he's then barred from raising an objection to the other party talking about those same statements. And so what we've endeavored to do is we have reached the point at which Detective Ricketts has had his recollection refreshed about these conversations with George Melton and who had them. And my next series of questions to preview them for the court would just essentially be, are you aware of anyone in law enforcement that had a conversation with George Melton? Did they talk to George Melton about Chris Melton's whereabouts on the morning of January 19th of 2001? And what information did Mr. George Melton give about Mr. Chris Melton's whereabouts?
All right. Thank you. Mr. Cruz, do you care to respond, sir?
Yes, ma'am.
Go ahead.
So I wholly disagree with the state's position that if, and I'm not saying this is the case, and I get into the hearsay piece, if hearsay is elicited, they could then bring in a report that's essentially double hearsay. But in regards to the hearsay portion, Your Honor, I didn't elicit hearsay. I asked the officer about what was not said. I didn't ask the officer about a specific statement that was said. So my examination questions were not hearsay because I didn't elicit a statement. I just simply elicited that Mr. George Melton did not say a particular thing. As far as what the state is trying to introduce, and I've said it before, I believe the state is trying to use this witness to, and I don't think it's intentional, it flows from the act. We have a right to examine the witnesses, to cross-examine the witnesses. With prior witnesses, it has already come up regarding the statement to law enforcement on May 4th, 2001. However, because Detective Ricketts, during my examination, he explicitly made clear, and correct me if I say anything wrong, but he explicitly made clear that his involvement from this case was January 19th to January 21st. And I limited my questions to your involvement. So now to go 4 months later and say, well, let's talk about Detective Taft's report and what George Melton, one level of hearsay, told Detective Taft, that's the one level, and then Detective Taft put it in a report, which is the second level of hearsay, and then to ask this witness to testify about same, Your Honor, is improper.
Ms. Kris, let me ask you a question.
Sure.
When you asked a question to this witness about statements allegedly made by George Melton, did you phrase it in the time frame that you've just suggested, the 19th through the 21st, or did you just make a blanket question about Mr. Melton?
So the officer limited his answers to that window.
All right.
So the officer said during my involvement in this case, which we established was January 19th to January 21st. And please correct me if I misstate anything.
Well, that is how he responded.
Correct.
All right. Thank you, sir. Mr. Yalamanchili, anything else that you would like to say?
I do believe the question was stated in such a way as to go beyond whether a statement was made directly to this witness, one, or two, limited to the time frame of January 19th to January 21st. That's my recollection of the question, Your Honor, but of course the court will have its own recollection.
And just to add, Your Honor, my questions are not evidence. It's the witness's answers that are evidence. I didn't elicit anything from this officer that Mr. Melton, in the course of this investigation, did not say X, Y, and Z. If the state would like to get into that and give us an opportunity to cross-examine whichever witness it may be, I believe he said Detective Taft has passed away, but she had a partner with her. So if the state wants to call that individual in and we get into those statements, I think that's fair. I think that's proper. But to use Detective Ricketts as a surrogate to get in inadmissible hearsay or to counter anything we bring out from Detective Ricketts' personal involvement in the investigation, we think that is improper. We have no way to cross-examine Detective Ricketts about what George Melton told Detective Taft. And he couldn't lay a foundation for the audio recording either way. So we would be handcuffed in the sense of we can't confront those statements, Your Honor.
All right. Thank you, Mr. Cruz. So I think there are a number of issues going on here. And one of them is semantics. And it is improper for one party to say or to argue that the other party is not entitled to go into something that was raised because one party used the word not or didn't use the word not. And so I just want to make a statement about that. It is not, this is not a court of, well, I'm just going to say it that way. I'm going to respond to what I was just going to say in a minute. With regard to the defense's comments that they only limited their questions to the 19th to the 21st, that is not terribly accurate in how the cross-examination went. The cross-examination was directed in a way that forced this witness to continually remind counsel that he was only referring to the 19th to the 21st. And so to argue that the defense has only asked questions about that period is inaccurate. in terms of what we've been hearing for the past 45 minutes. And so I want to respond in that moment. The law allows either party to go into something that the other party has raised without an objection in order to respond properly. The law allows that. And so Mr. Yalamanchili is correct about his ability to cross-examine this witness. On the document that refreshed his recollection, you will have every opportunity, Mr. Cruz, to cross-examine him on how he had his knowledge, if he has the knowledge, and all of those things. But the defense did bring it up, and so I'm going to allow it. You may bring the jury back in. All right, ladies.
This line of questioning with, I respect the court's ruling, so I'm not trying to challenge that. I just want to put on the record that a prior witness came in and testified about this particular information as well, Your Honor.
You have the floor.
Thank you, Your Honor. Detective Ricketts, before we took that brief break, I believe you had just reviewed a police report from Detective Rebecca Taft from May 4th of 2001. And I'll ask you the same question I just asked you previously. Having reviewed that report, did it refresh your recollection as it related to George Melton's statements to law enforcement?
Yes, it did refresh my memory on that Becky was the one that went out to the residence, interviewed the family, and got those timelines on for the family and for the time that they got up in the morning and at the time that the helper showed up because Josh got there that morning.
And so as it relates to the date that we're discussing, are we talking about the night of January 18th, that Thursday, into the morning of January 19th, that Friday?
Correct. She had a time when she got up and then he was up that morning.
Okay. And I want you to let's limit your testimony to what George Melton said. As it relates to George Melton, did he make any statements to law enforcement regarding Chris's whereabouts on the morning of January 19th of 2001?
He did. He said that he was there on the morning of the 19th when Josh showed up to pick him up and was there that morning from, I think, the time frame I saw was like 6:15 that morning.
Okay. And when you say there, where are they referring to?
At that residence.
Okay.
Home.
And would that be the residence of Mr. Melton's mother and father?
That's correct.
Okay. Detective Ricketts, I'm going to hand Mr. Cruz what's been marked as State's Exhibits 149 through 157, and after he's done reviewing them, I'll hand them to you.
Yes, sir.
Detective Ricketts, I'm going to hand you States 149 through State 157.
Yes, sir.
Just take your time, flip through them, let me know when you've had an opportunity to review them all.
Yes, sir.
And kind of collectively, not individually each one, but generally, what are all those pictures?
These are the photos that Detective Newton took while we were at the hospital at Athens Regional, where the blood work was done. We had Kris remove his shirt, and we took pictures of his upper torso, his arms, his back, his neck, pretty much every part of his body except the groin. We had him pull his pants really up in his underwear so we could see pictures of his legs, feet, back of the feet, everywhere on his body, and just mark any abrasions or scratches or anything that we saw on the body.
And those images, do they appear to be true and accurate depictions of Mr. Melton's appearance in the photographs taken on January 21st of 2001?
Yes, sir.
Okay, Judge, I move to tender those at this time.
Any objection, Mr. Cruz?
No, ma'am.
They are admitted.
Your Honor, if I could publish them on the L notes of the jury.
You may.
And State's Exhibit 149, I'm putting that up on the Elmo. What are we seeing for purposes of the record? Obviously, the jury can see it themselves, but what are we looking at in State's 149?
We're in the clinical room where the where the phlebotomist was. This is the front picture of the torso. And another photo, there's a minor scratch on the left arm right there of the patient, or I'm sorry, I flipped at the EMS mode. I work EMS, so I apologize. On Mr. Melton on his left arm there, and it's just the front of him with his shirt off.
Okay. And then I want to point out one other thing. You said the word phlebotomist. What is a phlebotomist?
The person who does the blood work, made pulled the blood from the person.
And I'm pointing this right here in the corner right there. Do you recognize what that is?
Yes, sir. I believe that's the injection point right there.
Okay.
She pulled them both out on ACs right there.
All right. And so the injection point, would that be where the phlebotomist accesses his vein? Or?
Yes, sir.
Okay. State's Exhibit 150, what are we seeing here?
Just the lower part of the torso from the nipples kind of like to that pelvic line there. Just again, looking for any types of abrasions or scratches.
151, what are we seeing there?
Lengthwise from the scalp down to the belt line, back of both of the arms. Arms are left straight down to the side so you can see the back.
Yeah, so Dr. Nick is saying, did you check to see if his eggplant had bite marks on it? I'm pretty sure we heard that he wasn't sure if they actually made him take his pants off, so...
And in the other photo, you can see the straight side of the front of the arms.
State's Exhibit 152.
Just to look at that side from the patient's left, or sorry, from Mr. Melton's left. I apologize.
State's 153.
Mr. Melton's right side.
State's 154.
Front of Mr. Melton's legs with his underwear pulled up as much as possible, just to have a look at his legs.
Okay. State's 155.
Back side of the leg from the knees down to the ankles of bottom of his feet, or the top of his feet.
State's 156.
The front of the feet from the kind of top of the shin bone down.
And State's 157.
I believe that's his left arm, and that's the little mark that I was talking about there on the side.
I don't know if the first thing he did, if this was Chris Melton, and Chris Melton seems to have known about that black power cord from the printer that Tara was strangled with, I would think you'd be scratching the tops of somebody's hands and maybe get some of their arms, positioning on their arms. I wouldn't expect to see scratches on feet, ankles, lower legs.
Thank you, Detective Ricketts. I don't have any other questions for you right now.
Cross-examination or recross, Mr. Cruz.
Sure. Your Honor, based on what was brought out on redirect, it's going to take some time. Can the jurors get lunch and I can start after their lunch?
We have everybody at the bench for a moment.
Are we going to get yelled at for scheduling, even though...
Detective Ricketts, I'd like to talk to you about a couple of things you discussed with the state, okay?
Sir.
All right, first, let's talk about the over an hour with traffic to drive from Mr. Melton's home to Ms. Baker's home, okay? Can you tell us the speed that the individual was traveling?
I cannot.
Okay. Can you tell us how long traffic was stopped?
I cannot.
Okay. So that over an hour, it doesn't account for the various conditions that led to that amount of time. Is that right?
No, sir, it does not.
Okay.
That was just in general.
Yes, sir. They also talked to you about the meeting that Detective Taft had with Mr. Melton's parents. Is that correct?
That's correct.
And we've already agreed that this murder happened on January 19, 2001.
Correct.
All right. That meeting occurred on May 4th, 2001, correct?
Correct.
So it's about 4 months after this has taken place. Is that right?
That's correct.
Okay. And Mr. Melton had been staying at home for those 4 months. Is that fair?
I don't know if I can answer the question. That I'm sure he moved out of his apartment, which he said he was going to do, but I don't know if he moved up there or not. I don't know when he did it. I guess you should say that.
And I show you the same report that the state showed you?
Yes, sir. Thank you.
And it will be in the second paragraph, officer, I believe, either one of the first two sentences.
Okay, so you're talking about from right here?
The second paragraph?
Yes, sir. And this was before Tara died.
Correct.
About 2 weeks before Tara died, he had been living there. Yes, sir.
The parents said that Mr. Melton had stayed with them about 2 weeks before Tara died.
Correct.
So Mr. Melton, you would agree, had 4 months to tell them his alibi. Is that right?
4 months before they were interviewed?
January to May. He had between January and May to talk to his parents about where he was and his whereabouts.
No, because on the tape, on the interview I did with him, Mr. Melton told me that he'd been living up there for that whole week. Now, they went up and said the 2 weeks, but I know probably, I won't speculate, Kris used to come back to Athens on the weekend and stay in order to be closer. But on the tape in the first interview, I believe it's in my notes, Mr. Melton said that he had been with him most of the week while he was starting the business. So that 2 weeks is correct. The time frame is correct on that, but Mr. Melton corroborated to me before that time on the 19th that he had been there almost that whole entire week. So I had a week. Taft says 2, but I knew for a fact on the 19th a week, well, from Mr. Melton's statement, if that makes sense.
That's fair. And I try not to get in other people's statements because they come and testify and they tell the jury themselves. So
that's okay. I
be careful
understand
with that.
I went around the tree on that one, so
Yes, sir.
I apologize.
No, that's no problem. But I do want to talk to you about a couple other things. So we've established that Mr. Melton was at home with his parents when they spoke with, when his parents spoke with law enforcement on May 4th. Is that right?
Yes, sir.
Okay. Now I want to talk to you about what Mr. Melton told you about knives and Miss Tara Baker, okay?
Okay.
On January 21st, 2001, Chris Melton told you that...
I'm going to object. I don't think any questions came up in direct examination or cross-examination when Mr. Melton testified regarding any kind of discussion about knives.
All right, let me see counsel at the bench, please. May have.
Didn't want the jury to hear about whatever the knife question was going to be. Made sure those arguments were in front of the jury.
That's what I was looking for.
I got you.
Now, the state asked you about Detective Taft's interview with the parents. Is that correct?
That's correct.
And you stated that you were aware of her report in her interview with the parents. Is that correct?
That's correct.
Detective Taft stated, unable to locate Nash Plumbing to verify that Josh and Kris were there that morning. Is that correct?
That's correct.
And this was May 4th, 2001. Is that right? She also stated there is no listing in information for them. Is that correct?
To my knowledge from that report, that is correct.
Thank you. All right, no other questions.
Thank you, sir.
Any, excuse me, any redirect, Mr. Yalamanchili?
Briefly, Your Honor, and I'm sorry I should have done it the first time. My apologies.
Oh my gosh.
Just gonna.
So, scope only works in one direction.
Refer to this real quick. In cross-examination, Mr. Cruz elicited testimony from you that Mr. Melton indicated that he and Mr. McCurdy had only known each other for a month, and Mr. McCurdy indicated they had known each other for a year. Do you recall that?
Yes, sir.
Okay. Was that your recollection of the interview?
No, my recollection of the interview, it was more like a year they had known each other and been working on and off. That when Kris decided to start his own business, he came over to assist from somewhere else. So I think Kris pulled him over there, if that makes sense.
Okay. And so your recollection of the interview is that Kris indicated that they had known each other for about a year. Is that right?
Yes, sir.
Okay. Judge, I don't have any other questions.
Recross, Mr. Cruz.
Yes, ma'am.
Go ahead.
If the honorable court is willing, can the jury go to lunch? Because I think this is going to be a back and forth.
I'm gonna ask you to continue your recross, please. Thank you.
Do. So it is your testimony here today that Chris Melton stated that he knew Josh McCurdy for a year when you interviewed him on January 21st, 2001.
I would say approximate between the interview on the 19th and the 21st. That's what I pulled away from there.
Okay, that he knew Josh McCurdy for a year.
Yes, sir.
All right, court's indulgence, Your Honor.
Let me find an afternoon feed because it looks like this one stops at lunch.
Before I get into how long they knew each other, I asked you a couple of questions just to be considerate of everybody's time, so we could knock it all out in one swoop. When Chris Melton appeared at the police department on January 19th, he appeared with Josh McCurdy. Josh McCurdy was present as well. Is that correct?
To my knowledge, I wasn't there when they arrived, and I never saw Josh on the 19th.
Okay.
Like I was saying in my opening, I came up from the other part of Georgia doing a cold case, so I didn't get there till after things had already been going.
So your testimony here today is that Josh McCurdy was not at the police department on January 19, 2001.
I didn't talk to him there. I don't know if he took him straight to the scene and then came back over there.
Not did you talk to him. Was he present at the police department on January 19, 2001?
And Judge, I'm going to object. Lack of personal knowledge. I think the witness has already said that he never saw him there and he wasn't there earlier in the day. So.
I'm going to allow him to ask the question.
Ooh.
I never saw. I'm sorry. Go ahead.
I would ask the state to make a objection, give the ground, and honorable court rule. I would ask them to stop attempting to coach the witness from the stand, Your Honor. Mr. Yalamanchili just gave an answer that the witness was about to repeat. So I would ask the honorable court to instruct Mr. Yalamanchili, if he has an objection, just state the ground and allow the honorable court to rule.
Judge, if I could just briefly,
You may.
What I did was restate the answer the witness gave to a previous question, and that is the explanation for why he lacks personal knowledge. I would also, strongly dispute the miscarriage
Okay, and so you just deprived the defense of the opportunity to see if the same witness would deliver consistent testimony.
Characterization of what we're doing when we're just repeating what the witness has already said.
All right. Thank you. Mr. Cruz, you may continue.
Thank you, Your Honor. So is your testimony here today that you don't know if Josh McCurdy was at the police department on January 19, 2001?
Yes, I don't know he was there.
I'm going to play for you. I'm going to bring the computer to you just to make sure you are aware of this recording. And for the purposes of the record, I am going to play from minute mark 0 to minute mark 129. And after you listen to it, I'm going to have some questions for you.
I mean, hopefully they end up playing it loud. We can, like, kind of hear it. All right, we can't hear that. I'm going to speed through it, even though I guess it's technically audible. But let's just get to them playing it for real, or asking the questions. That's right, HT, don't forget to hit the like button during the downtime.
Or I'm marking, forgive me. I am marking minute mark 0 to 129, 1 minute and 29 seconds, as the defense exhibit 46. Detective Ricketts, you had opportunity to hear the recording that was marked as defense exhibit 46. Is that correct?
Yes, sir.
Okay. You recognize your voice?
Yes, sir.
Okay. Did you recognize Mr. Melton's voice?
I did.
Okay. And you recognize that recording as your interview with Mr. Melton on January 21st, 2001?
Yes, sir.
And based on that portion of the recording, was it a fair and accurate depiction of your conversation, or a fair, accurate recording of your conversation with Mr. Melton?
Yes, sir, it was.
And did it sound like that portion of the audio had been altered in any way?
No.
During this interview, you asked Chris Melton what happened to Josh McCurdy. Is that correct?
I did.
And you stated that Josh disappeared on you. Is that right?
He did. That's what I said.
Let me put it in the context. You stated Josh, he disappeared that night. Where'd he go? Is that correct?
Yes.
I also asked you about how long Chris Melton worked, or stated that Josh, or stated how long he knew Josh. He stated he knew Josh from working at McCart Plumbing. Is that correct?
Correct. That was that year part I was talking about.
Mm-hmm. And he's say that one more time.
That was the year part I was talking about. They'd known each other for about a year working at McCart Plumbing.
Chris Melton didn't state he's known him since December, or he's worked with him since December of 2000.
So December 2000, I took
Together in December of 2000.
I took from that conversation that they had worked.
Okay, it looks like the feed jumped right there. Let's just make sure.
He's known him since December, or he's worked with him since December of 2000.
So December 2000, I took
Together in December of 2000.
I took from that conversation that they had worked together elsewhere, and then when he started his business, Josh came over with him.
And a week before January 19th would have been January 12th. Is that right?
Yes.
No more questions, Your Honor.
Any redirect of this witness?
No, Judge, we'd ask that he be excused.
Any objection from the defense?
We have him under subpoena, subject to call.
All right. You are free to go, sir, but you are still under subpoena by the defense.
Thank you, ma'am.
You're free to go.
We need to get contact from Detective Ricketts.
I'll certainly let you have a conversation with him. Absolutely. All right, ladies and you may step down. Ladies and gentlemen, we're going to take a lunch break until 2:30 this afternoon. It's a little bit longer. Please don't, of course, discuss the case. Go to any place that you may have heard about. Please don't do any research other than that. The deputies are going to escort you to the elevator and to the parking deck. Enjoy your lunch. We'll see you all at 2:30. Thank you.
All right, so we'll switch over. Where's the full screen option? There we go. Skip the lunch. And guys, I was trying to tune into... Oh, actually, make sure they didn't argue before I close. Okay, yeah, they went away to lunch. I was trying to call in. There's supposed to be a hearing in the Fat Joe and Tyrone Blackburn extortion lawsuit. That's been a whole mess. But I only had waiting music. That's why I had my camera off. I only had waiting music. So I don't know if they rescheduled that court hearing or if they're just not letting me in. But unfortunately, I don't have an update on what's going on there. But I'll keep checking the docket.
Any evidence that you all were discussing?
I don't believe so at this time, Your Honor. I don't think I'm going to necessarily have any disagreement with I guess
the court is still
the
muted, but
substantive
Yalamanchili
portions
saying
of what Mr. Cruz has indicated that he believes should be redacted.
Let
They
us in,
seem
Maurice.
on first review to match up with the things that the state noted as well. We talked before Your Honor entered the courtroom, and there may be like a sentence on each side of the timestamps that one party or the other seeks to admit admissible rulings.
The right way.
That
really
additionally
have it
can
muted
kind
this
of cross
whole
you
time?
now with stuff. So
We'll play through.
I think it's my
Anything
audio.
that the court needs to discuss
guys
with
hear the
regard
court?
to
I don't, Your Honor, I don't think I'm going to necessarily have any disagreement with I guess the substantive portions of what Mr. Cruz has indicated that he believes should be redacted. They seem on first review to match up with the things that the state noted as well.
All right.
We talked before Your Honor
You'll
entered the
listen on my-
courtroom, and there may be like
Right.
a sentence on each side of the timestamps that one party or the other seeks to admit. But I think we have the same understanding about the information that would not be admissible in front of the jury. And so I don't think that we need the court to make any rulings at this time.
Ms. Cruz?
Okay, there's something before lunch. It looked like they just went to the ceiling and then Fox cut out. Did they go to the ceiling and come back? Because then I'd hop over to Law and Crime to see. Let's see. Let's see. Sorry, guys. I'm struggle streaming. I can hear this one.
From marking, forgive me.
Correct.
He said he knew Josh from working at
All right, yeah, let's try law and crime because from the Fox feed, it didn't look like they had anything. So let's go look at what happened before lunch. Oh, Law and Crime restarted their feed too. Maybe they have to if, well, they usually just put up that pause screen, the live screen. All right, here's. All right, so I don't see a part 1 from Law and Crime right now. It must be rendering. So, does anyone have a summary of what happened? Oh, they might have shown the jurors. And she had a few things to say. Let's see if 11 Alive has it. All right, 11 Alive only started like an hour ago, so they're not going to have it either. All right, so the judge was giving warnings. What we can do, guys, is when we finish with the day, we can look back and see if like Law and Crime has uploaded their part 1. We'll do it that way. So let's jump into after lunch. She said that it's her job. Thank you, Lauren. Says that it's her job to decide when the jurors need breaks, not Mr. Cruz. So she got yelled at for it. He got yelled at by the judge. Can't do anything. Can't do anything in that courtroom. Big thank you. Shout out to Lauren in the chat for giving us the 411.
Of Miss Baker's death.
They really did take a long lunch.
With regard to
All right, I think we're back.
Mr. Cruz, I'll just speak to both of you since you all have talked about getting together over the break. Anything that the court needs to discuss with regard to any evidence that you all were discussing?
I don't believe so at this time, Your Honor. I don't think I'm going to necessarily have any disagreement with
The statement from Cruz.
I guess
from Faust.
the substantive portions of what Mr. Cruz has indicated that he believes should be redacted.
Okay.
They seem on first review to match up with the things that the state noted as well.
Okay.
We talked before Your Honor entered the courtroom, and there may be like a sentence on each side of the timestamps that one party or the other seeks to admit. But I think we have the same understanding about the information that would not be admissible in front of the jury. And so I don't think that we need the court to make any rulings at this time.
Mr. Cruz?
I would ask that the motion is granted.
Right. I am going to grant your motion, but I want to make sure I've got the right language. But go ahead. Yeah.
But we are on the same page. As Mr.
Okay.
Yalamanchili stated, we're on the same page with the timestamps.
Okay.
I'm assuming, and I asked Mr. Yalamanchili, is this Mr. Howell we're going to get this in, or Ms. Bigham?
I intend to play it through Agent Howell.
Okay.
And so when we do that, I mean, the one thing that I would say is just out of an abundance of caution, a little additional time to make sure that I have the mechanism of making sure it's not published to the jury down in a way where it doesn't cause some kind of issue. But we can kind of cross that bridge when we get to it.
Okay.
And I think, we can push forward. It's 2:30 now. I tell you, the state intends to call Agent Bigham next.
Okay.
So I imagine Mr. Cruz would have a fairly lengthy cross-examination for, just based on some of the prior hearings and stuff. So if that doesn't get us to a latter part of the afternoon, we could call Agent Howell, who has some testimony about crime scene and other related things. But I would ask the court that before I got to the point of talking to him about the statement and putting it into evidence, if we could break for the day at that point, just so, or just not start him, honestly, might be. But however the court wants to handle it, we'll take your direction. But I will say a little more time to make sure I have the redactions exactly right would be helpful.
All right, thank you. Yes, sir.
I'm just asked out of abundance of caution, and Mr. Yalamanchili may already be about to do this, but if not, our office could cut off the video. We can actually take parts out of the video if you all would like, and give a copy of the video that would play through, but only with the relevant portions.
I'll let y'all work on that. I don't think I need to get involved. I don't think I need to get involved in it. I'll let you all talk about it. I think it is fair to say that we do need to take a break before you wanted to introduce the video. We'll do that whether it's the end of the day or tomorrow morning. Just for the record, to be clear, the motion is granted. It has always been granted. I think the issue was to get both parties on the same page if possible, and then if not, I'd hear both arguments about what is admissible and what's not. But as long as both of you have agreed that the portions that are going to, as long as you both have agreed to the portions that are going to be redacted, I'm not going to get involved in all of that. That's fine. I will grant your motion with the basically stipulated moment that you both have come to about what needs to not be entered into evidence. So if we need to take anything up, if it becomes clear that maybe you don't have a meeting of the minds, you need to let me know as soon as possible so that we don't, the jury doesn't hear it. But other than that.
Yes, Judge.
All right. I will. Yeah.
Hold on, let's listen to this timeline.
Yes, Judge.
All right. I will. Yeah.
I don't know. I hear him saying Thursday at the latest and then saying next Tuesday. So.
Field has asked to remind you, if you can, to wear the lanyard as best you can, or use the microphone so she can hear you.
Yes, ma'am.
Thank you very much. And if Mr. Yalamanchili has that issue, we're going to find one for you too. So.
Yes, ma'am.
She just needs to hear you, that's all.
Yes, ma'am.
All right. Anything else, Mr. Cruz?
I know that the court talked about this morning in regards to the link. One of the witnesses, they're out of the country. So I just want to make sure that I can sync it up with them before the state rests. And I understand the state may be resting at earliest tomorrow, at latest Thursday morning.
Oh, you mean for the WebEx?
Correct.
Sure. So when you all seem to have a better idea of when that person needs to be called, we'll take it up and we will figure out the best time. If this person is out of the country, we're also, I guess, dealing with a time change.
Right.
So we'll work it out. We'll make it happen. It's not terribly complicated, but it does require some advance preparation to be able to make it happen.
Yes, ma'am. And just to let the court know, I would have to give her advance notice because I think when we're here and it's daytime for her, I think
Right. I mean, that's what I mean. Yes, I understand that completely, but I think it's just best to get a little bit better time frame, because if you give a time frame now and that's not going to be the time frame, it's hard to change it. You'd have to sort of cancel it and do it all over again, and that might be more complicated. So, but we'll make it happen. I think the one thing to tell all your witnesses, whoever is going to be on WebEx, and I don't think the state has made a proffer that any of theirs are going to be on WebEx. Obviously, it's the defense's ability to object to that. But WebEx is the medium, and so, or the mode, or I don't, whatever you call it. And so your witness is going to have that downloaded on whatever apparatus your witness is going to use, whether it's a phone or a computer. WebEx is the only medium the courthouse can use.
Yes,
so,
ma'am.
all right. Anything else, sir, before we bring jury up?
No, ma'am.
All right, thank you. Ms. Yalamanchili, Ms. Bolden, anything else?
No, Judge.
All right, thank you. Mr. Chair, if you'll bring the jury up, thank you.
All right, so state plans to rest either tomorrow or Thursday, which means the evidence we're going to end up hearing against Faust is true allele in the DNA. We're going to hear why the cold case unit was sending things to Pure Gold. We're probably going to hear that they were suspicious of Faust because when they interviewed him and said, hey, you raped somebody, and he was like, what are you talking about? They thought that that was signs of a guilty conscience. And also determining that he had a stepmother with an address in the Deer Park area. I don't know if we're going to see much other evidence from the state that relates to Faust. And I don't know, it doesn't seem to me like they're going to bring Brenda Swinney in, but maybe they'll have one of the detectives talk about their discussion with Brenda Swinney, where after she had a stroke, she said God came to her and showed her what Faust did, and that he set a house on fire and took a TV, which there's no TV stolen in this case, after they've been questioning Brenda Swinney for quite some time. We'll see if we hear about that, and or if Brenda Swinney is actually called by the state. This is Liz right here. This is Elizabeth Bigham. She's a GBI cold case unit detective. Faust was the same age-ish, like give 2 or 3 years as Tara. That's what he looked like back then.
On the record, State of Georgia versus Edrick Faust, SU 24 CR 0547. State ready to proceed?
State's ready, Judge.
Defense ready?
Oh yeah, the jailhouse snitch.
All right, thank you. Mr. Yalamanchili, you may call your next witness.
State calls Agent Elizabeth Bigham.
Oh, here's Liz.
Yes, absolutely.
Your Honor, we need to take up a matter outside the jury if Ms. Bigham is being called before she testifies.
Oh.
All right. Ladies and gentlemen, I know you just got here. I'm going to take up something outside your presence I was not aware of. If you'll have a seat and don't discuss the case.
Kick Liz out too. Before we get into this while the jury's leaving, thank you, Freedom Ring, for the super and all your insights in the chat. The quote here in Judge Lisa Lott over here. The motion is granted. It's always been granted, but I'm not ruling on the motion. I'm just deferring on you two. You two stipulate. If you ever decide you need me to rule, let me know, then I'll rule, and then I'll never actually rule. So I'm improvising that last line there. Thank you for the super, and this is how it feels. In earlier streams, we did a look at the docket, and there's just all these motions that look unanswered. The defense raised an issue before trial in their motion to disqualify, to recuse this judge, that the judge doesn't respond to anything that comes from the defense. Yet, on a Saturday, within 24 hours, they'll respond to something from the state. And then there's a wall on the docket of denied motions, largely denied motions from the defense, and granted motions, largely motions from the state that are granted. Just all laid out there. Plain as day. Plain as day. So thank you here, and I agree. I think that's a great, a great quotish here.
We had done this before the jury came out, Mr. Cruz, but go ahead.
And I apologize, Your Honor. I was under the belief that Jeremy Howell was going to testify, and that's why I didn't bring it up. I was going to wait till Ms. Bigham testify before I brought it up.
Jeremy Howell is the other GBI cold case unit detective.
But we're going to get into, with Ms. Bigham, her case file and the case file. As the court is aware, during a prior hearing, Ms. Bigham testified that she's seen every document in this case. One of the documents that we're going to discuss with Ms. Bigham includes where Mr. Faust was staying at the time of, or at least the weekend of Ms. Baker's death. I would ask the Honorable Court, because the only thing we're going to get into is just the address and where he was staying. However, it goes into a matter that the state has expressed that they don't intend to introduce in this case. And I would like the Honorable Court to provide an instruction to Ms. Bigham not to delve into the incident or the specifics of the incident involving Mr. Faust and Mr. Christian Foster. And we will not open that door by asking specific questions about the situation with Mr. Faust and Mr. Foster. We only intend to discuss Mr. Faust's address on the weekend of Ms. Baker, and before Ms. Baker's death.
All right, so it's motion and limine.
Yes, ma'am.
All right, any response to the motion?
I guess I would like to know what the document is first that Mr. Cruz is making reference to.
Didn't we also already have a motion in limine with regard to Mr. Foster?
We did not have a hearing on this. The state stated that they did not intend to call Mr. Foster.
Okay, so we've had a discussion. Okay.
Picture. I don't want it to fall on. Picture looks like it's about to fall.
They say a picture looks like it's about to fall. Oh my God, is the picture behind the witness stand about to fall? Is that what they said?
Picture. I don't want it to fall on. Picture looks like it's about to fall.
The hand is coming down, guys. Oh.
Your Honor, it appears from a preliminary review of this document that what Mr. Cruz is referring to is a statement from one of the witnesses of the incident where Mr. Faust stabbed Mr. Foster, who states to law enforcement that she used to date the suspect for approximately a year. He lived with her for some of that time, and she additionally said that the suspect stays with his girlfriend, Brenda Howard, in Knollwood Apartments off of Old Hull Road. So, one, I don't think any of that is admissible. It is double hearsay. It is a statement by a witness.
So I think the relevance here would be Brenda Howard, who might be Brenda Swinney, and that would be Faust wasn't living with the relative that lived in the Deer Park area across that main road. Because Brenda new name is Swinney, but I guess used to be Brenda Howard.
To a separate law enforcement officer that is then memorialized in this report, and that'd be Detective Sean Potter, who I think is deceased, Judge. And so the state is not planning to elicit any statements regarding what was told to Detective Potter from Agent Bigham. And I don't believe that Mr. Cruz would be allowed to do so without it drawing a hearsay objection, which the state would make, and therefore I'm making an oral motion in limine to ask that Mr. Cruz not be allowed to elicit double hearsay information without the state having opened the door to the same.
Mr. Cruz?
Thank you, Your Honor. The statement is not hearsay. Ms. Bigham is the lead investigator. The state's position for this entire case has been that Mr. Faust stayed at 350 Cooper Road. As the lead investigator, the fact that Mr. Faust actually stayed in Knollwood Apartments goes to information that she knew, and that's the objective effect. As the lead detective, she was aware that Mr. stayed at 350 Cooper Road. The state presented same in their opening, despite Ms. Bigham being in the courtroom with the state and having knowledge of this situation. So it's not hearsay. We're not offering it solely for the truth of the matter asserted. We're offering this information to show this is information that Ms. Bigham had. This is solely entered for its objective effect, so it is not hearsay. So, and the simple way is to, she knew this fact. She was aware of this fact. That's the sole purpose of it.
Okay, well, I guess let me start with this.
Sure.
First of all, that doesn't get around the hearsay problem, even offering it as something that tends to show an objective effect or for the purpose of showing what's in a case file does not overcome a hearsay objection. So I want to get that straight. I guess what I don't understand is what are you trying to do with this piece of evidence? Maybe we should start with that. Are you trying to tender that or question Agent Bigham about what's in that document or something different?
So I would only...
Just question.
And I will follow the Honorable Court's ruling. I always have, I always will. I disagree with the interpretation of the law. I would like to provide the Honorable Court with some law in regards to non-hearsay, not hearsay, and hearsay. This will fall under, if I understand correctly, non-hearsay because it's offered solely for its subjective effect and knowledge that Agent Bigham knew. But as far as my intention with that evidence, it's just simply to ask her, same thing we've already discussed. You've reviewed the entire case file in this case. Mm-hmm. And based on your review of that case file, you're aware of information that Mr. Faust resided at Knollwood Apartments at least as far as the weekend of Ms. Baker's death. That's as far as I would go with that line of questioning, Your Honor. And may I provide the Honorable Court with case law in regards to objective effect?
You may, but let me just ask the state what the question you have just made. Mr. Yalamanchili, based on that question that Mr. Cruz has proffered, I realize there are objections the state is making kind of surrounding what that question may elicit. But in terms of the question itself, does the state have an objection about that particular question?
Can I get the question one more time, Your Honor?
Mr. Cruz, if you don't mind proffering again for the court the question you said you were intending to ask.
Sure. So the first question would be, Ms. Bigham, you reviewed your entire case file. And based on your review of the case file, you are aware of information in your case file that Mr. Faust resided in Knollwood Apartments or at Knollwood Apartments around the time of Ms. Baker's death.
Okay. With regard to that question, Mr. Yalamanchili, I realize you may have some comments about, again, what you're saying the defense is trying to elicit. But in terms of the question itself, do you have an objection to the question?
I think that I do not have an objection to the question if it is phrased as you were aware that Mr. Faust lived at Knollwood Apartments.
Right.
I think once you make reference to information within the case file, you're getting to a point at which the question is referencing this hearsay information or double hearsay information that Mr. Cruz has just identified in this police report. I think he can ask Agent Bigham that question, and then she will answer it in whatever way she does.
I mean, I wanted to give you an opportunity to respond, but that would certainly be my sort of first response to you, Mr. Cruz, is that is not an objectionable question. I think the question becomes what happens with the answer. And so since we're talking about this document that you've just given to the state, can you proffer what might come next? Because we need to talk about whether the information in that document is going to be admissible.
Sure. Agent Bigham would be under oath, so I anticipate Agent Bigham, not even anticipate, I trust as an officer of the law she would be honest. So I couldn't imagine her saying no. The state would have obligation as well if Agent Bigham was to
Suborn perjury.
be dishonest under oath, and I'm sure, I don't even want to imagine that because I don't think that'll happen. But I expect that once I asked the question in regards to the information she had that Mr. Faust stated no was the department's around the time of Ms. Baker's death, I just anticipate that being a yes and us moving on.
Okay.
Well, and Judge, if I could
Sure.
briefly, just, I mean, anyway, I don't know what Agent Bigham's answer will be. I would like to state whatever her answer is. I don't agree that one answer or the other could be characterized as a dishonest answer when we're talking about the source of the information being a double hearsay statement from a witness that, from my memory out of the case file, the GBI never directly talked to in kind of a collateral matter involving Mr. Faust, or an other acts matter at the minimum.
Okay.
And I have a case for you, Your Honor.
Case for the court for what?
In regards to this information being non-hearsay.
All right. If you want to give me the case, but explain to the court why it is not hearsay. I mean, you've stated that it is, I'm assuming what you meant, but tell me if I'm wrong, that you're saying that it is not hearsay because it doesn't go to the truth of the matter asserted. Is that
Correct.
what you're saying?
It goes to notice.
All right. All right. Whatever you would like to provide the court, you certainly
Sure.
can.
It's a 2025 case. It's Vaughn v. Winfield, Homeowners Association, Inc., 375, Georgia Appeal, 18, 913, Southeast 2nd, 74. And as an example in this case, it states, disclosure at the time of, and this is the facts of this specific case, but showing how it was non-hearsay. Disclosure at time of sale that homeowners association was mandatory was not hearsay offered for its truth, but offered to show buyers had notice of the legal status of the association. The next case is U.S. v. Schley. That's S-C-H.
Oh.
L-E-I. It's 122, capital F, period, 3D, 944. This is page 981. And it states, statement offered for the effect it would have on the hearer, providing knowledge that certain instruments were forgeries, is non-hearsay. Also, Benford, and this is the last case I give on the court. I have a list of them, but this is the last two cases I give on the court. Benford, B-E-N-F-O-R-D, v. Ricketts Medical Co., 792, capital F, period, 2D, 1537, page 1540. Non-hearsay when it's shown or entered to establish the effect on the hearer. In that particular case, it was to prove notice of problems. In our case, it's to prove notice of Mr. Faust's address at the time of Miss Baker's, passing. And the final case is U.S. v. Darby. That's D-A-R-B-Y. That's 744, capital F, period, 2D. 1508, page 1524. And non-hearsay when introduced to show effect on the hearer. In that case, to intimidate witnesses. In this case, to show notice of Mr. Faust's address at the time of Ms. Baker's death, Your Honor.
Okay, so let me ask you this question, Ms. Cruz. I want to make sure I understand what you're asking to have permission to elicit. Are you asking for permission through that document to elicit information through, as the state has called it, double hearsay, to present evidence of Mr. Faust's address at the time of the incident? And you're calling that notice. Is that right?
No. Let me make sure I understand your question. Are you asking me if I'm attempting to introduce the document?
No.
Okay.
What I'm asking you is, I want to make sure I understand what you're trying to do. Are you asking to receive permission that the information in the document you gave the state, that the state refers to as double hearsay, about Mr. Faust's address? I'm assuming that, is that right? That's what you're saying is double hearsay is the address? Or the people that said what the address was?
That's right. So
Okay.
there's an individual, a witness,
Right.
who says she knows that or believes that Miss Brenda Howard lives at Knollwood Apartments and that Mr. Faust stays with her, and that is relayed to Detective Potter, who then puts it in the police report.
Okay, thank you. And Mr. Cruz, tell me if this is right.
Sure.
That you are asking permission to introduce or elicit testimony about that, what Mr. Yalamanchili just said, because under the notion that that information is simply notice to the hearer of where someone lived.
The reader. In this case, it would be the individual reading the document, but correct.
And so you're saying that's just simply notice?
It's non-hearsay because it's notice of Mr. Faust's address at the time of Mrs. Baker's death. Correct. It's just notice. She had notice of that information.
Okay. All right. Thank you for that clarification.
Yes, ma'am.
Mr. Yalamanchili, anything further that you would like to argue?
Not anything further, Judge.
That's not notice. That is a fact that if the defense wants to raise and properly get admitted and properly present evidence supporting that, the defense is able to do that. But that's not notice. That is not the effect upon the hearer. That is a material piece of information or evidence that needs to be proven, as every other piece of evidence in the court of law needs to be proven. And so it is.
And so if it's a fact in dispute, you should let both sides introduce their evidence that goes to proving that fact or disproving that fact. Will she allow that?
Double hearsay. It is not just notice. And I'm not going to allow it, Mr. Cruz, in the form that you're asking to introduce it. You certainly, I'm not prohibiting that information if you choose to present it in a way that is supported by the law.
If you bring Sean Potter back from the dead, I'll let you bring in this piece of evidence because he's an unavailable witness. And even though I ignored unavailable witnesses when the state wanted to introduce something, I don't want to look like I'm constraining you unfairly. So I'm going to tell you I'm not tying your hands behind your back, but I'm going to tell you that you need to do the impossible that I didn't expect the state to do for you to be able to bring your evidence towards a fact in dispute. That's what we're doing here.
The law, but not in this manner, not by double
ma'am.
hearsay.
Yes, ma'am.
All right, thank you. All right, anything else?
Nothing from the state, Judge.
All right, Mr. Cruz, anything else, sir?
No, ma'am.
All right, you may bring the jury out. Thank you. Wait, hang on one second. Did you need to say something, Mr. Hill? Who wanted to get my attention? I'm
I
sorry.
was going to ask you this.
Yes, hang on a second, sir. Yes.
It's multiple ways I could ask that question, Your Honor. I just want to make sure I don't run afoul of the court's
Okay.
order. So if the court can make clear on the record exactly what I am prohibited from asking, it'll help me make sure I don't offend the court in any way or fail to abide by the honorable court's order.
Well, I mean, I would say that is a difficult thing to answer in that context.
You just said you're not going to let him bring it in this manner, but you'd let him bring it in another way. Be specific with your ruling, Judge.
The order says that
Make her write it on
the
the
order
easel.
that I just said orally says that you cannot elicit the information you are asking to elicit in the method that you are asking, for example, by means of double hearsay. And so I don't know if I can be any clearer than that. Double hearsay, unless there's an exception to that, is not allowed.
So I won't ask her about a statement. Is it okay if I ask her if she's aware of information that Mr. Faust did not reside at 350 Cooper Road during the weekend of Ms. Baker's death?
Before I answer that, I'm going to give the state the opportunity to respond, since we're sort of in this context of proffering and things of that nature. Mr. Yalamanchili, anything you would like to say in response to that query?
Well, I think that the information that he's making reference to is still the double hearsay, Your Honor. So I think it's the same analysis with some semantic changes.
All right. Mr. Cruz, anything further, sir, that you would like to ask the court?
I would just say that doesn't, my position is it doesn't fall under hearsay, but I respect the Honorable Court's ruling, whatever it may be.
Well, let me ask you this question. The document that you have provided that we're talking about, is that the document that you're claiming gives this agent the information that you're seeking to ask her about?
Correct.
Okay, then I would say that it is barred. I would, just based on my prior ruling. So I would say you can't ask that question.
Yes, ma'am.
All right. Anything else, sir?
No, ma'am.
All right, thank you. You can bring the jury up.
I have a motion.
Oh, we have a motion.
All right, you want to do it at the bench, or?
I need to do it outside the presence of the jury.
You do?
I do.
All right. Go back to the jury. We're going to talk about the case.
Good thing I didn't take
Y'all
down
may
my
be
outside
seated.
jury presence picture down.
Yes, sir.
I'm moving for a mistrial.
Got a mistrial motion.
The state, throughout this case, in opening, they stated that Mr. Faust stayed at 350 Cooper Road. That information is false. It is not true, and it's shown by their own report. Before this trial started, we had Agent Bigham on the stand, and I specifically asked Ms. Bigham, have you reviewed your entire case file? Ms. Bigham said, yes, I reviewed my entire case file. As of right now, Mr. Faust cannot argue consent. Mr. Faust's counsel has been held in contempt due to an interpretation of the rape shield statute that, of course, I disagree with, but I follow the Honorable Court's rulings. But now we're being told not only can't argue a material defense to rape, we're also being told, despite the fact that the state knows that Mr. Faust did not stay at 350 Cooper Road, they are still able to present, please forgive me, Your Honor, I'm talking too fast, but present this false information. And we're being told that we can't confront that information, we can't cross-examine that information, because it falls under hearsay, although it's offered solely to show the fact that the state had notice.
And not only did the state say that in opening, I wish she emphasized that they pulled the sky view of the Deer Park area, all those roads, the same sky view that we keep seeing, and put a gold star in Tara's house, and Chris Bolden, prosecutor Chris Bolden, who did the opening statements, circled a house on Cooper Road. So it's more than just like a quick passing statement that you had to catch. It was emphasized and circled during opening statements.
Mr. Faust can't defend himself, Your Honor. If we know that the state is presenting evidence that is not true, we should have opportunity to rebut that evidence through this agent. This agent, I anticipate, will testify that Mr. Faust stays at 350 Cooper Road, and he did not. So we don't believe Mr. Faust will get a fair trial. We do believe that ruling is extremely prejudicial because the jury would only be presented with, not even only, they would be presented with information that's not true, Your Honor. So we would ask that the Honorable Court grant our motion for a mistrial, Your Honor.
Thank you, Mr. Cruz. Ms. Yalamanchili, do you want to respond?
I don't think I need to, Judge.
All right, thank you. Mr. Cruz, I would ask that when we have a recess, you look at the law on what a mistrial actually is and the grounds for it. This is not one of those. The comments that you make do not satisfy the requirements for the court to consider granting a mistrial, so I'm going to deny your motion. I want to respond to a few things that you have said. The prohibition that you have referred to for the courts not allowing what you have referred to as a material defense to a rape allegation is a lot more complicated than the manner in which you have described it.
I've never heard that you can't file a motion for a mistrial because of a procedural issue. He waited to file this motion for a mistrial. I'm not surprised that she's denying it, but her reason that she's given for denying it, she's acting like you can't ask for a mistrial on the grounds that an evidentiary ruling is preventing a fair trial. And I think not being able to confront somebody at a fact at issue, which Judge Lisa Lott said in her ruling on the previous matter, was a fact at issue. So there's no disputing that it's a fact at issue. She denies something that would give the defense an opportunity to present its proof relating to that fact at issue. And so he goes, Your Honor, I'm moving for a mistrial because we can't present evidence that confronts something that was presented in opening statements that now this witness is going to testify about. How is that not a basis for a mistrial motion?
Talked about the defense's failure to file the appropriate motions that would enable the court to hear whether the information, defenses, or evidence you seek to introduce would actually be admissible. And so that's something we've gone over many, many times, and I know that you know that. And so it isn't simply a blanket decision by the court to not allow certain things, but it is a response to whether the evidentiary and procedural rules have been followed, and I found they had not been. So that's the first thing. With respect to your other arguments, Mr. Cruz, they are best handled by appellate courts. They are not grounds for a mistrial. You will have every opportunity to cross-examine this witness. You will have every opportunity to cross-examine every other witness that you disagree with. But the complaints that you are lodging are not mistrial moments. They are moments for other courts to review. And so I'm going to deny your motion at this time, and I'm going to bring the jury out and we're going to get started, unless there's something else we need to talk about.
Just because something could also be an appellate issue doesn't mean you can't make a motion for a mistrial, or any motion for that matter. But yeah, I say file it. I say put it in writing.
Anything else, Mr. Cruz?
No, Your Honor.
All right, thank you. Mr. Yalamanchili, anything else?
Nothing from the
Very
state,
good.
Judge.
Can you bring the jury in? Thank you.
Oh, are we going to the seal? I don't want Dom Wiss right now. It looks like they came right back.
Witness.
All right, we've got Liz on the stand.
We're back on the record.
Bigham.
Mr. Yalamanchili, you may call your next witness.
Thank you, Judge. The state calls Agent Elizabeth Bigham, who has already taken the stand. Ms. Bigham, will you raise your right hand and take an oath? Do you swear or affirm the testimony you'll give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you would, please state and spell your name for the record.
My name is Elizabeth Bigham, Elizabeth Bigham.
Where are you currently employed, ma'am?
I'm employed as a special agent with the Georgia Bureau of Investigation, and I'm currently assigned to our Office of Special Investigations Cold Case Unit.
Prior to that assignment, where did you work in the GBI?
So prior to this, I spent about 10 and a half years, or maybe just under 10 and a half years, at our child exploitation and computer crimes unit, where I worked cases involving the online exploitation of children, child sex trafficking, and child pornography cases. And then prior to that, I was assigned to our Athens field office for about 6.5 years. And I worked general investigations to include anything from homicides to aggravated assaults, thefts, child molestations, etc.
Before you worked for the GBI, did you have any other kind of law enforcement experience?
No, I did not.
Okay. And when you become a GBI agent, what is the training process to become an agent?
So it's changed over the years, but back when I went through the academy in 2007, it was a 14-week basic GBI academy where we did everything from learning law to learning how to write search warrants, emergency vehicle operations, shooting, etc. And then after that, we did a 2-week undercover narcotics school. And then we were sent to our respective field office and we were involved in a field training program. I don't remember how long it was. It varies because there's basically a field training book and you have to check off certain things. There's so many interviews you have to do. You have to fingerprint someone. You have to do all these different things. So it can vary in how long it takes. But I would say on average about 6 months or so. And then you're kind of on your own with the help of older agents or more seasoned agents.
As it relates specifically to the Office of Special Investigations, as well as your unit, the cold case unit, when is it and how is it that that unit came into existence?
So our unit was established as part of the Coleman-Baker Act. Our unit was established in July of 2023, and there are 10 special agents that are assigned to that office, and we essentially work cold cases. That's our primary responsibility. And the Coleman-Baker Act was enacted, I don't recall the specific date that it was enacted, prior to that, but essentially there's some criteria that you have to meet in order to file a Coleman-Baker application. And those are that the case had to have been a homicide.
Mr. Yalamanchili, do you care to respond to the objection?
Your Honor, it goes back to this witness's training and experience.
Yes, sir. Okay, I'm going to overrule the objection. You may continue.
And Agent Bigham, I think you had just started in on talking about some of the statutory criteria for making a request.
Yes. So the case had to have been a homicide, had to have occurred after 1970. It has to be at least 3 years old, for lack of a better word, or cold if you want to call it that. There are some criteria that indicates that it has to be, or it has to have been investigated by a GBI office if you're requesting the GBI, but also you can request the police department or sheriff's office. That was the initial investigating agency under the same thing. And that the leads and all of the kind of probative leads have been exhausted and there are really no suspects at that point. And that's kind of the criteria that you have to meet. I believe you have to be a family member as well of the deceased.
When is it that you joined the unit?
I joined October of 23.
And did you, at any point after you joined the unit, were you assigned to review the case of the murder of Tara Baker?
I was.
Okay. Do you recall approximately when it was when you were assigned that case for investigation as part of the cold case unit?
If I'm not mistaken, it was the first case I was assigned.
All right.
When I got there.
And was there any other agent who was assigned to that case as well with you?
Yes. Special Agent Jeremy Howell.
Once you received that assignment, and kind of more generally, once you receive a cold case assignment, what are the initial steps that you take and took in this case?
So I don't know that there's a specific way you have to work a cold case every single time. I think it's kind of our preference as well, or agent preference, how you're going to start and what you're going to do. But logically, you'd get the case file and start reviewing the case file. In this particular investigation, it was a bit unique in the sense that Athens-Clarke County Police Department had an extremely large case file, and GBI also had an extremely large case file. So it took a minute to collect all the files, get all the Athens stuff, get all the GBI stuff together, and kind of mesh it all together to figure out where we were at and where we needed to start.
And you mentioned an extremely large case file for ACCPD and an extremely large case file for the GBI. How did the volume of this case file compare to other cases you had worked as either an agent dealing with the sexual exploitation crimes that you made reference to, or prior to that when you were an agent working homicides, aggravated assaults, et cetera?
Mr. Yalamanchili, like to respond to the objection of relevance?
I think it goes directly to the amount of information that Agent Bigham had to review and digest as part of her work on this investigation.
I'm going to overrule the objection. You may continue.
So our GBI case files, before we went electronic years ago when we used to print everything, they're generally about an inch thick. And if I'm not mistaken, there's 25 or 27 of those. at the GBI office in Athens. So there's about 27 volumes. We called them a volume, and they were generally about an inch thick. And then the Athens file, if I'm not mistaken, was about 15 4 or 5 inch thick binders of just paper and printouts and things of that nature. And then there were also multiple boxes containing various pieces of the case file, and we kind of had to get it organized a little bit.
And that's just the paper associated with the case, is that correct?
Yes, I would say it was about 20,000 pages or so.
Is it important to review the physical evidence in the case as well?
Oh, absolutely.
Okay, and so is that something that you did as part of reviewing the case file in this case?
Yes, Agent Howell and I, in December of 23, spent a few days over at the Athens Clark County Police Department going through every single piece of evidence that they made available to us, which was, my understanding was everything but one piece, which stayed in the evidence room but was accounted for. And we inventoried it, created a spreadsheet to help us follow it because the Athens evidence had been through, I believe, 3 iterations of an evidence program. So we wanted to ensure that, you know, the barcode it was given when it was first taken in 2001 matched up to what barcode it had now, and it all kind of stayed consistent. We wanted to see if we had any missing evidence. We wanted to see if there was anything that was unaccounted for. So we spent days just going through every piece one by one, documenting it and ensuring that it was present and where it had been and things like that.
That talks about physical evidence in general. I want to talk to you a little bit now about a subset of physical evidence that I'm going to refer to as biological evidence, okay? As a cold case unit investigator, what importance does biological evidence have to you and to your job in investigating cold cases?
So I think that's kind of what we were focusing on initially, because those are the things that we can send back to the crime lab and hope that there's potentially updated testing or new testing. And at that point, it would have been, 23 years or so, that we can maybe get something from. So we obviously noted things that could potentially be retested or tested with new technology that was available.
So you used the phrase 23 years or so, and I mean, I just want to make sure that we're clear about what are you referring to? 23 years from what?
2001.
Okay.
January 19th of 2001.
All right. And so is that a process you went through in evaluating the physical biological evidence in this case?
Yes, Agent Howell and I documented everything, and eventually we had a meeting with our crime laboratory about that.
Okay. And I don't want you to get into anything anybody said during that meeting, but based on that meeting, did you make a determination about resubmitting certain items of physical evidence?
We did.
Okay.
DNA, the swabs.
And let me ask this also. Are these things happening one after another sequentially or all at the same time?
It's kind of all at the same time. Well, in December, we're inventorying evidence, and then we're still reviewing the file. And then in February, we have a meeting with the crime lab. We're still reviewing the file. We're just kind of doing different investigative acts, but all sort of at the same time. And once we do one thing and it's kind of holding for a minute, we move on to some other things.
And as it relates to, besides review, particular steps that you take, as part of your review, do you kind of create an idea of who the witnesses were at the time of the actual crime?
Yes. As we were reviewing the file, we would make notes about maybe potential people we wanted to re-interview just after sort of an initial review of everything or reading it through the first time, and start just kind of keeping notes on what we wanted to do separately from the evidence.
And so as part of y'all's investigative actions in this case, were certain witnesses re-interviewed?
Yes.
Okay. Did you yourself conduct all of those interviews?
No.
Okay. Besides you and Agent Howell, was there anyone else from the GBI who was kind of helping with some of those interviews as well?
Yes. Many of the other agents from our office, and then also some agents from field offices around the state. So for instance, if we had an interview in South Georgia that was 4 hours away, I would ask an agent to handle that for me.
At any point, did the resubmission of some of that biological physical evidence from January 19th of 2001 yield any new information?
It did.
Okay. And what information is it that you received?
So on April 30th of 2024, we received, and by we I mean Agent Howell and I, received a crime lab report in reference to some DNA evidence. Okay.
Okay. So I'm sorry.
Sorry.
That's all right. And you did the right thing. And so I just want to take you back to the question there for a second. And it was, what information did y'all receive?
Okay. So as part of that crime lab report, we learned that there was a match to DNA in the sexual assault kit that was taken from Tara Baker at the time of her autopsy.
Okay. And when you say a match, what, like, was there a particular individual or individuals to whom that match came back?
Yes, it came back to Edrick Faust as part of the oral swabs that were tested out of her sexual assault kit.
Okay. And when you're saying oral swabs, you're talking about swabs labeled as oral swabs.
Yes.
Is that correct?
Yes.
Okay. And was there any other individual to whom a DNA result came back?
Yes, there were additional reports that were issued as well within a very short time period, but we also were informed that there was DNA matching Chris Melton or Christopher Melton as well from different parts of the sexual assault kit.
And so I think you already testified this would have been April 30th of 2024. Is that correct?
Yes, when the first match report came out.
What investigative steps did yourself, Agent Howell, or other law enforcement involved in the investigation take at that point?
So after we received Mr. Faust's information, and then subsequently, a few days later, when we received Mr. Melton's information, we obviously knew who Mr. Melton was and started to conduct some interviews. We went and re-interviewed Ms. Hall or Ms. Peavy, Ashley Peavy, Tara's roommate, went and re-interviewed Ms. Lowe or Dr. Lowe, Valerie, and started to just kind of go over everything that we had, read in previous interviews through the case file. We looked at the case file again as far as Mr. Faust was concerned to see if his name had ever come up or if there was any reference to anything like that, and we did not see anything relating to him in the case file. So we started to try and kind of familiarize ourselves with Mr. Faust and who he was. We conducted, like I said, some additional interviews and essentially kind of went on from there.
Okay. Did you ever re-interview Mr. Chris Melton?
We did. We interviewed him on a Sunday morning, I believe it was May 5th.
Okay. In your review of the case file, did you find any information connecting Mr. Faust to Miss Tara Baker?
The only information, no, we could not find any connection between Ms. Baker and Mr. Faust, except that Mr. Faust lived 585 feet from Ms. Baker's residence.
Okay. And what address is that you had that was 585 feet from Miss Baker's residence?
350 Cooper Road, Athens, Georgia.
Based on what you did up to that point, did y'all make a decision on whether or not to arrest Mr. Faust?
We did.
Okay. And when is it that the arrest was executed?
May 9th, 2024, so about 10 days after we received that report.
Okay. Following your arrest of Mr. Faust, did y'all continue your investigation of this case?
We did.
Okay. I want to talk to you a little bit about your understanding of the DNA evidence back on April 30th of 2024 and in those subsequent couple of weeks. At that point, what was your understanding of the DNA evidence?
Your Honor, based on the court's prior ruling, that would constitute hearsay. So we have a hearsay objection.
All right, Mr. Yalamanchili, any response to the hearsay objection?
Your Honor, I think asking her understanding of it is not hearsay.
Go ahead, sir.
We had a hearing outside the presence of the jury in regards to the exact same thing. Potentially so that our question is hearsay, that question is hearsay.
I'm not quite understanding your objection, so I'm going to ask either both. Why don't you both come to the bench for now? If we have to send the jury out, we will, but let's start at the bench.
Whenever it doesn't sound good, get it outside the presence of the jury. But that's exactly what happened. He even tried to say, can you be more specific with your ruling? What am I allowed to do so I can get an understanding? And one of the examples he gives is, what if I just ask her if it's her knowledge without eliciting any hearsay? Also, shout out to Positive QB saying, we need to contact Cruz's law firm. This judge needs to go. I'm sick to my stomach. I pray if this isn't a mistrial, he's found not guilty and sues the cramp out of the state of Georgia. How dare the judge sound irritated? I did share the link if you want to the contact form for attorney Ahmad Cruz. That might not be the proper vehicle for recuse the judge, but if anyone wants to contact and send some words over to Mr. Cruz, that link is in the chat there. And yes, if you want to look it up after, it's Cruz, Crews there. So shout out here to positive QB. I would never want to be on trial in this manner, way, shape, or form. How do you defend yourself? How do you defend yourself?
Agent Bigham, I'm going to ask my question in a different way, ma'am. When you reviewed the physical evidence in this case, did you identify any swabbings that were labeled any kind of way on the exterior of the envelopes?
Yes.
Okay. In your review of the autopsy and your review of those envelopes, what were the labelings on the envelopes that you reviewed in the physical evidence as related to the swabbings from the sexual assault kit done at the autopsy?
Right. So our understanding was that there were 2 packets of swabs that were labeled oral swabs and 1 that was labeled rectal.
Okay. Did that seem to, I'm trying to find the right word for this, make sense when taken in conjunction with the autopsy?
No.
Okay. What about it didn't make sense?
Well, the fact that they took, or that 2 packs of oral swabs were taken, 1 of rectal, but no vaginal swabs were taken, seemed kind of odd. And we knew from reviewing prior crime lab reports that we had vaginal smears that were made back in, I believe, 2001. So obviously, if a vaginal smear was made, a vaginal swab had to have been taken. So our understanding at that point, and from what we learned from the crime lab as well, was that something was amiss as far as what got labeled incorrectly.
Is this something that you discussed with the GBI crime lab?
Yes, we did.
After discussing it with the GBI crime lab, did you make a decision about any other labs or testing that should be pursued in this case?
Yes, after consulting with the crime lab, we learned about Pure Gold Forensics and that they were a company that could help us to potentially differentiate between the swabs
And
scientifically.
When you say differentiate between the swabs scientifically, which swabs in particular are you making reference to?
2I and 2J, or 2I is oral swabs B, or swabbings B, I think it says, and then 2J is swabbings A.
Okay, so the 2 things are both labeled oral swabs?
Yes.
Okay. And what steps did you take to facilitate Pure Gold's review of those 2 pieces of physical evidence?
So we had a video conference with, I believe he's the owner or CEO of Pure Gold, I'm not really sure of his title, and explained a bit about the case and what we had going on and what we were looking for, and asked if that was a possibility, if that's something their lab could do. Obviously, we received a quote for how much that was going to cost, and I ended up sending off the cuttings of swabs that were provided to me by our crime lab to Pure Gold for testing.
And now, just to put some dates on these things, when is it that y'all sought help from Pure Gold in order to make a determination about what was actually in each of the oral swabbing labeled envelopes?
I honestly don't remember when we had that video conference. I don't remember.
Do you remember when you received the results from Pure Gold?
I would have to look at the report to see, or my report to see. I don't remember.
Okay.
I want to say it was maybe fall of 24.
Okay. Well, do you think that reviewing that portion of your report would help refresh your recollection?
Absolutely.
And Your Honor, I apologize. It's going to take me a second to find that particular one. Judge, my computer's frozen, so it may take a few more seconds.
Womp womp.
Judge, I'm going to show Mr. Cruz a report dated from September 5th of 2024.
So guys, if you missed the Pure Gold testimony, there was a bit of voir dire outside the jury presence, and then there was the testimony in front of the jury. And it's the first time that any of the parties are aware of that Lugol's iodine testing was allowed as court testimony in a court. So if you missed that, I think that was day 4. I think that might have been day 4. The witness was Marissa Lacon. Let's see, voir dire, day 4. All right, so the evening of day 4, the end of day 4 was the voir dire, and then the morning she was the first witness. Marissa was the first witness of day 5.
By Agent Bigham, sorry. Agent Bigham, I'm going to hand you a laptop that has a copy of your report from Thursday, September 5th of 2024. I'd like you to review it, don't read from it, and let me know when you've had a chance to review it.
Okay.
Having had an opportunity to review that report, does it refresh your recollection?
Yes.
All right. If you would, please let me know when it is that y'all sent the information to Pure Gold.
September 5th of 2024 is when I would have mailed it to Pure Gold.
Okay. Now I want to go backwards a little bit and go back to May. Did you re-interview Mr. Chris Melton in May of 2024?
Yes, Agent Howell and I did.
Do you recall what date you re-interviewed him?
I believe it was on Sunday, May 5th. I believe that was the 5th.
Okay.
No, it was a Sunday morning for sure.
And just so we have our timeline, when was it again that Mr. Faust was arrested?
May 9th.
Okay. So going back to May 5th of 2024, that's obviously before the September date we just talked about. Is that right?
Yes.
Okay. So when you went to go meet with Mr. Melton and interview him, where did you believe his DNA had been recovered from?
At that point, we believed it had been recovered from oral swabs, which would have been taken from Ms. Baker's mouth during autopsy.
All right. And I was not precise in some of my questioning. I've been saying, when did you re-interview him? Had y'all ever interviewed, and when I say y'all, I mean you, Agent Bigham, and Agent Howell, had the two of you ever interviewed Mr. Melton?
No.
Okay.
Had not.
Were you familiar with your review of the previous investigation in the case file, whether or not he had been interviewed before?
Yes.
Okay. Did you have an opportunity to review those interviews?
I did. I reviewed the audio recordings as well as the summaries that were written.
All right. And in your review of that, as well as your review of the case file, did you develop any kind of opinion about the way in which Mr. Melton perceived his interaction with law enforcement from the time period of the original investigation in 2001 and kind of continuing forward?
I guess my perception was that, I mean, obviously he was kind of the first suspect, the first person they looked at, and they continually looked at him for years. Interviewed, I believe, 4 times over the years.
Does that math? Does that math? They looked at him continuously over the years. Such good job. Very good job. 4 times. This happened in 2001. It is now 2026.
Did you develop any kind of opinion about the way in which Mr. Melton perceived his interaction with law enforcement from the time period of the original investigation in 2001 and kind of continuing forward?
I guess my perception was that, I mean, obviously he was kind of the first suspect, the first person they looked at, and they continually looked at him for years. Interviewed, I believe, 4 times over the years by different people, different agents, different officers. And our perception was that, you know, he was the one that they were kind of continuing to go back to and ensure that they were
4 times total
getting statements from him and, you know, verifying
4
his
times
alibi
total.
and things like that.
Given that he had already
Liz.
talked to law enforcement several times, well, let me back up a little bit and lay a little groundwork. As an investigator who interviews suspects, are there certain interview techniques that you use?
Yes, I think it depends on the type of case, the type of person you're talking to, and kind of what you're trying to glean from the interview.
Okay. Was there any kind of technique or approach, even, technique might be a bad word, that you were intending to use or used with Mr. Melton on that May 5th interview?
As far as that's concerned, I generally do interviews pretty much the same way all the time. They're very relaxed, very casual. It's more like a conversation. I don't get fired up. I'm not a yeller that I can think of in any interview I've been in the past 18, 19 years.
You just very gently
I generally
ask them to help
approach
you
interviews
explain
like
things.
that. I kind of have this rule of thumb that I'm not ugly to anyone unless they give me a reason to be ugly. So with him, it was just very relaxed. I mean, obviously we wanted to talk to him. We wanted to kind of rehash his story and go through everything again. But other than that, I mean, there was no reason to confront him or no reason to be ugly towards him.
And, you know, this might be a hard question, but if you know approximately how many of the original witnesses were re-interviewed as part of y'all's investigation?
Oh my gosh. I mean, I don't know how many were re-interviewed. I would say maybe 20 or 30 off the top of my head.
Okay.
We did well into 100 interviews, I would say, but as far as re-interviews, maybe 20 or 30. I'd have to go look for an exact number.
And I don't want you to get into any of the contents of the interview at this point, but after you arrested Mr. Faust on May 9th of 2024, did you and Agent Howell interview him?
We did.
Okay. And did Mr. Faust provide y'all with a statement at that time?
He did.
Okay.
They're going to confront in the statement. I want to give a shout out here to Moses, who I think is on the ball here, saying that Kris just needs to confront Bigham about the false address and let the jury see how the judge and the state react. I think that's exactly what would happen if he tries to get into it. It's going to be, I'm so sorry, Jerry, we have to send you out for a moment, and then make them approach. So Kris can't make his argument out loud as a speaking objection in front of the jury. I think that's exactly, or a speaking response to the state's objection. I think that's exactly what's going to happen. And thank you for the super.
Agent Bigham, I'm going to show Mr. Cruz State's Exhibit 158. After that, I'll bring it up to you. What's that? Mark State's Exhibit 158. You recognize that?
I do.
Okay. And let me ask you this. How do you recognize it?
So it's got a GBI evidence property tag number on it. It's got our evidence label on it. And I recognize the crime lab number that's on it as being this case's crime lab number.
All right. And do you know what is contained in that envelope or baggie?
I do.
Okay. And what is it?
It's, I'm assuming a box, yes, buccal swabs that were taken from the mouth of Mr. Faust.
Okay. And so when you say Mr. Faust, were you present when those samples were collected?
I was. It was Agent Howell and myself.
All right. Did you collect them or did Agent Howell collect them?
No, Agent Howell did.
Okay. But you were present when it was collected, is that right?
Yes.
Okay. And were you present when it was placed in that evidence bag?
I remember him boxing them up. I don't recall if he put them in a bag where we were right then.
Okay.
But boxing them up, they go inside of like a white cardboard box.
All right. And when you say Mr. Faust, do you mind pointing to the individual who you saw those buccal swabs taken from and describing an article of clothing that that person is wearing if they are present in the courtroom today?
Sure. So he is sitting over at the table over there by the door, and he's wearing an Argyle sweater that's light blue, teal, and gray.
And
First
Your
time
Honor,
we've
I'd ask the record
identified.
reflect that Agent Bigham has identified Mr. Faust.
It's a reflex.
All right. And I'm not going to tender this exhibit through Agent Bigham. Your Honor, we'll connect up the rest of it with Agent Howell. If I could have just a moment, Judge.
Okay.
Auto doc. I mean, if there was a way,
Your Honor, I don't
this
have
judge
any other
would find
questions
it.
for Agent Bigham at this time.
All right. Mr. Cruz, cross-examination.
Let's update the banner.
Good afternoon, Agent Howell.
Bigham.
Excuse me. Good afternoon, Agent Bigham. Please forgive me. You have opportunity to sit in the courtroom during the entirety of this trial. Is that correct?
Yes, it is.
And you've had the opportunity to hear everyone's testimony?
Yes.
You've had the opportunity to hear my opening. Is that right?
Yes.
The state's opening.
Yes.
Mr. Melton testify.
Yes.
Ashley P.B. Hall testify, as well as Valerie Lowe.
Yes.
On Sunday, May 6, 2024, you and Mr. Howell interviewed Chris Melton. Is that right?
I believe it was Sunday, May 5th.
Thank you for that. So Sunday, May 5th, you interviewed Mr. Howell. Excuse me. I am sorry.
Mr. Melton.
Mr. Melton, please forgive me. And you met with him at the Walton County Sheriff's Office. Is that correct?
Yes, it was one of their satellite precincts.
And you knew during the interview, Kris volunteered that the longest he had gone without seeing Tara before her death, it was 10 days because of work. Is that right?
That's what he indicated initially in the interview before we helped refresh his recollection based on his original statements that were given immediately after the homicide.
And you asked him whether Tara slept at his parents' house the Saturday before her death. Is that correct?
I believe I did.
And Kris told you for a second time, no, I hadn't seen her for like 10 days beforehand or something.
Yes, we went back and forth through the 10 days and the 5 days and what was originally stated and whatnot.
Sure. And during your conversation, you told Kris, I don't have it on this, but I think what you said is that she slept at your parents' house a Saturday night before, and then she left Sunday morning, and that was the last time you saw her. Do you recall making that statement to Mr. Melton?
I don't recall that specifically. I'm not sure what the I don't have it on this is.
Can you repeat that for me?
I don't recall specifically making that statement. I can reference my summary if you'd like, but I don't understand the part where you said I don't have it on this. I'm not sure what I was referencing during the interview.
Sure, and I'll simplify the question. You recall telling Kris that he previously said that Ms. Baker slept at his parents' house the Saturday before her death.
Can I reference my summary?
Of course.
To clarify that?
Of course.
So I have that. I referenced the original interviews with him and that he told law enforcement back then that he last saw Ms. Baker the Sunday prior to her death.
Can you repeat that?
I referenced my notes that I must have written myself some notes that I had back then during that interview. And I relayed to him that he told law enforcement that he last saw Ms. Baker the Sunday prior to her death. And I do believe, yes, that was at the parents' house, his parents' house.
And Mr. Melton's response to you was, that doesn't sound right either. Is that correct?
I don't recall if that was his specific response, but he kept going back to the 10 days. He kept thinking in his head it was 10 days.
Multiple times, is that correct?
Yes.
And can we agree that Mr. Melton told you at least 3 times that the last time he saw Ms. Baker was 10 days before her death?
I don't remember how many times he said it, but I do know we had multiple conversations about it.
Sure. Would hearing your audio recording refresh your recollection?
Sure.
Court's indulgence? I'll let the record reflect that I'm going to refresh Agent Bigham's recollection from minute mark 14:57. Excuse me, 1 hour, 14 minutes, 57 seconds through 1 hour, 17 minutes, and 6 seconds. Just to make sure it's clear, what we're looking for here is Mr. Melton telling you 3 times that he hadn't seen Ms. Baker for 10 days prior to her death. Is that fair?
Yes. Can we move this? Okay.
All right, I can't hear.
So you'd agree within that timestamp that was previously stated, you have heard Mr. Melton state at least once that he hadn't seen Ms. Baker for 10 days?
Yes.
Okay.
He's a talker. Okay, that might have been a little audible. We'll have to wait for his questions.
And we've heard a second time that Mr. Melton puts the last time he's seen Ms. Baker at least 10 days before her death.
Yes, he states it's the weekend before.
The weekend before her death.
Before, yes.
Okay. All right, and within that 2-minute and 8-second time span, Mr. Melton has said at least 3 times that he has seen Ms. Baker for the last time 10 days prior to her death.
Yes.
And then what magical piece of information leads to the change?
And for the third time, you told Kris that you last saw her Sunday morning when she left. Do you recall making that statement?
Yes, based on the previous interviews.
Okay. But you're reminding him that previously he stated that he saw Tara the weekend before her death. Is that right?
Yes, we were refreshing his recollection.
Okay. And Mr. Melton told you a fourth time that it had been 10 days since he last saw Ms. Baker. Is that correct?
I don't recall if he said it a fourth time.
Let the record reflect that I'm refreshing Agent Bigham's would hearing the recording refresh your recollection? Yeah. Okay. So we're going to do number 4 and 5, okay?
Okay.
So let the record reflect that I am playing minute mark 1 hour, 20 minutes, and 10 seconds to 1 hour, 21 minutes, and 57 seconds, Your Honor. Okay, you've heard for a fourth time Mr. Melton state that he believes it was the weekend before her death. Is that correct?
Yes.
Yeah, I don't know why they don't have headphones for these witnesses. Like, they've had days to learn. It can improve the court.
Okay. So he told you at this point at least 5 times that he had not seen Ms. Baker for 10 days prior to her death.
Yes.
And this is after you've told him multiple times, or repeated to him multiple times, what he told law enforcement in 2001. Is that right?
Yes. I think he was processing, we were kind of going back and forth, like he was processing, you know, what he recalled and the fact that it's 24 years later at that point. So.
You then asked Kris, and I believe this is the 5th time you asked Kris, so was there ever a time in those 10 days, whatever, leading up until her death that y'all just had a quick booty call or met up real fast or anything like that? Do you recall asking that question? And for the 6th time, Mr. Melton stated that he had not seen Ms. Baker within 10 days of her death.
Said that he had not been with her, I believe, the week of her death.
Mr. Melton's response was not no.
I don't recall specifically, but I remember the further we got into it, I recalled that he was saying, because we were going down the path of, did you see her at any point for a booty call the week of her death? We were trying to figure out and narrow that timeline, and he said no.
Let me make sure I'm clear on my question. The question that you asked him was there any time within that 10-day window that he met up with Ms. Baker for a booty call? Would you agree on that?
I don't remember saying the 10 days. If I did, that's fine.
Sure. Would hearing the recording refresh your recollection?
Here we go.
Yes, I did state that it was in the 10 days. Had y'all had a booty call or met up real quick or anything like that?
And he said no.
And he said no.
Okay, so now we're at time number 6 that Chris Melton has told you that he has not seen Ms. Baker 10 days within her death. Is that correct?
That's correct.
Okay. Now, you would agree that you told Chris that you know that he's been dishonest with police for 23 years.
I don't remember telling Chris he had lied to police for 23 years.
Do you recall telling Chris, I need you to be 150% honest with me?
Yes.
Okay. And you explained, I know that what I'm about to ask you is not what has been said for 23 years, and that may hinder you from wanting to be honest with me. Do you recall making that statement?
Something along those lines, yes.
And you then told Chris, but we're here because there's been some evidence that's come up that you can't really argue and say, I was with her 10 days prior. Do you recall making that statement?
Yes, something along those lines.
And then you shared with Chris, there's been some DNA that's come back to you. Is that fair?
Yes.
And this was before you told him. So what that leads us to believe is that perhaps you were with her at some point sexually, much closer to her death, and this is the language I emphasize, than has ever been let on. Do you recall making that statement?
Not specifically, but I do remember having that conversation with him.
Would hearing the recording of your statement refresh your recollection?
Sure.
I asked that question just to make sure the record is clear. So you told Mr. Melton, so what that leads us to believe is that perhaps you were with her at some point sexually, much closer to her death, and I emphasize this language, than has ever been let on. Is that correct?
Yes.
And at the time of the interview, you received a DNA report on May 2nd, 2024. Is that correct?
I did.
Okay, and the interview with Mr. Melton was May 5th, 2024. Is that right?
Yes.
And the reason you knew Mr. Melton's DNA was present in her mouth is from the May 2nd, 2024 DNA report. Is that correct?
Between the April 30th and the May 2nd reports, the swabs that the DNA had come back to were labeled oral. So that's what we believed at that point.
Sure. But the report from May 2nd also stated that Mr. Melton's DNA was present in Ms. Baker's anus as well. Is that right?
Yes.
Okay. And you were aware, as the lead investigator in this case, that Ms. Baker had been sexually assaulted. Is that fair?
Yes.
And you would agree that DNA lasts in the mouth for up to 12 hours. Is that correct?
I can't speak to that. I'm not a scientist. I have an understanding in what I was told.
What was your
generally what can
understanding?
occur, but I can't speak to specifics about how long DNA lasts in someone's
Sure.
mouth.
But you told Mr. Melton that it lasts for 2 to 3 days. Is that right?
I don't remember specifically what I told him. I'm not arguing with you about it. I just don't remember specifically what I told him. But I do know that we had some information about how long it could last.
But we know it wasn't 10 days. Is that
Correct. That was not the information we had at the time. We did get information later.
And we could also agree that DNA doesn't last in the mouth 5 days.
I'm not going to speculate to that. I'm not a scientist. I don't know.
That's fair. But we did know Mr. Melton's DNA was in her mouth.
No, Mr. Faust's DNA was in her mouth.
Okay, so
ultimately.
is your testimony here?
You're talking about at that point?
Correct.
Oh, at that point, we believe that we knew it was on the oral swabs or a pack of swabs that was labeled oral at that time. And yes, that's what we believed at that point.
Fair. And you have access to the GBI's DNA experts. Is that right?
Yes.
So they could tell you, hey, either this should be here or this should not be here. Is that correct?
As far as what?
How long DNA lasts.
Yes, generally.
Now, despite this, you assured Chris, Jeremy and I are not here because we think you killed Tara at all. Is that a fair statement?
Absolutely.
And you tell Chris that his DNA was in a place that makes sense for you two, but doesn't make sense for bad guy.
Yes, because he was her boyfriend.
And bad guy is Mr. Faust.
That's who was identified through the CODIS match.
And just to make sure, you didn't know Ms. Baker, is that correct?
No.
And you tell Kris, we have bad guys evidence there, but we got to separate those two. Do you recall making that statement?
Something along those lines, yes.
And it is fair to say, despite acknowledging that Kris lied for 23 years, you were asking Kris to help you explain away his DNA to pin Ms. Baker's death on Mr. Faust.
I don't believe that Kris lied for 23 years. I reviewed his statements that were given the day of Tara's death or murder, and 2 days later, and those statements were consistent and made more sense, especially with the new evidence that they had sex 5 days or so prior to her death.
Sure. So my question is this. If you don't think he was being dishonest, why would you make the statement so that leads us to believe that you were with her at some point sexually much closer to her death than ever has been let on?
Because when we were interviewing Mr. Melton, we obviously had this new information from the crime lab, and we're under the impression that it shouldn't last more than a few days or somewhere in that vicinity at that point. We're going with the information we had on that day at that point. Of course, that can change once evidence is processed and more things are done to it.
Objection narrative, Your Honor.
Overruled. So we were going with what we had at that moment, and now I've totally forgotten your question. I'm so sorry.
Sure.
Can you repeat it?
My question was that you told Mr. Melton that, court's indulgence. I want to make sure I give you the proper question. But you told Mr. Melton that that DNA evidence led you all to believe that he had been with Ms. Baker some point sexually, much closer to her death than has ever been let on. Is that right?
That's right. Thank you. So at that point, we're going with the information that we had in the moment from the crime lab reports, speaking with the crime lab personnel, et cetera. And we were re-interviewing Mr. Melton to obviously just go over the statement and go through all the things again, but also to ensure that there was nothing we were missing. Is there some reason that, he did have a booty call or go meet her for a quick, quick meetup or anything like that had just never come out before? And we were trying to explain why, or this evidence and why it was there. I mean, obviously we knew that's her boyfriend. It should be there, but we were trying to get the timeline down.
So at this point, we agree that you had Mr. Melton's DNA in Ms. Baker's mouth and her anus. Is that fair?
Are you speaking of that day?
Correct.
At that moment, that was the information we believed because both of the packages were labeled oral.
And during your interview on May 5th with Mr. Melton, Mr. Melton told you that him and Tara did not engage in anal sex. Is that correct?
That's true.
And we also had Mr. Faust's DNA in her mouth. Is that right?
That's true.
So at this point, we can agree that the evidence against Mr. Faust at this time that you have is DNA in Ms. Baker's mouth.
No, at the time, they had processed the other set of oral swabs, and that came back with Mr. Faust as well.
So my question is, the evidence that you had against Mr. Faust is DNA in Ms. Baker's mouth. Is that right?
At that moment.
And at that same moment, we had Mr. Melton's DNA in her mouth. Is that right?
Yes.
DNA in her anus. Is that right?
Yes.
And also a statement from Mr. Melton that him and Ms. Baker did not engage in anal sex. Is that right?
That's right.
And just for the purposes of this, Mr. Melton was not arrested at his May 5th interview. Is that right?
No.
Okay. You did not obtain warrants from Mr. Melton based on this information. Is that correct?
No, we would have no reason to.
But you explicitly told, or would you agree that you explicitly told Mr. Melton, well, I think Jeremy would agree with this. I don't want to speak for him, but like we are here to try to separate you from the killer. Is that fair?
Probably something along those lines.
Okay. And you were speaking again of Mr. Faust.
At that point, that was the other information we had.
Okay. Based solely on his DNA in her mouth.
No, at that point, I mean, that was, 5 days or so? And we had already been working on and reviewing the investigation again. We had Mr. Faust's name 5 days prior to the interview with Mr. Melton.
Let me ask you this, because it's not a trick question. I'm not trying to trip you up or anything. When we're talking about physical evidence, the only physical evidence you had connecting Mr. Faust with Ms. Baker is Mr. Faust's DNA in Ms. Baker's mouth.
Yes.
But on this May 5th interview, although we have more physical evidence involving Mr. Melton, you tell Mr. Melton you want to separate him from Mr. Faust. Fair?
Correct.
We've agreed on that.
Mr. Melton had an alibi.
You then asked Mr. Melton for the 6th time, so was there ever an instance closer to her death that you just went over and got a blowjob, that y'all met up real quick, you know, just get a little quick rump out? Do you recall making that statement? Okay, and before he answers, you tell him, because 10 days before, there's not still going to be sperm. Like, literally, scientifically, it doesn't last in your mouth. Is that correct?
Or I said something like that.
Okay. So at this point, you aren't even interviewing Mr. Melton as a suspect. Is that fair?
No, he wasn't being interviewed as a suspect because he's had an alibi for 20-something years.
And you also make clear to Mr. Melton, but we have to separate you from the bad thing that happened and make sense of the thing that would be understandable and normal. Is that correct?
Something along those lines.
So can you explain to me how Mr. Faust's DNA being in Ms. Baker's mouth and Mr. Melton's DNA being in Ms. Baker's mouth and anus, although Mr. Melton stated they don't engage in anal sex, makes it understandable and normal? Can you explain that?
My understanding through speaking with the crime lab is that there's something called drainage and gravity. I mean, we all know what gravity is, but drainage and that you can, that semen or sperm can drain down from the vagina to the anus, and that can be a possible way that it gets into an anus. And yes, while at that point, we still had 2 packs of oral swabs, we knew or had a belief that one of those was vaginal swabs. We just didn't know which one it was yet.
Let's talk about drainage. So we've established, at best, Mr. Melton says it's been 5 days before since him and Ms. Baker had sex. Is that fair?
Yes.
And we would assume, I know you say that you don't know Ms. Baker, but Ms. Baker would take a bath every day. Is that right?
I don't know specifically, but my understanding from previous interviews is that she would shower in the mornings.
Okay, and that's daily, right?
I believe so.
Okay. So your position is, and correct me if I say it wrong, we know Ms. Baker was sexually assaulted anally. Is that right?
Yes.
We can agree that in the May 2nd, 2024 report, Mr. Melton's DNA profile is the only identifiable profile. Is that correct?
In the May 2nd report?
Correct.
No.
I would like you to look at the 5th paragraph on the first page of the May 2nd report from Dr. Ashley Hinkle, please.
I don't have it.
I have it for you.
Ask about the semen. Lack of.
I mean, I have notes regarding it, if that's
And I can give you the whole thing, or I can give you the pertinent page. Which one do you prefer?
what, either way.
I give you the whole thing.
Okay.
Your Honor, I'm going to object. My understanding, Mr. Cruz hasn't said anything about refreshing recollection or anything along those lines. It seems that he's asking Agent Bigham to testify off a report that she did not create. So I'm going to object.
All right.
But on direct examination, Agent Bigham testified that she was aware of the DNA report from May 2nd, 2024. So she's already established her knowledge of same. I asked her if she was aware that Mr. Melton's DNA was the only identifiable DNA in Ms. Baker's anus, and her answer was, I believe, no, I do not recall that.
Oh, I don't.
Okay.
Correct me. Please correct me if I make a mistake.
Was that your answer?
Well, I'm sorry. I may have misunderstood you. I don't remember you specifying her anus. I thought you were talking in general about the DNA. But if you're specifically talking about the rectal swabs, then yes, you're absolutely right.
I'm going to let you
Sorry.
re-ask. Let's do this, since there's been an objection, but I think maybe this witness was confused by your question.
Sure.
If you'd like to ask the question again, you may do so.
Mr. Melton's DNA profile was the only identifiable DNA profile in Ms. Baker's anus.
Yes.
Okay. In the state's theory and law enforcement's theory of how he's the only DNA profile is that it was drainage.
That was a theory that was proposed to me,
Okay, that's a theory?
or just a way that it can happen.
A way to explain away Mr. Melton's DNA so you could focus on this. Is that right?
No, I don't think that's accurate.
From the question,
Argumentative?
it's argumentative.
I'm going to sustain that objection.
Yes, ma'am. And you also
Yeah,
told...
so if it's from drainage, and you're saying that the one oral swab is actually a vaginal swab, then why don't we have both profiles present in the anal swab?
Kris, that in order to separate him from Ms. Baker's murder, we got to figure out that timeline and clarify it, or it doesn't make any sense. Do you recall making that statement?
Something along those lines.
And you would agree that to a reasonable person, it could appear that you're asking for Chris Melton's help in pinning Ms. Baker's murder on Mr. Faust. Is that fair?
Object, Your Honor, calls for speculation.
I'm going to sustain that objection. I don't think it's a proper question. You may rephrase, Mr. Cruz.
Yes, ma'am. What you're trying to do, is it fair to say that you're trying to explain away why Mr. Melton's DNA was in Ms. Baker's mouth? Is that fair?
No, I'm trying to get an understanding of why it was in her mouth, because that's what we thought at that time.
Okay, so let me ask you this. We've already agreed, you and I are aware, that Mr. Melton was aware that Ms. Baker was sexually assaulted. Is that right?
I'm sorry, say that again?
Sure. We both are aware that Ms. Baker was sexually assaulted. Is that correct? Yes. You didn't find it odd when you told Mr. Melton about DNA in Ms. Baker's body. His response was, I'm taking in that there was something else in her, somebody else's stuff there too.
Mr. Melton during that time once we started getting into the specifics of the evidence that we had and what the questions we were asking him, he was starting to become kind of very distraught and almost just kind of like in shock. I remember talking about that with him, like, I was in shock as much as you're in shock. You know, like, he was trying to process everything. And
was this before or after he said 6 times that it had been 10 days and maintained that it had been 10 days? And then you're like, but we have your DNA and that doesn't add up because it would be 2 or 3 days max. So something's not adding up here. I need you to be 150% honest with me right now, implying that we don't think you're telling the truth. Does he start getting sweaty and breaking down then?
I took that sort of statement as him sort of processing everything that we were talking about.
Sure. And that's your interpretation of his statement.
That's my interpretation.
Okay. But after you made that statement, after Mr. Melton made that statement, Kris tells you for a 7th time, like, as far as, you know, the 10 days is stuck in my head. Is that correct?
Again, I think at that point he's sort of reeling and processing everything and trying to kind of make sense of this information that he's now learned after 20-something years.
Agent Bigham, this is your investigation. Is that correct?
Myself and Agent Howell.
Okay, but you're the lead investigator. Is that correct?
Sure.
Okay. And because of your work, this prosecution was brought against Mr. Faust. Is that correct?
Because of our work.
Sure. But you wouldn't want to do anything that would hurt your chances of convicting Mr. Faust. Is that right?
I just want to work a case to its proper conclusion and convict the right person.
Well, sure. And that's an excellent point.
So wouldn't you care?
When we talk about convicting the right person, you would agree that when you obtained arrest warrants for Mr. Faust, the only evidence you had of his connection with Ms. Baker was DNA in Ms. Baker's mouth. Is that fair?
Yes, that was the only evidence we had of their connection.
Okay.
They had no other reason to be connected.
Sure, but physical evidence, just DNA in the mouth.
That's correct.
Okay. But for Chris Melton,
I apologize. At the time of arrest?
physical evidence, correct.
Yes, yes.
But for Chris Melton, we've already established that we have DNA mouth, DNA anus, and a statement from Mr. Melton saying that they did not engage in anal sex. Is that right?
That's accurate.
But based on your determination, the right person to arrest is simply the person whose DNA is in her mouth.
It was Mr. Faust.
And Mr. Melton.
No, I'm talking, you said the right person to arrest, and I said
Sure.
Mr. Faust.
And Mr. Melton, because Mr. Melton's DNA was in her mouth as well. Is that right?
It was, but Mr. Melton had an alibi.
Wow.
And you would agree that you told Mr. Melton you were shocked to learn that his DNA was present.
Yes, I believe I said something along those lines.
Okay, and you explained to him, and in my thought, when I got this news, and I was about as shocked as you are right now, last week, you were a 23-year-old kid, you were being hammered by the effing cops that are treating you like S, you know, after you've just found out your girlfriend's been brutally murdered. Is that correct?
Yes, I remember making those statements.
They're treating you like S? Lady, they interviewed him 4 times. Total. They let his dad be present for one of the interviews. One of the interviews was only 46 minutes that we know of. Like, does this sound like when we watch other cases, especially when we get into appeals with confessions and interrogations, and we hear about 27-hour one-time interviews, all taking place at one time. This does not sound like what we normally hear about a thorough interrogation. And I'm not advocating for 27-hour interrogation sessions. But what are we doing here?
And then you continue. You stated, and you're terrified knowing, yeah, y'all had a booty call. You know, she got back from the library that night. You came up. She went down to have a booty call real quick. And you know, in your head, you're like, I was literally the last person with her.
That was an interview tactic, I guess, or technique, whatever you want to call it, that that I was using to just try to give him one more opportunity to let us know if something had occurred that week. Like, just basically putting into context for him, like, you were a kid and, you know, you were scared and the cops were going after you and things of that nature, and just trying to give him an out to give us that information. But he stuck strong to his statements that he was not with her that week at all.
And he also stuck strong to his statements that he hadn't seen her in 10 days as well. Is that correct?
By the end of the interview, we had come around and he agreed that with the prior information or information from his prior recordings that I had listened to, that he agreed that it was accurate that he had had sex with her, or they may have had sex on that Sunday before she left his residence, which would have been in that 5-day marker.
Yeah, and I would ask for the opportunity to get my answer from the witness because we are on cross, excluding the narratives. Another report said that the witnesses are allowed to narrate after they answer a question.
No, they're allowed to explain, Mr. Cruz. So tell me what your objection is. Do you have an objection?
Semantics. Narration is explaining to this judge.
I'll make the objection when it takes place, Your Honor. I think that's the appropriate way to handle it.
All right, go ahead, sir.
But then you told Kris, you know you didn't kill her, but you were the last person there before she got killed. Do you remember making that statement?
No, I mean, I do remember making that statement, but that was in the context of me giving him that narrative of the last, or giving him an out with that narrative. That was not separate, nor was I telling him he was the last person with her. It was in the context
Objection,
of that
narrative, Your Honor.
I'm going to overrule that. I think she's explaining her answer to you, Mr. Cruz. I'm going to overrule
Just
that
object
objection.
anyway.
And you continued, and so in my mind, it makes complete sense that you would be omitted from the conversation because you don't want any more pressure on you. They are already hounding you enough, and you know that you didn't kill her, but you knew you were with her. You would agree that's an accurate statement?
No, that was my narrative that I was giving to him to use as a technique to try to give him one last opportunity to tell me that he was with her, if that was the case. But again, it was not.
Well, this is an interesting thing. You've already told us that when you interviewed Mr. Melton, you weren't interviewing him as a suspect. You were just interviewing him to have a conversation with him. Is that right?
Yeah, that's right.
So giving him a justification as to why his DNA was present when it should not have been, would it be fair to say that you were justifying or trying to explain away his DNA with him?
No, I mean, his DNA should have been present. He was her boyfriend at the time.
Sure. And
I wasn't giving him a justification. I was ensuring that we.
Objection, narrative, Your Honor.
I'm going to overrule that objection. You've asked a question. She's answering your question. I'll allow her to answer.
I was ensuring that we, trying to think of a good word to use. I was ensuring that we clarified everything in his statement and and interviewed him in the best way possible before we started kind of moving on to Mr. Faust. And obviously we knew going in.
Moving on to Mr. Faust. Moving on to Mr. Faust. That is not the order of events here.
In that he had an alibi and he did not kill her, but we were trying to do our best to explain this DNA with what we had at that moment.
And despite you explaining or giving him a way out, Kris still doesn't change his timeline from 10 days. Is that correct?
No, I believe I already stated that towards the end of the interview, he agreed that they would have had sex on that Sunday before she left his parents.
Let me specify the question. After you told Kris you know you didn't kill her, but you were the last person there before she got killed, and so in my mind, it makes complete sense that you would be omitted from the conversation because you don't want any more pressure on you. They're already hounding you enough, and you know you didn't kill her, but you knew you were with her. Kris's response was, that's the tough part. Like, I don't recall being with her between the time.
I would have to listen to it, but I mean, we don't have to. I'm just saying that again is the narrative that I was kind of spewing to him to see if he was going to say anything else before we concluded this interview.
So my particular question.
But no, I don't believe it was accurate.
My particular question is, after you made that statement to Chris Melton, he still did not change his timeline from 10 days.
He was still kind of reeling all the information and kind of, he was almost like
25 years
having a
later?
conversation with
23?
himself.
Objection,
out loud.
non-responsive.
Overruled. You've asked her a question, and she's answering it. I'm going to allow this witness to answer your question.
Run the tape.
I'm done.
Is that a yes or a no, Agent Bigham?
You'll have to ask me your question.
Sure. After you gave him the statement about him not being the killer, and specifically, you know you didn't kill her, but you knew you were with her, Kris still did not change his timeline from 10 days. Is that correct?
I don't believe that's accurate.
And you've heard portions of this interview, is that correct?
Yes.
Okay. And you recognize the interview because it's your interview with Mr. Chris Melton, is that correct?
Yes.
Based on the portions you heard, had that interview been altered in any way?
I only heard minutes of it.
Sure.
I would assume not, but I can't speak to that.
So I'll let you hear minute mark 128:16 to 128:43.
Listen, listen, listen.
Yeah, he says.
But that is a fair and accurate portion of your statement or your conversation with Mr. Melton on May 5th, 2024.
Yes, a portion of my conversation.
Okay. And for that particular portion, which is minute marks 128:16 to 128:43, you recognize that particular portion. Is that right?
Yes, I do.
Okay. And it hadn't been altered in any way to your knowledge.
I don't believe so.
Your Honor, I would move to introduce minute mark. Well, excuse me. Let me show the state. Please forgive me.
All right.
I don't have any objection, Judge.
All right, and what is, there's no objection, but you, Mr. Cruz, tell me what you want to admit.
Sure.
All right?
As Defense Exhibit 47, I am admitting minute mark 128:16 through 128:43
Right.
of
Sorry, I
Miss
left it loud.
Elizabeth Bigham's conversation with Mr. Chris Melton on May 5th, 2024.
It is admitted.
And may I publish? Same
May.
procedure, Your Honor.
Okay, you. In your head, like I was killed. You were the last person there before she got killed. And so in my mind, it makes complete sense that that would be omitted from the conversation because you don't want any more pressure on you. They're already hounding you enough, and you know you didn't kill her, but you knew you were with her.
That's the tough part. Like, I don't recall being between the times. Like,
So again, Mr. Melton is telling you he does not recall being with her in between that time. Is that correct?
Right. And at that point, he's just reeling over all this information. He's visibly upset to the point where we got him tissue.
What world would you ever give this benefit to someone that you said was a suspect if you didn't have blinders and rose-colored glasses on for? Holy moly.
And just kind of processing all this information. So we're going back and forth about it.
You said you two were going back and forth about it?
Like, that's what we had been doing, like, back and forth as far as, like, going, like, him talking about the 10 days, me talking about what he previously said, things not in an aggressive or argumentative way.
So it got to a point where Mr. Melton, as we've agreed, has stated multiple times that 10 days was the last time he saw Ms. Baker. Is that right?
Like I've said, I believe towards the end of the interview, we came to an agreement that they had sex Sunday before she left his parents' residence, which would have been the 5 days.
Sure. So my question is, during the interview, at some point, Mr. Melton continued to say that he hadn't seen Ms. Baker for 10 days. Is that right?
Yes, he said it multiple times.
And at a certain point, you would agree that you and Jeremy Howell started pressuring Kris to change his answer. Is that right?
No, we were just talking to him and trying to refresh his recollection and explain to him that what he said the day of her murder and 2 days, or I'm sorry, 2 days after her murder, I apologize, was that they had sex 5 days prior.
Okay. And you interviewed Mr. Faust. Is that correct?
Myself and Agent Howell did.
But Mr. Faust didn't get that same benefit, did he?
We didn't get that far in the interview.
Did Mr. Faust get that benefit? Yes or no?
And Judge, I'm going to object. The interview is not in evidence, and the defendant is not allowed to elicit possible self-serving hearsay.
I didn't.
Response, Mr. Cruz.
Absolutely. This officer has personal knowledge of the interview as she was present. And I didn't ask for any hearsay statements, Your Honor. I just asked if Mr. Faust received that same benefit.
Okay, I think that Mr. Yalamanchili's statement is a correct interpretation of the law. I'm going to sustain the objection.
Yes, ma'am. But our last question was that you and Mr. Howell began pressuring Kris to change his timeline. Is that correct?
I don't know that I'd call it pressuring. We were, again, utilizing interview techniques to try to elicit information if it were any different than what he had been providing for 20 some odd years.
Okay. Well, I asked you about that earlier, and you stated that you didn't believe Chris Melton lied 23 years earlier. But now you're saying that...
No, we didn't. We were trying to explain the DNA and trying to understand why it was there.
So would you agree that the statements that Mr. Melton had given for 23 years prior was inconsistent with the DNA you had in Ms. Baker's mouth?
That's hard to answer because at that moment, because we believed that that was her oral swab, that was the oral swab.
At that time, May 2nd, we're talking about
That's
May
what I'm
2nd.
trying to think through. Can you ask me the question one more time? I apologize.
Sure. The statements that Mr. Melton had given for 23 years was inconsistent with the information you had regarding his DNA being in Ms. Baker's mouth.
Yes, I guess that would have been inconsistent at the time with the information we had in that moment.
Sure. But you asked, excuse me, Kris has asked, despite this conversation and him saying 10 days, he has asked, is there even a percentage of a chance you were with her Thursday night? Is that correct?
I'm sure I said something like that.
Okay, and Kris responded no.
That's correct.
He was then asked, not even a 1% chance? Is that correct?
Yes,
Kris again responded no. Is that right?
that's correct.
And despite him saying no, 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 he is then asked again, even Wednesday night. Is that correct?
That's correct.
And Kris responds no.
That's correct.
However, despite Kris saying no, law enforcement tells Kris, I understand you're saying you don't recall.
Are you saying we told him that?
Correct.
I don't remember.
You don't remember making the statement, excuse me, you don't remember Mr. Howell making the statement. I understand you're saying I don't recall.
I don't. I mean, I'm not arguing with you that he did make the statement, but I just don't remember that specifically.
I'll let you listen to the portion just to make sure it's accurate. Okay. Your Honor, may I approach the witness?
You may.
Do you recognize Agent Bigham?
I do. That's Agent Howell speaking.
Okay, but you're present as well. Is that
Yes.
right? Okay.
Yes.
And did that recording sound like it had been altered in any way?
No.
Okay, and we've already established that this is the May 5th, 2024 interview with Mr. Chris Melton.
It is.
Okay. Your Honor, I would move to admit minute marks 1:28:58 through 1:29:10 into the record.
Is this D48?
No, this is the same exhibit. I'm just marking different points that would be admissible, and I'll give the court reporter the portions that'll be admitted.
I think it's probably best we just call it 48.
D48. How will we sticker it?
I'm not exactly sure at this point, but just for the record, to be clear, these are two separate
Portions.
entries,
Sure.
and it can be the same thing. And just so it's recognized that they're two separate entries, the last one is 47, this is 48.
Yes, ma'am.
Is there any objection?
Yes, Judge, I took Mr. Cruz's original action to be refreshing the witness's recollection, which she stated she was refreshed and then testified consistently with the statement. So I don't know that there's any reason to admit it for publication in front of the jury as a prior inconsistent statement, which seems to be what Mr. Cruz is planning on doing here.
All right, Mr. Cruz, you care to
May I
respond?
respond? Sure.
Yeah, of course.
The question I asked her was just personally to make sure that she recognized that so I could lay the foundation for a prior inconsistent statement. Her statement to that question was, or to my last question that led to this, was in regards to despite Kris saying no, Kris was told, I understand you're saying I don't recall. And her response to that was no. So I laid the foundation as a prior inconsistent statement, and we're asking for admission as same.
Okay. Mr. Yalamanchili?
That wasn't her response. Her response was, I don't recall, at which point Mr. Cruz played this statement for her, and then she responded, yes, that is Agent Howell. So,
I mean, I think that's accurate. I don't think we're dealing with the prior inconsistent statement. I'm going to sustain the objection.
Yes, ma'am. So, however, despite Kris saying no, he's told, I understand you're saying I don't recall.
No, when I listened to that just now, my understanding of what Agent Howell was saying was, I understand if you don't recall. That's how I interpreted what Agent Howell was saying.
Sure. Your Honor, I would ask to admit minute mark 128:58 through 129:10 as a prior inconsistent statement. Or
That's
it's
my
two,
interpretation.
impeachment by contradiction as well. So I think this one would fit more so under impeachment by contradiction.
All right. Mr. Yalamanchili, any response?
I just have the same response as I had before, Judge.
I think based on the witness's statement, Mr. Cruz, you have not proved that this is a prior inconsistent statement for purposes of admission. You may be able to admit it later, but for this specific purpose, I'm going to sustain the objection.
Okay. Is this sustained in regards to impeachment by contradiction as well?
Yes.
Okay. Understood, Your Honor. Now, during your questioning, you have no reason to disagree that Kris changed his timeline from 10 days to 5 days. Is that fair?
We talked about it towards the end of the conversation.
Okay. And with that conversation that you had with Kris, you told Kris, but I think what you said is, and I believe we talked about this, is that she slept at your parents' house the Saturday night before, and then she left Sunday morning, and that was the last time you saw her. Is that accurate?
Yes, that's accurate.
And Kris is then told that you and Jeremy have to be able to explain his DNA and that he needs to be within a certain window or you can't explain his DNA. Is that correct?
I'm not going to argue with you that it's not. I'm sure it is. But we were, again, trying to explain to him that we've got to understand why this DNA is in here
Okay. So
in a certain window.
did you have to explain it for Mr. Faust?
Again, we didn't get to that point.
Okay. Did you try to explain it for Mr. Faust?
We didn't get to that point in the interview.
We're going to sustain that objection.
Thank you.
At the time you interviewed Mr. Faust, you already had a...
Again, Judge, he can't reference this interview without it being admitted, and as the defendant, he can't admit it.
Judge,
Mr. Cruz and Mr. Yalamanchili, may I see you at the bench, please? Thank you.
Oh, we're going to get a yapping. Oh, we're going to get a yapping.
I think it's just. Yes. Let me ask that question.
At the time of your interview with Mr. Faust, you had already secured arrest warrants. Is that correct?
Yes.
So in regards to Mr. Faust, we have DNA.
I like, he's illustrating the difference here. So what they knew at the time, before they sent things off to Pure Gold Labs and got the mislabeling of the swab set out, we have a comparison. On the left hand, we have Faust with DNA in the mouth, arrest warrant secured. Melton, DNA in the mouth and anus, says he did not engage in anal, and yet no arrest warrant secured. Reason being, because he had an alibi.
So in regards to Mr. Faust, we have DNA in Ms. Baker's mouth, and based on that, Mr. Faust, an arrest warrant is issued for Mr. Faust for murder. Is that correct?
Yes.
Okay, felony murder. Is that correct?
Yes.
Burglary. Is that correct?
Yes.
Arson. Is that correct?
Yes.
Aggravated sodomy. Is that correct?
Yes.
Okay. But Mr. Melton's DNA is in Ms. Baker's anus, and an arrest warrant isn't issued for Mr. Melton for sodomy. Is that right? It isn't issued for murder?
No.
Despite acknowledging that Mr. Melton may have said something for the past 23 years that wasn't consistent with the DNA evidence that you had on May 5th, 2024.
Was that a question?
Yes, ma'am.
I'm sorry, you'll have to rephrase.
Sure. Now, let me ask you this way. Despite having Mr. Melton's DNA on May 5th, 2024, okay, and despite knowing his statements for the past 23 years were inconsistent with the DNA evidence that you believed you had on May 5th, 2024, an arrest warrant was not issued for him.
No.
Okay. Now, let me ask you this. Do you know Mr. Melton's family?
No.
Okay, so you don't know if he's related to anybody?
No.
Okay. Does he have any family in law enforcement that you would know of?
No idea.
So just based solely on Mr.
investigate.
Melton, I'm assuming being Mr. Melton, an arrest warrant isn't issued for his arrest.
Mr. Melton had an alibi that made it impossible for him to kill Tara Baker.
And you've been in the courtroom each and every time we've talked about Mr. Melton's alibi. Is that correct?
Yes, but I also reviewed it in the 20,000 plus page case file and multiple interviews over the years.
And you'd agree that once Mr. Melton is told, that window we're in is we have to be able to explain why you are where you are just as much as we have to explain why someone else is there as well. But it's a narrow window, and it can get complicated if your window is greater than the window of expectation for how long evidence could be there. And that's what we're trying to drill down into. The further in time you are from how long this could last, the more complicated and less reasonable that explanation is. Do you remember Mr. Melton being told that?
Did I say that or did Agent Howell say that?
Mr. Melton was told that.
I'm
You don't-
sure he was. I don't recall if I said that or if Agent Howell said that.
But once that statement was made, we can agree that Kris then says, if anything, it would have been maybe that Sunday, the weekend before. Is that correct?
We had been talking about that the entire time because I had continually refreshed his recollection on the statement he gave 2 days after Tara's murder.
So, Ms. Bigham, my question is, after that statement was made to him about his DNA, his response was, if anything, it would have been maybe that Sunday, the weekend before. We would have done something Sunday morning before she left. Is that accurate?
Yes, he did state something along those lines.
Now, Ms. Bigham, we've agreed that Chris Melton stated that Ms. Baker spent the night at his parents' house the weekend before her death. Is that right?
Yes.
Okay. However, you would agree that nowhere in your case file or in no report that Mr. Melton's parents ever confirmed that Ms. Baker stayed at their house the weekend before her death. Is that correct?
I do know they were interviewed. I don't believe they were asked about that, but I would have to look at the report to be certain, but I don't believe they were asked about her spending the night.
So the answer to my question is a yes. Is that correct?
Well, yes, they were interviewed.
So my question was that Mr. Melton's parents never confirmed the information that Ms. Baker was at their home the weekend before her death.
I believe that's correct.
And you cannot show the jury any report confirming Mr. Melton's claim that Ms. Baker was at Mr. Melton's home the weekend before her death.
No, I don't recall seeing anything there.
In fact, law enforcement simply took Chris's word for it. Is that correct?
I wouldn't say they took Chris's word. They conducted additional interviews with alibi witnesses, for lack of a better way of saying it.
Objection, non-responsive, Your Honor. My question didn't involve alibi witnesses.
I'm going to overrule the objection. I think this witness is allowed to explain her answer. You may follow up with any questions.
Sure.
They conducted interviews with additional witnesses that could confirm where Chris was on Friday morning. Their focus was on Friday morning. That was law enforcement's focus back then.
It makes no sense for that to be the focus when DNA could be there for several days. So, for example, let's say Chris Melton was on trial and I was his defense attorney and the prosecution saying his alibi, he tried to give an alibi, but it didn't quite check out. You know, the time of the fire starting is outside that window. It doesn't, his alibi doesn't cover the possible time frame. Then the defense attorney for Chris Melton, if he were the one on trial, could say something, well, you didn't even try to go verify. Or on the flip side, the prosecution could have said, we did go and try to find out if that was in fact true, that he had seen her maybe 6 days, and that's on the very outside border of what would be, you know, scientifically possible for DNA to still be present on the 19th. But we did go verify that Christopher Melton was telling the truth, or he was lying. Witnesses said, no, he wasn't here that night. Or we found a witness that says Tara was actually here on that Sunday. Like, this would never fly if this trial was going any other way.
This is your case file. Can you show the jury where that information is in your case file?
Where what information is?
That Mr. Melton or anybody confirmed that Ms. Baker was with Mr. Melton the Saturday before.
I never said that they confirmed that.
Okay, so that isn't confirmed. Is that right?
No, I never said that. I said that law enforcement focused on his whereabouts Friday morning of her murder.
So based on the information you had on May 5th, whether that window was 12 hours, a couple of days, you would agree at the time of Ms. Baker's death, Chris Melton's DNA being in her mouth would suggest that he had been dishonest about the last time he saw Ms. Baker.
We believed at the time of the interview that it was in her mouth. That was later determined to be incorrect based on additional crime laboratory testing that we did.
Let's talk about that because I believe you've mentioned that a couple of times. So I would like to hone in on that. And is it okay if we have a discussion about that?
Sure.
Okay. Now, we've agreed that you told Chris, or Chris was told, that law enforcement needed to be able to explain his DNA. Is that fair?
Yes.
Okay. And it is fair to say that Mr. Melton would not put himself with Ms. Baker within the week of her death. Is that fair?
That's correct.
Okay. You would agree that by removing Mr. Melton from her mouth and putting Mr. Melton in Ms. Baker's vagina, it changes the timing window. Is that correct?
My understanding is the window that sperm can last in the vagina is different than in the mouth.
Which would allow you to explain Chris's DNA. Is that right?
Once we determined that those were indeed vaginal swabs, it definitely made more sense.
Okay.
So you had
You'd
a reason
agree
to send
that you
pure
did
gold.
not obtain the result. Well, excuse me. The testing that you did was with a California company. Is that right?
Yes. With
Okay.
Gold.
And we're in Georgia. Fair?
Yes,
We're on the East Coast. Is that correct?
that is correct.
Pure Gold is on the West Coast. Is that right?
That's right.
And you heard Ms. Lycon's testimony?
I did.
And she stated that multiple labs throughout the United States conduct this type of testing. Is that fair?
I believe she said that.
Now, we could agree that we didn't move Kris from the mouth to the vagina until November 4th, 2024. Is that right?
Is that when the Pure Gold report was issued?
Unfortunately, I cannot answer
Oh,
any questions.
If that's when the Pure Gold report was issued, then that was when we got confirmation that those were vaginal swabs.
Would you have any reason to disagree that that report was issued November 4th, 2024?
I don't, but I would have to look at it to be 100% certain.
Now, you mentioned confirmation that it was vaginal swabs, but Ms. Lycon herself said this is a
Can't
presumptive test. There is no confirmatory testing. Would you agree?
Yes, she did speak to that.
Okay. So for the benefit of Mr. Melton, the
Good
mouth
call.
swab
Good
was
question.
turned into a vaginal swab based on a presumptive test. Is that fair?
I would say it was for the benefit of the investigation, not for Mr. Melton specifically. But we needed to figure out which ones were vaginal swabs because we knew from the vaginal smears that one of those packs had to have been vaginal swabs and they were just mislabeled.
Well, this is the thing. You would agree there have been a lot of mistakes in this investigation, right?
I'm not going to speak to other potential mistakes.
Well, you've been in the courtroom with us. We had an incident. You remember the incident where we opened the package, the state admitted, and it was empty, but it was supposed to contain hairs. Do you recall that?
That was the package that the hairs were collected in. Once the hairs go to the crime lab, they get mounted on slides.
Sure. How about the clock? Did you hear the testimony about the clock being lost?
I don't remember the clock being lost.
That's fine. How about the screen? Did you hear the testimony about the screen being lost?
Oh, absolutely.
Do you all have possession of Miss Baker's house keys?
I don't believe so.
So, Ms.
As
Baker,
far as the GBI is concerned, I
Correct.
don't believe so. And I don't remember seeing them during the evidence inventory.
so Miss Baker's.
What?
Let me make sure. You're saying that you never had a set of keys from Miss Baker?
I don't believe so. I don't recall seeing a set of keys.
From Miss Baker, is that correct?
From Ms.
Holy
Baker.
shit.
Court's indulgence, Your Honor.
Holy shit. End
I
it
can look through the
there.
evidence list if you'd like me to.
Please do, and I'll look through the one that we have as well.
Man, if Cruz is correct here. Wow. Also, let me show some gratitude here.
Are you speaking of Elvis key ring with 2 keys, Tara's apartment?
I am.
Oh, I mean, it says we did check it actually. I just don't remember.
So do you have possession of Miss Baker's keys?
No, I do not have possession.
Okay, where are Miss Baker's house keys?
I don't know. They were in the possession of the Athens Clarke County Police Department on December 11th of 2023.
As-
I apologize. I don't remember. There were 180
Do you not want to say the date once she realized what the date
something
was?
pieces of evidence that we inventoried.
Do you have the lock to Miss Baker's home?
I mean, I don't believe we have everything. I think Athens Clarke County Police Department has all of the evidence. I do recall the lock. Yes, the deadbolt from the front door. Is that what you're speaking of? Yeah, that was inventoried and we checked it on December 11th.
Do you have possession of that lock in the courthouse here today?
I have no idea. I'd have to go look.
Do we have possession of those keys in the courthouse here today?
I have no idea. I'd have to go look.
All right, but you stated that you are the lead investigator on the case with Mr. Howell. Is that fair?
Yes.
Excellent. So I want to talk about the physical evidence from Ms. Baker's house based on your investigation and your decision to get an arrest warrant. We can agree that no hairs in the home were connected to Mr. Edrick Faust. Is that fair?
Yes.
Okay. If you could write under arrest warrant secured, no
Got her
hairs.
on the board. Oh, he has his co-counsel over there.
And we could also agree in regards to Mr. Melton's hair, his hair was found on the cord used to strangle Ms. Baker. Is that correct?
No, that's incorrect. It was found on the, I think people keep calling it the power transformer box for the printer. Now, the cord of the printer was utilized to do that, but if I'm not mistaken, it's on the power transformer box.
I think
The power transformer is connected to the cord.
I think what Freedom Ring is pointing out here is the mark. Keys not taken had to be Melton. He had his own set because we've heard crews argue over and over and over. No sign of forced entry. And the state's way of getting around that is, well, it's possible that somebody lifted up the blinds, dusted down the inside of all the windows, lifted the window, pulled out the screen, put the screen down, climbed out the window, fixed the blinds, closed the window from the inside, reinstalled the screen, and wiped it all away while in a rush to get out and not be seen.
But if I'm not mistaken, it's on the power transformer box.
And the power transformer is connected to the cord that was used to strangle Miss Baker. Is that correct?
Yes, that's my understanding.
As far as fingerprints, I'm sorry. Attorney Hill, if you were right, hair on, and make sure I put this right, Ms. Bigham. I want to make sure I get this accurate, okay? Put hair on under Melton, correct. Under anal. Hair on weapon. Is that fair? Power cord was used as a weapon?
It's on the power transformer box. It was not on the cord.
That was connected to the cord, is that right?
Sure.
Okay, fingerprints. None of Mr. Faust's fingerprints were found in the house. We could agree on that.
That's correct.
Okay. And I won't go into the interview. I'll save that. But at this point, the evidence we do have, DNA, mouth, anus, Mr. Melton did not engage in anal sex. Mr. Melton, hair on power transformer connected to the cord used to strangle Miss Baker. Is that fair?
Yes.
We also have a mitochondrial DNA test that states that the pubic hair found on Miss Baker's butt could not eliminate Mr. Melton as the contributor. Is that correct? And that's from 2007, from lab court.
And this is critical to get some information on that they did do mitochondrial DNA testing on the pubic hair found on the butt. Chris Melton cannot be excluded. But when we had Peterson on the stand, the GBI guy that did all the hair microanalysis and comparison said, did you test it? Yeah. Is it in your report? No. And said that they indirectly eliminated, he didn't even do a microscopic visual ocular comparison of the pubic hair recovered from Tara's left hand, different pubic hair, and the known pubic hair sample of Chris Melton. Didn't even do a visual analysis, said it was indirectly eliminated. And we don't have a mitochondrial DNA test on that. Yet, now we're hearing, and I swear I've heard crews hint at it, but I wasn't sure. I was getting lost in the pubic hairs. We did have a mitochondrial DNA test on the pubic hair found on the buttocks, and Melton cannot be eliminated as a contributor. Now, mitochondrial DNA is not as precise. Like, I think when Dr. Katie Spirko was talking about it, it's like you get like 1 in 5 odds chances if you're dealing with like a household of people that might have similarities. So it's not that pointed, but the fact that he can't be excluded as a contributor and Faust is the one on trial, it doesn't eliminate a piece of reasonable doubt.
And you say that it couldn't eliminate Mr. Melton? I'd have to look at the report again to refresh my recollection.
Sure, and I believe it's already in evidence, so that's fine.
Okay.
But you did not have any hairs that was in your GBI or ACCPD's custody tested for DNA. Is that correct?
No, we did not.
Okay.
In 2024 or 3 and beyond.
Okay. You had the swabs and you solely went off the swabs. Is that correct?
No, after meeting with the crime lab that in February of 24, we went through every piece of evidence. The meeting was hours. We went through every single piece of evidence with each section head of each area. So hairs and fibers, DNA, latent prints, etc. And went through all the evidence and talked about all the evidence, what had been done on it in the past, what could be done on it in the future, or not in the future, but now. Had any technology changed or been updated that would be valuable to retest or to help retest these items. And that's how we determine what we could resubmit versus what couldn't be resubmitted because either maybe the technology wasn't there or nothing, they've already done everything with it and there's nothing else to do, things like that.
So can you tell the jury what items of Mr. Melton's were, well, let me rephrase that. What items were resubmitted for DNA testing? Because I understand that you all's position is the reason we have the DNA is because of new technology. Is that fair?
Yes, newer technology. Okay. That's my understanding.
Excellent. But we can agree that no DNA testing took place of the unidentified hairs. Is that fair?
Yes, but there was reasons for that. Some of them were not suitable didn't have a root suitable for DNA testing, et cetera. I have an explanation for some of the hairs.
Sure, that's fine. Now I'd like to ask you this, and I'll end on this note with you. And I won't go deep into it, but we've talked about the DNA in the mouth and anus. Is that fair?
Yes.
Okay, and we've already agreed that you were armed with that information. Is that correct?
Some of that information on May 2nd.
And despite being armed with this information, you told Chris Melton, but that's why it doesn't matter. If you're like, you know what? I effing lied about it 23 years ago because I was a scared, terrified kid. And you're right. I had a booty call with her that night. I left at midnight. I don't know what happened after that. It'll be, thank you. Have a nice day. We'll let you know what happens. Laughs like that's it. Is that a correct statement from you?
Yes, because Mr. Melton had an alibi that would have made it impossible for him to kill Tara.
And you explained to Chris again, we just want to be able to explain it and make it make sense so we can focus on this. Is that correct?
Yes.
Okay. Thank you. Those are my questions.
Redirect.
Any redirect, Mr. Yalamanchili?
I don't have any redirect questions, Judge.
Right, you may step down.
Do you want this or do you want me to leave it?
You can leave it with the court reporter.
All right, ladies and gentlemen, it is 5 o'clock, perfect stopping time. We are going to stop the trial for today. I'm going to release you, ask you to return, of course, tomorrow at 9 o'clock. Please don't talk about the case, do any independent research, go to any of the places that you have heard about in this case. And of course, as I talked to you about yesterday, I know I keep repeating the same instructions, but it is important. Certainly try to avoid all social media that could show you some things about this case that were taken up outside your presence. That certainly would not be appropriate for any of you to see, which is why we do things, of course, outside your presence. I know sometimes it probably seems really difficult for you to get up and get down. I know I mentioned this yesterday, and I'm sorry about that. It is very important, however, to have certain proceedings outside your presence, and I appreciate your patience in all of that. With the thanks of the court, you're all excused for today. We'll see you tomorrow morning at 9 o'clock.
All right, so there is a poll. It is just based on the timing. So remember that Faust was arrested in May of 2024 before they sent the stuff over to Pure Gold. The poll is, did Bigham, that's Liz that we just saw on the stand, make a reasonable choice in issuing the affidavit in support of arresting the defendant, Edrick Faust? So that is the question. It deals with that time frame of when she put together the arrest warrant on May 9th of 2024. So that poll is live. What a day. What a day. We are nearing the end of the state's case. It seems like they might rest tomorrow. They think that the latest that they would continue is into Thursday. We haven't had the true allele, any DNA stuff from true allele come up yet. So my guess is they're going to bookend their case and end with that final DNA testing. Just to really run it home that we have this guy's DNA, even though it's only a partial match. So we'll see how the defense does on dealing with something that in and of itself, DNA can be very compelling to people. You hear they have someone's DNA. How do you explain that away? You know, the defense isn't having an easy time getting into any possible consent, and there isn't sperm. You know, we didn't find sperm, but this DNA is somehow present by whatever means, oral and vaginal swab. So could an encounter explain that? Is the jury going to look for the defense to be able to explain how Edrick Faust and Tara Baker might have known each other and convince them that Tara Baker would give Faust the time of day? I don't think that's their burden. But looking at some of the comments I've seen online, there are a lot of people that feel like this case, what the defense needs to do is prove that that encounter would even be a possibility, which I think is kind of a very disappointing thing, a disappointing reflection on the way we think that two people in the same age group might be looking at each other. We should still have, what's his name? Jeffries? Something Jeffries? The jailhouse snitch? Yeah, Cedric Jeffries. The uniquely situated inmate. So we should still see if the state's going to call him. It seems like they're going to call Jeremy Howell, the other GBI cold case agent. So, yeah, and Hellraising Angel, let me be clear. I think defense is disputing whether or not we even have a vaginal swab. But I'm saying even if you take the state's argument that we have the oral swab and vaginal, then how do we explain it? How would we explain it? So, let's see. Amber says, I personally don't even trust that Faust swabs are related. I think there's going to be a mess with the DNA presentation. I don't think it's going to be clear-cut, absolute. We can trust that the DNA was even where we're hearing that it was present. But we'll see. We'll see. And the reason I'm saying that is because the other work in this case seems so shoddy. I might not be so skeptical if the state, through its investigators, through the GBI, through the way the state prosecutors in this case are presenting the case, set me up to raise my eyebrow and make me feel at least several times a day that I'm not getting to hear about something. So, let's see. Yeah, DB says, I don't see what True Allele would have done in this case. I don't know, I've just heard it mentioned, so I think it'd be pretty bad for the state if they don't try to, like, hammer home the DNA, because I think whether it should be or not, I think that's what they're going to say is compelling. And we can do a poll if you want on, usually I leave this to, like, when the state rests their case, we'll get the poll up. Like, do you think the state has presented their case beyond a reasonable doubt? That's always the question we ask here. It's not, if we do a poll on personal opinion on a defendant's guilt, it's a separate poll from, did the state meet their burden, right? We always do the burden poll after the state rests. So, we've got, let's see. Yes, I think this was great testimony to get out, and to especially get it out through Kris. Because if you want to believe, if someone wants to think that Kris is a sympathetic witness, that he's believable, that he has an alibi, it still would go a long way for him, if you find him trustworthy, to also have him say, look, Tara didn't have any racial biases. And I believe some of her friends, I don't know if it was Ashley or Valerie or maybe the student that she was studying with in the library, one of them also said the same thing, that Tara loved everybody. There was no racial bias. She was not a racist person. But I think that goes a long way to, even though the defense isn't getting into other possible alternative suspects, their single third-party culprit that they're pointing to, and the only person they're allowed to point to within the confines of this trial, is Chris Melton. But hearing things like that could still get the jury wondering, like, okay, but what if it was consensual and then some other person came along and just maybe a burglary gone wrong, whatever reason they wanted to get her laptop? Because we know the only missing thing that we know about is the laptop. So a lot to think about, a lot of food for thought, and honestly, all of it just seems like reasonable doubt for this particular defendant. It's Faust that's on trial here, and the questions I have all point to reasonable doubt for him. Also want to give a big thank you here to Hospice RN. We've got a nurse in the building. Hospice RN Autumn. Thank you for becoming a member. Thank you for being a nurse. We've also got Talia. So we've got 2 new members here turning themselves green. Thank you both. Thank you for becoming a member. And I think you've been a member before. So YouTube isn't showing me a counter, but I know your name. I feel like you've been here for a while. If you've been a member for way longer, happy anniversary. Thank you for becoming green again. We've also got AutoDoc on the 5-month mark. Thank you for being a member for 5 months. Saying thank you for giving us more to be outraged about. No problem. Thank you for being outraged with me. Thank you for letting me not feel like I'm screaming into a void. Screaming into a void. We've also got Cody with the kind words saying, Kat, you are the goat of trial watchers. Hey, this is one big couch for all of us to hang out on. I'm just the one on screen running the play button and pulling up some comments once in a while. So thank you for being part of it with me. Yeah, and also, yeah, those big clunky laptops back then. Yes. Yeah, and double, Moses is right. Much respect to all nurses, but especially hospice nurses. Incredible to have that skill set to work in that position, both for the patient and the family members. So definitely not a skill set that everybody has. And it's great work. It's honorable work. Is Bob coming on tomorrow? I will send, if it's True Allele Day, definitely going to send Bob Defense Diaries a link for sure. I've been waiting to hear when are we getting True Allele, so I can just throw Bob a link and say, rant away, Bob. I might have to steal their rant emoji just for that occasion. Put it in the chat. Yeah, shout out to Miss Janet Demeanor for co-hosting yesterday. It was super awesome to have her on. I feel like we can see when she's been able to pop in while she's working today. So thank you for also spending your time in the chat. She's also letting us know that Infamous Sylvia will be covering juror reactions tonight. So if you guys don't already know who Infamous Sylvia is, if you guys are familiar with the YSL trial, you already know Infamous Sylvia. But if you just heard about her yesterday when she got her Rule 22 in this case, she is often boots on the ground for a lot of different Georgia trials, sometimes New York trials, sometimes she travels out of state. But a lot of the time, she's the only reason we've had coverage or any insight on what goes on at critical hearings, like Jeffrey Williams, Young Thug, the civil forfeiture hearing in relation to the YSL case. She was there in person giving us some feedback, things like that. So she is a great resource, always willing to, on her way to court, on her way home, sometimes on the lunch break, or if not any of those points in time, when she gets home for the evening, she'll fire up a live and share what she observed in the courtroom. So if you don't already know her, there is her channel link in the chat. So there we go. The live she did last night is available. So it's streamed 19 hours ago. Actually, I'll link directly to it. Let me link directly to yesterday's. So there we go. And Sirach, thanks for, Sirach, you've been a member before too. Thank you for becoming green again. We're just going to call it like a hodgepodge anniversary. You get to pick your number because YouTube's not tracking it for you. So thank you for becoming green and good to see you. Good to see you. Hope you've been doing well. And yeah, so that's what we've got, you guys. Earlier in the day, we did a quick look at the docket. You know, saw that Sylvia's Rule 22 was on there. I didn't see anything come through like throughout the day, but I will check this evening, see if there's anything before we start up the stream tomorrow. We'll start up again around 10:30 or 11. We'll skip that lunch break and we'll see if the state rests tomorrow. Thank you guys so much for hanging out. Sheriff Chuck saying, did I miss much? You missed Liz. Liz took the stand, Sheriff Chuck. So your homework, see what Liz had to say. See what Liz had to say. good old first name basis friend of Chris Melton, who was beaten on, hammered by investigators for years when they only spoke to him 4 times total. Go and see what Liz says. That's your homework. That's got to be your homework. And we've got an yes to back me up here. So you guys all have a good one. See you tomorrow. Maybe see you somewhere over in Sylvia's chat. I'll be over listening to Justice Served TV. I heard Kelsey Fitzsimmons' judge was disqualified. Someone in the chat mentioned it, but I didn't get to look at it yet. And I'm sure Justice Served TV will be talking about that at 6. That's where the stream's going to redirect to. They cover a lot of stories, you guys. So if you're looking at a recap of other things that happened all day while we were absorbed in this courtroom, it's a great place to go every day at 6 p.m. Eastern. So see you guys over there and tomorrow. Bye, guys.